For direction, direction. Exact memo ಬಂದಿಲ್ಲ. Madam ಸರ್ 2 ಸರಿ ಮೂವ್ ಮಾಡಿದ್ದೇವೆ ನಾವು ಬರ್ತಾ ಇಲ್ಲ. ಬಂದಿಲ್ಲ ಆಗ್ತಾರೆ. ನೋಡೇ ಬಿಡು ಸತ್ಯ ಇಲ್ಲೇ ಇದು.
ಸರ್ ಈಗ ನಮ್ದು ಹೆಂಗ್ ಮಾಡ್ಬೇಕು ಸರ್ ಅಪ್ಡೇಟ್ ಇಲ್ಲ ಅಲ್ಲಿ ಇಲ್ಲ ಯಾಕಂದ್ರೆ ಏನಾಗಿ
ಶಂಕೆ ವ್ಯಕ್ತಪಡಿಸ್ತೀವಿ ಆಪೋಸಿಟ್ ಕೈವಾಡ
ಫೈಲ್ ಇಲ್ಲ ಅಂದಿಲ್ಲ ಮೆಮೊ ಇಲ್ಲ ಅಂದಾರೆ
ನನ್ನ ಕಡೆ ಹೋದ್ರೆ 2 ಲಕ್ಷ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿ ಸರಿ ಸರ್ ಆರ್ಡರ್ ಕರೆಕ್ಷನ್ ಆಗಬೇಕಂದ್ರೆ ಐದರ್ ಬೀನ್ಸ್ ಕೊಟ್ಟು ಮೆಮೊ ಹಾಗೆ ಕರೆಕ್ಷನ್ ಎರಡರಲ್ಲಿ ಒಂದು ಮಾಡ್ಕೊಂಡು ಮೆಮೊ ಕೊಡಿ ಖಾಲಿ ಮೆಮೊ ಕೊಟ್ಟರೆ ಅದೇ
ಹೌದೊಂದು ಮೆಮೊ ಹೋಗಿಲ್ಲ ಅಂತಾರಲ್ಲ ಅದ ಹೆಂಗೆ ನನ್ ಕೈಗೆ ಕೊಟ್ಟಿದ್ರು ಹಾ ಸರಿಯಾಗಿ ಹುಡುಕ್ಲಿಲ್ವಾ ಅವ್ರ ಮೇಲೆ ಅಲ್ಲ ನನ್ ಕೈ ಕೊಟ್ಟಿದ್ ನಿಜ ಕೊಟ್ಟು ಹೇಳಿದ್ರು ಈಗ ರಿವರ್ಸ್ ಆಗೋಯ್ತು ಸರ್ ಅದು ಸರ್ ಇಲ್ಲ ಇಲ್ಲ ಇವಾಗ ರಿವರ್ಸ್ ಆಗೋಯ್ತು ಸರ್ ಈಗ ನೀವು ಸರಿಯಾಗಿ ನೋಡ್ಲಿಲ್ಲ ಅನ್ಬಿಟ್ರು ಅವ್ರು ಅಷ್ಟೇ
65/22
ಡೇಟ್ ಹೇಳಿ ಸರ್ ಯಾವತ್ ನನ್ ಕಡೆ ಕೊಟ್ಟಿದ್ರಿ
23
ಮತ್ತೆ ಅವಾಗ ಹೆಂಗೆ ಸರ್ ಹುಡ್ಕೋದು ಒಂದ್ ದಿವ್ಸಕ್ಕೆ ಮಿನಿಮಮ್ 100 ಮ್ಯಾಕ್ಸಿಮಮ್ 300 ತನಕ ಹೋಗುತ್ತೆ ಮೆಮೋಸ್ ಹುಡ್ಕೋದಂತ ಕಷ್ಟ ಇನ್ನೊಂದು ಕೊಟ್ಬಿಡ್ಲ ಕೊಡಿ ಅದನ್ನ ಹೇಳೇ ಕೊಡಿ ಬೇಡ ಬೇಡ ಮೆಮೋ ಹೋಗಿಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ಬಿಟ್ಟೆ ಕೊಡಿ ನಮ್ ಮುಂದೆ ತಪ್ಪಾಗಿದೆಯಲ್ಲ ನೋಡಿ ಅಂತಾರೆ ಹುಡುಕ್ತಾರೆ ಎಲ್ಲಾನು ಹುಡುಕಿ ಇಲ್ಲ ಸರ್ ಯಾವತ್ತು ಆತರ ಸಬ್ಮಿಟ್ ಮಾಡಲ್ಲ ಮಾಡಿದಾರೆ ಅಂದ್ರೆ ನಮ್ದು ಏನೋ ತಪ್ಪಾಗಿದೆ ಅಂತ
ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಟೋಟಲ್ ನಂಬರ್ 12 ಆಗಿದೆ ಅಲ್ಲ ಅಲ್ಲಿ ಅಪೇರ್ ಆಗಿದೆ 9 ಹೋಗಿದೆ ಓಕೆ ಸರಿ
My lord,
One matter, my lord.
Monday, yes. Monday.
Sorry, Girish.
Early, Monday, not on, yes. Monday, yes. Tomorrow, yes. Monday. Yes, Saturday, yes.
Saturday.
Monday, yes. Monday, yes. What is that urgency, mister? Argument has to be heard before that they can be, yes, Monday, yes.
Sorry, Monday.
2020 is not Namdilla. 21 Namda, yes.
Big group.
Yes. 25th, 26th.
There is an order of status quo granted by this from the report whereby the construction has completely stopped. Trial court issued emergency notice against the repetition is filed. We have appeared before the trial court and we are filing the petition. So also may have it tomorrow or after.
Saturday, yes.
my lord, this is a petition challenging the conditional stay order granted by the lower court in a miscellaneous petition to set aside ex parte decree and judgment. The respondents are seeking for a delivery warrant, my lord. Urgency in this matter. The next date is on 22nd, my lord. We may have it tomorrow, my lord. I've already moved memo for today.
Yes,
my lord.
22nd.
Much obliged.
State government position 40 years. I think the government is trying to dispose it.
No, your application for
For injunction.
injunction is,
Notice has been issued.
notice has been issued. Yes. What is that? The court has not find any prima facie case.
But there's no reasoning in the order. Absolutely lack of reasoning.
Yes, Monday, yes.
One matter, my lord.
For tomorrow,
Saturday, we have so many matters.
They can dispose it.
Monday, yes.
for tomorrow,
Monday, we'll see, yes.
for tomorrow, please, my lords. It is an order of, it's a suit for declaration, wherein order 39 rule 1 and 2 has been dismissed. But order 38 rule 5, the honorable trial court states that within 60 days, a bank guarantee has to be furnished with respect to the property or the amount. It is a suit for declaration. It is not a suit for recovery, please, my lords. Though such being the case, there is an express provision that it cannot be done. Though such being the case, this has been done, please, my lords. The urgency is that I am a builder. These are flats which I have sold, which I have brought it to the market, please, my lords. And the registrar is saying that I am not going to register it because this order is there, please, my lord. That is the urgency.
Yes, day after.
One matter, my lord.
Tomorrow or Monday.
I have been
Tomorrow or
stopped.
Monday.
Day after tomorrow, yes.
My lord, I have been stopped.
Monday, please.
Not Monday, Tuesday.
My lord, I have been stopped from,
Tuesday.
my lord, the construction, my lord, work. My lord, I am seeking for equity. My lord, since, my lord, before the trial court, my lord, injunction has been, my lord, not granted. But in RA, my lord, it has been, in MA, it has been granted. Now, by virtue of this, my lord, though, my lord, I have already constructed the building. Now, it has been stopped, my lord, I have sought for equity before this. At least, my lord.
Yes, 25th.
Let's applicant.
mention, man.
one ನಿಮಿಷ wait ಮಾಡಿ sir.
Yes.
No, that have you filed an application for vacating? Yes, 26th, yes.
Let's 35.
Yes,
26th.
yes, let him dig, mister. We'll close it, yes. Yes.
Yesterday I moved the application.
No, what is that order you are challenging?
not to pass order on the police protection process. The MA I have filed the date is for 25
Hmm.
and move ಮಾಡಿದೆ ಸರ್ ನಾನು ಇವತ್ತು ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೆ.
Then you are moving that matter, you are not complete, then you are,
Small mistake 25.
then, yes, day after tomorrow, yes,
Rule 1 and 2, my lord. 39 rule 1 and 2.
day after tomorrow,
Both the courts dismiss their application, my lord. Here they have come up.
day after tomorrow, mister. Today I have given a date, you are not complied, I have given a date tomorrow also, yes, day after tomorrow. Yes, wait.
39 rule 1 and 2, both the courts below dismiss their application. They have approached the MLS and they have attempted, they have got an order of status from us. They have filed an application for vacating stay, my lord.
Getting, yes, 26th, yes.
26.
Suit for declaration, the petition filed with the written statement along with IA number 1 for permission, my lord. Same has been rejected and now matter was posted for finally kindly post it.
What is that next date?
26/3, my lord.
Yes, 26, yes.
Fresh matter.
ಎರಡಿದೆ. ಇದೆ.
What is that urgency? Next date, next week one date code, yes.
My lord,
Yes, 25th, yes,
Suit for money, my lord.
25th, yes, 25th. Yes, we'll see.
ಎರಡಿದ್ದಾಗ ತಗೋಬೇಡ ಅವರು ಸುಮ್ಮನೆ ಯಾವ್ದೋ ಸೇರಿಸ್ಕೊಡ್ತಾರೆ ಒಂದ್ ಜನರಲ್ ಮಾಡವ.
Yes, let it be there, evidence, nothing will happen, yes.
Lord, may I mention one matter from this side, my lord?
Application and order rule.
That urgently GPay application for appointment GPay was rejected. And ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಇದೆ, ಡಿಪೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಇದೆ.
No application for appointment of,
GPay ಎವಿಡೆನ್ಸ್ ಇದೆ, GPay ಜನರಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ. That application was rejected ನೋಡಿ. ಅದಕ್ಕೆ ಇವಾಗ ವಾಟ್ಸಪ್ ಮೇಲೆ ಮಂಡೇ ಮಾಡಿದೆ.
when it is rejected?
23 ಮ್ಯಾಟರ್ ಮಾಡಿದೆ.
23 matter, yes.
Please ಮಾಡಿದೆ.
Lord's,
ಮಂಡೇ ಮಾಡಿದೆ.
Lord's proclamation of sale, my lords. My lords, proclamation of sale is issued.
Next week one date ಕೊಡ್ತಾರ.
Proclamation of sale is issued in favor of my developer's lender, my lords. I am the buyer of the apartment from 2011. I moved the trial court under 21, 58 and 59, seeking adjudication and stay. Trial court rejects my advancement application itself. I have a prior right. Attachment is after my right has come into existence.
22nd, yes.
Well, suit for recovery of money, my lord.
Very well. Great.
So there is a direction by the high.
Application is rejected. When? No, when it is rejected, mister? What is the date? Yes, 25th, yes. When arrest warrant was issued?
Jan 6th.
January 6th. Till today, they have not arrested. Yes, you are safe then.
Monday, man.
Yes, 28.
26 matter is trial court matter.
28, yes. 3 ತಿಂಗಳಾಗಿದೆ, ಏನೂ ಆಗಿಲ್ಲ ಬಿಡಿ, yes.
ಎರಡು ಹೇಳ್ಬೇಕು.
Trial court.
Today, yes, tally tomorrow.
Suit for recovery of money, my lord. Order 11.
Tomorrow, yes.
The application was allowed, but my objections have not been filed yet. The urgency is that they are still in illegal possession of my land. May the matter kindly be taken up on.
Now, what is that order you are challenging?
The amended application was allowed. I have to buy my amended claim to that now. The only reason is that my lord, at the very least, in the stage of arguments, we filed a counter claim. That is guys that 617 application. The trial court has allowed the same, and now he's permitted to file a counter claim. I have challenged that order and come before the order. The urgency is that my lord, he's in illegal possession of my land.
No, allowing that amendment petition, illegal possession, how it is related, mister? That is true. That is true. If he is illegal possession or not, it will be decided. Now you are challenging that IA for allowing that amendment. How it is related to that for an urgency, mister?
The urgency will if there's a stay that's operating by this honorable court and the lower court proceedings have been stayed. There's not been proceeded since year 2022. If the matter continues, it has been listed for the last 3 days, but it has not been reached.
Yes, next week one date, yes. Next week date, yes.
The matter is posted for judgment tomorrow.
When it is rejected, your application for temporary injunction application is rejected and posted for judgment. There is no issues, evidence and all.
The suit is of 2017.
Hmm.
They written to yesterday,
Hmm.
and I will post it for them tomorrow.
No, there is no evidence, nothing, they directly posted.
Something-
Yes, Tuesday, yes.
The defendants have been placed ex parte in the trial court. There are no contesting respondents. But, the question is that daughter suit for partition, daughter has not been granted share because her name is not found in the article.
Hmm.
That's all my lord. That is the question.
Yes.
So yesterday it was supposed to be listed, but not listed.
Yes, 26, yes.
Execution proceeding, attachment warrant has been issued on challenging the final order of the fifth student. Eight connected matters.
8 connected matters. Yes, 27th, yes.
Yes.
All matters, yes, 27. Yes.
Millets for rejectment, millets,
Hmm.
filed by me. Millard, in view of the stay granted by this court, Millard, my suit is stayed.
Hmm.
Before Millard, I have filed vacating stay.
You have
Millard.
filed and vacating.
Please,
Yes,
my
next week or one date.
My lord, suit is one for for partition in possession, my lords. In this matter, the matter is coming up on 24th, Monday, my lords. I have sought an IA praying for the relief of ex parte interim injunction. The trial court has issued emergent notice, my lords. My object of filing this writ will be frustrated, my lords. There is urgency in this matter. My matter may be kindly be taken up tomorrow, my lords.
Monday, yes.
My lord,
My lords,
start-
the matter is coming up on Monday, my lords.
Yes, let it be. Yes.
138 proceedings, please, my
Well,
lord, dismiss.
May I make a
Sir, wait ಮಾಡಿ, wait ಮಾಡಿ.
Yes.
yes, ma'am.
138
ma'am.
proceedings, please, my lords, are dismissed. On the same cause of action, he files arbitration, please, my lords. Keeps the ex parte, gets it decreed in Chennai, then he files execution petition. And now attachment warrant has been taken against me, please, my
Hmm.
lords. 27th is the date fixed,
27th,
please,
yes, 26th, yes.
please.
Lord, sir, my lord, sir, filed an IA for interim consideration of prayer, my lord. Lord, so it was listed on Tuesday, my lord, it did not reach. Lord, the question is 7 years, my lord, after 7 years of judgment, they filed a miscellaneous petition.
Hmm.
Without any reasons, my lord, it has been allowed.
Yes,
My lord, so it is now posted on Wednesday for defendant evidence.
yes,
But that is also over. my lord.
Tuesday, yes.
Without mandamus, my lord, for speedy disposal of a suit. The 2006 partition suit, till today, plaintiff's evidence is not taken place. One other reason, my lord, they are filing an application.
Yes, day after tomorrow, yes.
That was suit for partition,
Hmm.
starting 1/6 the share. The suit value is 32 lakh, 1/6 the share is 5 lakh. We have filed an appeal before the district court. District court is not registering the case, raising jurisdiction on pecuniary jurisdiction. Raising that suit value is 32 lakh. Whereas I have challenged only 1/6 the share allotted to the plaintiff, its value is only 5 lakh. Even in spite of it, district court is not able to understand. It's a well settled law that value of.
Hi,
the-
Ian, what is that now?
My lord, it may be listed tomorrow, my lord. I have sought for direction to register the case, appeal.
Yes, Tuesday, yes, 25th.
With the kindly
Well-
of this court, my lords, one pending matter, my lords, partition suit, it was in FDP, FDP was withdrawn. Because Tahsildar issued endorsement that there is a case pending, they wanted to alienate. I came before my lordships passed order, notice was read, and now its service is complete. My
Service
lord, this matter may
completed.
be disposed of.
Yes. 26th, yes.
Well.
Yes,
My lord,
yes.
Melinda,
Yes.
ಹೇಳಿ sir, ಹೇಳಿ sir.
a fresh matter, my lord, by mistake I had filed the commercial appeal, my lord, now I have been permitted to convert it to writ petition, some urgency, my lord. The miscellaneous application has been allowed in a without jurisdiction, my lord.
Yes,
Tomorrow or Monday,
day after tomorrow, yes.
there, much obliged, much.
Yes.
Page wise adjournment, list number 1, page number 1, serial number 1 to 3. Page number 2, serial number 4 to 11. Page number 3, serial number 12 to 21.
My lord, serial number 12, my lord, 1 week's time
Yes, at the request of petitioner, read this matter after 2 weeks.
Page number 4,
Please.
serial number 22 to 27. Page number 5, serial number 28 to 30. Page number 6, serial number 31 to 34.
Appearing for petitioner lordship, serial number 34,
Hmm.
filing withdrawal memo.
Yes, 34 dismissed as withdrawn, yes.
31 case that I have already filed withdrawal.
Yes, 31 dismissed as withdrawn.
Page number 7, serial number 35 to 38. Page number 8, serial number 39 to 41. Page number 9, serial number 42 to 46. Page number 10, serial number 47 to 52. Page number 11, serial number 53 to 55. Page number 12, serial number 56 to 58.
My lordship, 57, my lordship, I'm appearing for respondent. Can you give a 1 week time, my lord?
57.
Yes, my lordship.
Yes, have you informed other side?
Will inform.
Yes, sir. The request of respondent, read this matter next week.
Much obliged, my lordship.
Page number 13, serial number 59 and 60.
Yes. Saturday, yes, day after tomorrow.
List number 1 for preliminary hearing, serial number 1, Sandeep S. Patil for petitioner, Guru Prasanna.
For the caveat respondent,
Yes.
first respondent.
I appear for the petitioner.
Yes.
Writ petition is by the defendant number 1.
Yes,
Suit is for
yes,
recovery of possession and arrears of rent.
yes,
In this, my lord, the written statement had not been filed.
yes.
So thereafter, we sought for permission to file written statement. That was rejected. Against that, a separate petition is pending. In the meanwhile, we made an application for production of documents at page 96.
Yes,
Page 96, we sought for production of BBMP approved building plan, fire safety certificate. The last one, memorandum of settlement dated 25/3/19, entered into between plaintiff and defendant number 2.
yes,
The lease deed, my lord, shows
Hmm.
that all statutory clearances had been obtained. That, my lord, your lordship would get it in the lease deed. That is produced at page 42.
yes,
Relevant page 44. Para 5.
yes,
The lessor has represented to the lessee that it has obtained all the required statutory and other permission, licenses, certificates, approvals for the commercial use and occupancy of the premises, so that lessee can enjoy peaceful possession of the premises without any let or hindrance, so and so, from the authority. Now, it is our case, blood, there was no
yes,
land obtained and occupancy certificate was not there. So therefore, we could not obtain trade license.
yes,
Then in the evidence also, at page 84,
yes,
82 it starts, at page 84, about 10 lines from the top.
yes,
If necessary, the approved sanction plan commencement and completion certificate issued by the concerned authority shall be produced by the court. If it is asked whether those certificates can be produced on the next hearing date, witness says he needs to check and verify from the office.
yes,
Now, my lord, there was another notice issued at page 75 to both defendant number 1 and 2.
Hmm.
In this, my lord, at page 76, there is a reference to the settlement deed which appears to have been executed with the other defendant, second defendant, para
Yes.
6,
para 6.
at page 76.
Hmm.
Starts from page 75,
Yes,
relevant page at page 76, 75.
yes,
Para 6. In the year 2018, the second of you have issued 5 checks to my client, all of which were dishonored for the reason. Funds insufficient. My client was constrained to initiate proceedings under 138 of the Negotiable Instruments Act. So and so. Upon your offer to settle your outstanding dues as on 2019, your assurance that there shall not be any further lapses in the payment of rent, my client accepting the memorandum of settlement dated March 25, 2019, which mandates that the second of you shall pay rupees so and so towards arrears of rent till January 30, 2019, so and so. This memorandum of settlement also, we have made a request that they should produce it.
yes,
Meanwhile, this defendant number 1, defendant number 2 and 3, there is
Yes.
an assignment deed, which is at page 66.
yes,
is an amendment of the lease deed. There, my lord, at page 68.
Yes,
Clause 4(2)(e) of the deed of lease shall be amended as follows.
yes.
The assigner has assigned whole of the premises to Messrs. Lemon Pepper Hospitality Private Limited, so and so. On assignment of the scheduled premises, lease entered into the deed of lease for 2/4/2016 shall be adjourned in favor of the assignee. That is, it is assigned from defendant number 1 to defendant number 2.
Yes.
In the plan, kindly see the plan. At page 32. At page 36. Now, arrears of rent is demanded
Yes,
from both the defendants.
yes.
So that is why I made a request that let these documents be produced. Now the lower court says, since you have not filed written statement, I will not allow it. Page 27.
Yes.
It is not just a suit for eviction, but also for damages. Admittedly, para 11 at page 27. Admittedly, there is a suit for eviction and damages, and the tendency of defendant number 1 is the plaintiff is not in dispute. On the other hand, what emerges from the cross-examination of PW1 is that defendant number 1 has subsequently adorned the tendency to defendant number 2. Therefore, defendant number 1 is not liable for any of the claim. For the sake of repetition, no defense is put forth on record by the defendant. When there is no defense regarding these documents, not being in existence or not being produced when called for by the defendant prior to filing of the suit, calling upon plaintiff to produce those documents is totally unwarranted. Merely because the defendants have not put forth any defense, the court is not required to automatically allow the claim of the plaintiff. The claim of the plaintiff is to be assessed independently based on the evidence on record, and necessary conclusion has to be drawn keeping in mind the fact in issue and evidence to lead in support of it. Learned counsel of the plaintiff relied on so and so judgment.
Yes.
Then at para 12, the court says there is no defense. Para 12, the observation made by the Honorable Bombay High Court in the above decision apply in full force to the prevailing facts and circumstances of the case. In the case on hand, there is no defense by defendant number 1. Under such circumstance, calling upon the plaintiff to produce the intended document is totally unwarranted. Now, but in this regard, what is the scope of Order 11? Rule 12 is, give me the judgment. Is examined by our High Court in one of the judgment.
Yes.
There, from the beginning, at the stage of admission, the respondents are notified. Accordingly, the first respondent has put in appearance the rear counsel. As far as the second respondent is concerned, it is stated that he has remained ex parte in the trial court. Therefore, the matter is heard on merits. The revision petition is directed against the order dated 10th November 1980, passed by the learned second additional civil judge, rejecting an application IA filed by the petitioner to direct defendant number 1 to produce certain documents which are in his possession is mentioned in the application. The learned judge has rejected the application on the ground that the documents are not relevant, that the petitioner plaintiff has no right to seek for direction to the defendants to produce documents under Rule 14, Order 11 of the Code of Civil Procedure, hereinafter referred to as the Code. There is no doubt that learned civil judge has not correctly read the provisions contained in Order 11, Rule 14 of the Code, which are as follows. It shall be lawful for the court at any time during pendency of any suit to order production by any party thereto, upon oath of such of the documents in his possession or power relating to any matter in question in such suit, as the court shall think right, and the court may deal with such documents when produced in such manner as shall appear just. From the aforesaid rule, it is clear that it is open for the court to make an order for production of documents at any time during pendency of the suit. No doubt, exercise of power under Rule 14, Order 11 of the Code is discretionary, subject to two conditions being satisfied. One, the documents, the production of which is sought for must be in possession or power of the party against whom direction is sought, and the documents must relate to the controversy involved in the suit. It need not be pointed out that the discretion must be exercised judicially and not arbitrarily. In the instant case, learned civil judge has not referred to the documents, the production of which is sought for by the petitioner. It is also not stated as to how the document in question are not relevant to the controversy involved in the suit. It is not disputed by the first defendant, first respondent, that the documents in question are in possession or custody. It is also not even stated by the first defendant that the said documents are not at all relevant to the matter in question in the suit. Then, my lord, the suit is for recovery of a sum said to have been paid to the first respondent, first defendant in excess of the amount which is required to pay towards the chassis allotted to him. It is the first defendant who has delivered the chassis to the plaintiff on collecting excess amount from the plaintiff as per case pleaded by him. In order to prove his claim, plaintiff has sought for a direction to the first defendant to produce the following documents so and so. Having regard to the arguments made in the defense put forth by the first respondent, it cannot be held that the documents in question do not relate to the controversy involved in the suit between parties. The first defendant, as it has already been pointed out, has not denied the custody and possession of the documents in question. That being so, the learned civil judge ought to have allowed the application. Similar views taken by another judgment, Justice Suraj Govindaraj.
No, see here,
Yeah.
court has not discussed all these points.
It is not discussed, my lord.
only
It
thing
only
is-
says, I have no defense.
They have no defense.
Yes,
Is it that law?
yes. That is, my lord, it says that Supreme Court also has held
Now
that not,
that is the only a question,
that is the
because
only question.
first,
They have
if that
to
is not the
discuss.
law, that just because you have not filed any defense, you can, then court has to see whether it is in the possession, then
Yeah.
it is irrelevant.
That is
Here
also,
they said you have not filed any defense, therefore,
that is
the law
only
on that point.
That is the only point.
My lords, I'll make my submissions, my lords. The petitioner has not filed his written statement before the commercial court. This is a commercial suit, my lords, for eviction and arrears of rent. He came on record on 30th of May 2024, my lords.
Yes.
Till 30th of September 2024, he doesn't file his written statement. As per the proviso to order 8, my lords, 120 days has elapsed. The learned trial judge observes that and says that by law, the right to file a written statement is forfeited. Subsequently, my lords, the evidence is of the plaintiff, that is the first respondent, is completed. Then, my lords, he files an application to cross-examine the plaintiff witness, my lords. That is also rejected in light of the fact that there is no defense.
We are
Please,
not on that
please.
point.
So, my lords,
Now, party who has not filed any written statement, it is not that he cannot examine that witness, he can cross-examine.
he has, my lord.
He has no
He has
defense.
completed. No, he has completed it.
That is it that law that just because he has not filed any written statement, he can't file an application under order?
Yes, my lords, that is so. I'll file a memo of citations, my lords, of the learned Supreme Court.
Yes.
In fact, my lords, non-filing of a written statement or any kind of a counter,
You
that
read-
doesn't.
Now, by reading order 11, rule 14, doesn't says that if that person who has no defense cannot be filed. It plainly says that when court has to, it is in a discretion of the court.
At the outset, my lords, the Commercial Courts Act, after the Commercial Courts have been promulgated, my lords, Order 11, Rule 14 has been omitted from the Commercial Court, my lords. That is in the schedule of the Commercial Court Act. May I kindly point out to this honorable court?
Yes, where is that?
Please, my lords. May I kindly see Schedule 1 of the Commercial Courts Act, my lords, which correlates to Section 16, specifying the list of amendments to the Code of Civil Procedure
Yes.
after the enactment of the Commercial Courts Act. My lords, Schedule 1, may I kindly see, my lords, I'll skip Order 11, the disclosure, discovery, and inspection of documents in suits. This, my lords, so the stage of Order 11 to be initiated, my lords, is for the purpose of disclosure, discovery, and inspection of documents, my lords. All of it, my lords, the condition precedent is the filing of a written statement. Rule 2, my lords, may I kindly see Rule 2, Rule 3 for inspection. Rule 4, my lords, for admission and denial of documents. Now, Rule 3 and 4 specifically state that all parties shall complete the inspection of all documents disclosed within 30 days of filing of the written statement or the written statement to the counterclaim.
Yes.
Then, my lords, comes the stage of admission and denial under Rule 4, my lords.
Yes.
That also says that each party shall submit a statement of admissions or denials of all documents disclosed and of which inspection has been completed within 15 days for the completion.
Yes.
Then, my lords, may kindly see clause 5, sub-rule 5, my lords, that has been amended.
Yes.
This is in fact the relevant, my lords. It says any party to a proceeding may seek or the court may order at any point during the pendency of a suit production of any by any party or person of such documents in possession or power of such party relating to any matter in question in such suit. 2, 3, 4, and 5, my lords, read in conjunction,
Yes.
make it abundantly clear, my lords, that if any right under Order 11 exists, my lords, it is upon the filing of a written statement. A specific defense has to be taken. It is also, my lords, in addition to it, I will state, and that is this, the position of the Honorable Supreme Court also.
There are two things.
Please.
All that clause says document which is in the possession of the party, either
Please.
the plaintiff or defendant. If the document which is not in the possession of the party to directed to secure from that other persons, now that order 11, rule 14 is there. If it is not included in that commercial court act,
Please.
then general provision is to be applicable.
Even so, my lords, the relevancy of the documents, my lords, this is
All
the
these,
least.
if
I
you
will just
see,
make two more submissions, my lords.
all this is that when that plaintiff or defendant has to file a plaint or a written statement, he has to disclose all these documents in
Please,
his possession
please.
or taken a leave, or that subsequently, if you want, then he had to give a reason it is not in the possession or why he has not produced. This is all related to documents in the possession of the party.
Lords.
Now, the documents which is not in the possession of the party, then order 11, rule 14, seek for any direction to produce.
As far as relevancy of those documents for deciding the dispute is concerned, my
I will
lords.
come to that.
Please.
Relevancy, whether
Please.
it is in that possession of that plaintiff or not, that has to be decided by the court. Now, here only rejected on the ground that he has no defense.
There's
Is
no-
it the law? I am asking that. First, you have to answer.
That is a law, my
then
lords.
we'll
May
go to
kindly see the decisions of the Honorable Supreme Court, my lords. The first judgment, my lords, is of Modula India versus Kamaksha Singh Dio.
Yes,
This is under the West Bengal Premises Tenancy Act, my lords.
yes.
May kindly see the discussion at para 17, my lords. This is a slightly long judgment, my lords.
Yes, yes, relevant paragraph.
Please. Then, my lords, may kindly come to para 19 of the judgment, my lords. My lords have it?
Yes, yes.
Yes. We therefore think that the defendant should be allowed his right of cross-examination and arguments. But we are equally clear that this right should be subject to certain important safeguards. The first of these is that the defendant cannot be allowed to lead his own evidence. None of the observations or decisions cited have gone to the extent of suggesting that despite of the fact that the defense has been struck off, the defendant can adduce evidence on his own or try to substantiate his own case. Secondly, there is force in the apprehension that if one permits cross-examination of the plaintiff witnesses by the defendant whose defense is struck off, procedural chaos may result unless great care is exercised, and that it may be very difficult to keep the cross-examination within the limits of the principles discussed earlier. Under the guise of cross-examination and purported demolition of the plaintiff's case, the defendant may attempt to put forward pleas of his own to perceive quickly the difference between questions put out to elicit a reply from the plaintiff, which may derogate from his own case, and questions put out to substantiate pleas in defense, which the defendant may have in mind, and to restrict the cross-examination to its limit will not be an easy task. We think, however, that this is a difficulty of procedure rather than substance. As pointed out by so-and-so, this is a matter to be sorted out in a practical application rather than laying down a hard and fast rule. May kindly see 21, my lords, the second part of the paragraph.
Yes.
Therefore, the court should, that is about 6-7 lines, my lords.
21 itself. it is
Please,
short.
please.
Para, yes.
A third safeguard which we would like to impose is based on the observations of this court in Sangram Singh's case. As pointed out, therein the essence of the matter in all such cases is that the latitude may be extended by the court to the defendant in spite of not having filed a written statement should not cause prejudice to the plaintiff. Where the defendant does not file a written statement or where he does not appear to contest the case, the plaintiff proceeds on the basis that there is no real opposition and contents himself by letting in just enough evidence to establish a prima facie case. Therefore, the court should ensure that by permitting the defendant at a later stage either to cross-examine the witness or to participate in the proceedings, the plaintiff is not taken by surprise or gravely prejudiced. This difficulty, however, can be easily overcome in practice because there is a wide discretion with the court, and it is always open to the court where it believes that the plaintiff has been misled to exercise its discretion to shut out cross-examination or to regulate it in such a manner as to avoid any real prejudice to the interest of the plaintiff. The next case. Milords, may kindly see the next case is also of the learned Supreme Court, Milords, that paras 18 and 19, Milords. In fact, I'll only read out para 19 of the next judgment.
Yes.
Having held as above, the next question to be asked into whether the NCDRC has given weight to such pleadings and contentions taken by the first respondent in the written submissions, or whether the decision of the NCDRC is based on any factors, or data furnished by the first defendant beyond the extent permissible on account of the legal trammel of forfeiture of its opportunity to file a written statement. At this juncture, we may hasten to add that even the defendant's opposite party's right to file a written statement is forfeited, and that by itself will not make it obligatory on the part of the NCDRC to pass an order in favor of a complainant in case the complainant concerned failed to establish a case. The power is to be read into the jurisdiction of the body with adjudicating power. This is because there is a distinct difference between a situation of non-filing of a written statement pursuant to a declaration that the opposite party had forfeited the right to file a written statement and absence of denial of specific pleadings of complainant in the written statement filed by the opposite party. Certainly, in the latter case, absence of denial of specific pleadings on facts can be taken as admitted. The next two judgments, my lords, are of the Honorable Bombay High Court. That, my lords, may kindly see at para 20.
Page.
My lords, internal page 31, my lords. This is the
Yes.
case of Kamlesh Singh, Harnam Singh Chauhan, my lords.
Yes.
It is no doubt, my lords, have para 20?
Para?
Para 20, son. Page 31 internal law,
Huh.
para 20.
Page 31.
Yes, that is judgmentally page 5, Swami. Bottomally page 5 of 7.
No, ink page 31.
Yes, my lords. Other para 20 is at the bottom.
Para 20 illala. Ink page, it's para 5, 6 is there.
Then, my lords, may kindly see para 20, my lords.
Para 20.
Please.
Para 20 is page 34. Yes.
Yes. It is no doubt
Yes.
true. My lords have it?
Yes, yes.
It is no doubt true that normally the power of cross-examination is unfettered and the court has ample power to order production of any document relating to the matter in question by any party at any stage, and it is for the learned judge to ultimately decide as to the relevancy and admissibility of the documents as provided under section 136 of the Indian Evidence Act. However, the discretion conferred upon the learned judge for the production of documents which are not relied on by the parties is to be exercised judiciously and with caution, and keeping in view the provisions of Order 11, Rule 14 of the Civil Procedure Code. And after having satisfied itself about the expediency, relevancy, and justness of production of the documents sought for, the ultimate test for the court is to consider whether the production of the documents would be necessary for fairly disposing of
All
the
that
suit.
is that the court has to now.
I will just complete.
threshold It has been, you have
Please.
the judgment on that point, because by plain reading of the
Yes, my lords.
provision
Last judgment.
doesn't.
Last judgment, my lords. May
Yes.
kindly see. Para 12 of the last judgment, my lords, also of the Honorable Bombay High Court.
Para 12.
Para 12.
Yes.
In the present case, there is no reference in the plaints to any of the documents of which production is sought by the defendants. The defendants have not yet filed the written statement. They have not given any satisfactory reason for production and inspection of these documents prior to completion of pleadings. From the affidavit in support, it is not at all clear whether the defendants allege that there was an existing concluded agreement between the plaintiffs and the defendants to grant various concessions to the defendants as set out in the affidavit or not. In fact, from the writ petition which the defendants have filed, it would appear that there is no agreement to grant any concession to the defendants, and defendants are seeking various reliefs in the writ petition, as a result of which they would have the benefit of these concessions. In any case, the stand of the defendants in connection with the granting of these concessions is not clear in the absence of any written statement. In this context, by asking for prior inspection of these documents before filing the written statement, the defendants seem to be embarking on a fishing inquiry in order to ascertain the exact nature of correspondence which has ensued between the plaintiffs and the Reserve Bank of India, in order that they may mold their defense on the basis of these documents. In these circumstances, where production of documents is asked for in order that defendants may mold their defense in light of the documents of which they want production and inspection, the discretion ought not to be exercised in favor of the
No,
defendants.
their court discussed that relevancy also.
Yes, my lords, and the reason I will make my submission.
Defense. It cannot be find out that whether it is relevant or not. That is what that. But see here, court is not went to that venture to see that whether it is relevancy or not, whether it's required for this case, whether it is in this your possession or not. Directly says, no, you are not filed written statement. Therefore,
that reason, my lords, is this. This is an eviction suit, my lords. The lease that the learned senior counsel read upon is
No,
5
I'm
years.
not on that.
It lapsed in 2021, my lords.
whatever
So the defendants are in possession, my
I
lords.
will tell you. See,
He is
I'm
seeking
saying
title
that
document.
let the court see whether it is relevancy or not, then decide. Then it is the discretion of
It
the
is, my
court.
lords. In fact, it is also, that is my plea also, that these documents are not relevant. I have taken the plea.
No,
The
that
court
should
has
be-
considered it, my lords.
No, that should be that application of the mind of the court and pass an order.
It has, my lord. It has, my lords. The primary reason might be that there is the defendant has forfeited his right to file a written statement. But the,
Yes.
without pleadings, my lords, there is no cause for the court to summon these documents, especially these are my lord title documents.
Yes.
When the lease has lapsed, the defendants are in, basically now they are squatting over the premises. They're running a restaurant, my
You
lords.
see the reasoning.
Please, I will, my lords. May kindly see para 10 and 11.
That since he has not filed any defense, that is not that. Since that defense is not there, document which is sought, which is nowhere relevant to that case.
Please.
Because we don't know what is his defense. This document is not related to this case. That should be a finding. Nothing.
That is my objection, my lords. He's considered it.
Court has not applied his mind.
My lords, he has, my lords. May kindly see.
Yes.
May kindly see para 9, my lords.
Yes, we'll hear. I see that para 12 is the final conclusion of.
Well, that might be the concluding, the final order, my lords, but may kindly see 8, 9, and 10, my lords.
Yes.
There is a discussion, my lords, and that is where the relevancy discussion is quite detailed, my lords. Under the present application, I am reading para 9, my lords, at page 25. Under the present application, the defendant is seeking for a direction to produce 7 documents as mentioned in the application for effective adjudication of the dispute.
Para 10 is also argument. Para 11, again it said, since you are not set up any defense.
He had, my lords, it is not, and my lords, that is in fact a relevant question to be considered because, my lords, the intention here to be.
Please two things, Mr. Counsel.
Please.
By reading this, if you produce the document straightly on the point saying that if there is no defense, no rights to file an application for production of documents, then you can succeed that. Otherwise, matter required to be reconsidered by that.
There is, my lords, the connected matter. I will just make one submission. My lords, this court, my lords don't have any restriction on the power to consider the relevancy of the documents. It is, my lords have pointed out that what the learned trial judge has only specified or only considered is the fact that there is no written statement filed and the right is forfeited.
Yes.
That being so, my lords have the power to see whether these documents are even relevant for the purpose of deciding the list.
Don't ask me to do that trial.
No, the reason I'm only making that submission, my lords, is
if you are able to convince me saying that he has not filed any written statement, his threshold bar to file an application.
It is, my lords. My lords have held it, my lords.
No, wait. Then you have in a case. Otherwise, matter requires to be. I will grant time even if you.
Order 11, Rule 14, my lords, firstly, is not, it's first of all not applicable. It is omitted by the Commercial Courts Act, my lords.
No,
And
is it?
it is, my lords. It is, my lords.
Wait. By omitting that, by you saying that it is not applicable to that.
It is not so, my lords, because it is, the language of it is in Rule 5, the amended Rule 5, and that precedes, my lords, by Rule 3 and 4, which requires a written statement to be filed. So, my lords, it has to be read in conjunction.
See,
It cannot be seen in isolation.
You read all this 4, 5 and all.
Please.
It is all related to that document in the possession of the party.
That is not even the statement, my lords. It's not even his case that it is in my possession only.
Maybe that legislature, why deleted? All that it is only in respect of that position of the documents in the parties, either plaintiff or defendant.
Please.
If 14 is concerned production, therefore it is not related. That may be the reason it has been deleted and it should be in the general provision.
My lords, that specific provision is omitted, but it is amended, my lords. I may say, I may use the word because
It's not omitted, then you could have said that.
his right is not unfettered. His right is not taken away, my lords. That is why I'm reading Rule 5, the amended Rule 5.
Actually, if it is not omitted, then you could have been argued that it has to be read along with that all other provisions.
It is so, my lords. It
Now
is
it
very
is-
much so.
Now you said that it is omitted from that.
Rule 40 is omitted, but I have also said that, my lords, it is contained under Rule 5. And that is the reason for my submissions that Rule 5 is preceded. The condition that needs to be fulfilled is the filing of a written statement, my lords.
Yes, we'll
In
hear.
fact,
No, only-
to hear this matter, my lords, I would make one final submission. Serial number 44, my lord, that is the specific writ petition which is against the forfeiture of the written statement right, my lord. That is also pending before the Honorable Court. Serial number 44, that needs to be considered, my lord. If that matter is considered, my lords, this wouldn't survive consideration at all. That is my respectful submission.
Yes.
The relevancy of the documents, my lords, are not even pleaded in my plaint. The limited right that was granted to the defendant to cross-examine was with regard to the averments in the plaint. If the plaint averments are seen, my lords, I have not referred to any of these documents, either khata or occupancy certificate. There is a presumption, my lords.
Trial court, after looking into that, let them say that this document is not relevant, therefore I am not exercising the discretionary power. I am rejecting that. But they are straight away, it's very simple and easy, referring the judgment and said that, yes, it is not applicable. They should
The
have
reason-
see
The reason, my lords,
agreement. This is the prior. See, you have no defense. Therefore, this is not relevance.
I will only also request this court, urge this court, my lords, in all earnest, to look at the conduct of the defendant, this petitioner. My lords, he doesn't approach this court at the earliest available opportunity. He forfeits his written statement. Then, my lords, 2.5 months later, he files a writ petition
No.
and then tags
In
this along with that. too. That is all I'm
suit for-
stating.
All suit for eviction.
I quite
Tenants
see, my lords. I quite see.
finding out that wherever that loopholes in the law, they want to
They-
extract that.
They are due to pay about 1.5 crores in rent, my lords. They are squatting on the property and now they're saying, you produce me documents to show that you are the owner of the property, my lords. That is contrary to the whole question of relevance itself, my lords. When they are in possession of the property, now they are saying that you produce documents to show that this document is proper. The
Could
building
have
is
been-
proper, I'm
it
sorry.
could have been dismissed saying that this documents is not relevant to this case. Therefore, we are.
My lords
rejecting.
can still make that observation, my lords.
Yes.
And dismiss this petition is all. That's in light of the observation of the learned Supreme Court, my lords. That's the relevancy also. It isn't.
Yes,
it
let
is-
that trial court say that. Yes. You will take notice.
Yes, my lords.
Yes. Take notice to whom?
This first respondent, my lords.
Yes. So and so learned counsel, aviator is undertaken to appear for. plaintiff.
May I formally file statement of objections, my lords?
Yes, you file it. Issue emergent notice to respondent number 2. Yes, now what is the stage in that suit?
It's also for judgment.
Posted it for judgment, then my lord.
And that is what is happening, my lords. What happens is the petitioner and the respondent number 2 are acting in concert. My lords. I'll make the submission because they have filed a separate written
You
petition.
agreed, I will dispose of, directed them to reconsider.
Please, my lords.
Notice to second respondent can be
Second,
dispensed with.
it dispense, he is
Please.
not an only.
Let it
I
be
will say
reconsidered.
that in terms of that, whether that other 2 condition which has to be satisfied. If it is satisfied or not, then let him decide and pass an order.
Even 33631, my lords, 44, that is the writ petition against the order rejecting the right to file a written statement because it was
That's a-
forfeited, my lord. That also may be disposed of.
That's an independent matter, my lord.
It is in so, my lord, because that is referred to in the judgment itself.
Yes.
If this order is seen, writ petition 33631 is referred to. In fact, they have also, in this writ petition, they have relied on that particular.
No,
writ petition.
suppose if that writ petition is either allowed or dismissed, even that writ petition is dismissed, he is not permitted to file a written statement. But this still stands, whether he can seek for a production of documents.
I am only stating so, my lords,
That's,
that
no,
it is,
that's why.
it is
If you want
related to. my lords.
clarify me how it is it related? I will definitely take it. But if you see that even that writ petition is dismissed, he has been prohibited from filing a written statement. Still, he can seek production of the documents.
I would only urge on the relevancy, my lords.
Say, you have a more defense before disposing that case. You can say that since there is no defense, then court has to see whether it is relevancy or not, only on the basis of your pleading. Yes,
Court has halfway done in the order, my lords, it has stated so,
yes.
stating that written statement is not there. And in light of that, the question of these documents does not arise to be considered.
Wait that to be decided. Suppose if
Well,
it is
I-
decided today,
Let it be disposed, my lords.
if I decided today and said that yes, he has a right to file a written statement, then it will go long. It's better you get it disposed of this IA first. Yes. In this petition,
My lords,
petitioner,
if both the matters can be taken up, my lords, disposed of in this, that is all. Because, my lords, what shouldn't be the case is, my lords, that they will again seek time and in light of this.
We have
because-
no difficulty, let further proceeding be stayed. I did
No,
not
my
want
lords,
to
then, my
say
lords,
that.
I will wait for
If that
disposal.
be so,
No, sir, because the attempt is only to stay, my lord. I don't want that.
yes. This petition is filed by defendant number 1 under Article 227 of Constitution of India, challenging order dated. What is the date of the order? 14/2/2025, passed by 85th Additional City Civil and Session Judge Bangalore in OS number 418 of 2024, whereby IA number filed by that petitioner under Order 11, Rule 14 of CPC is dismissed. plaintiff has filed a suit for recovery of possession,
Eviction and
suit
arrears of
for
rent.
eviction
Please, please.
and
1 crore 66 lakhs is the arrears of rent, my lords.
yes,
Lease is terminated due to effects of time, my lords, in 2021 itself.
and damages,
Arrears of rent, my lords.
arrears of rent,
Yes.
suit for
And also damages.
eviction and arrears of rent
And damages.
and also damages.
Please, please.
After the service of summons, petitioner defendant number 1 has not filed any written statement. On the basis of second defendant file madidra written statement.
He has been placed ex parte, my lords. There is another writ petition that they have filed.
Yes.
He was placed ex parte. 3 months later, he filed the writ petition.
Pleadings of the parties. Points are arises for consideration has been framed by the trial court. Parties are adduced their evidence. After completion of the evidence of both the parties, defendant number 1 has filed this application. IA number 10 under order 11 rule 14 of CPC, seeking direction to the plaintiff to produce the document as enumerated in the list. The same came to be dismissed. Hence, the defendant number 1 is before this court. So and so learned senior counsel appearing for order 10 rule 14. Petitioner has contended that the trial court has failed to exercise that discretionary power under order 11 rule 14. They dismissed that application only on the ground that the defendant petitioner has not filed any written statement. Contended that as per order 11 rule 14, court has to verify 2 aspects, whether documents sought by the parties are in the possession of that document is in his possession and whether that is related to that case. There is no finding in respect of this aspects, hence he sought for allowing that writ petition. Per contra, so and so learned counsel appearing for plaintiff respondent has contended that the defendant petitioner has not filed any written statement and they have not denied the contention raised by the plaintiff in this pleading. Therefore, there is no question of asking for production of the documents from the petitioner. Since party has not filed any written statement defending his case, he cannot seek for a production of the documents, and he further contended that documents which he has sought is not relevant to that case before the case pending before the court. Therefore, trial court has rightly rejected that application. Heard the learned counsel for the parties peruse writ paper. The first defendant plaintiff has filed an IA number 10 under order 11 rule 14 of CPC, directing the plaintiff to produce the document as enumerated in that list. Section order 10, order 11 rule 14 is extracted below. by plain reading the above provision, it is very clear that this is a discretionary power to the court and is subject to two conditions being satisfied. One, the document, the production of which is sought for, must be in the possession or the power of the party against whom the direction is sought for. The document, second, document must related to the controversy involved in that suit. In this case, in impugn order, there is no finding in respect to the above said 2 points. Under these circumstances, the matter requires to be remitted back to the trial court to reconsider this application afresh in accordance with law. Accordingly, writ petition is allowed, order dated so and so is set aside. The trial court is directed to reconsider that IA number 10 filed by the defendant number 1 under order 11 rule 14 of CPC in accordance with law after giving an upper to both the parties. Yes. All the contentions of the parties are left open.
Second, respondent notice is not required since he is placed ex parte.
Yes, memo kodi. Yes, memo is taken on record, notice to order.
No, the date, I mean, a certain period being fixed, my lord, within
That next date.
29th of this month, my lords. It's for judgment. It is actually posted for judgment, my lords.
Yes, trial court is.
Within that
directed
time.
to
my lords.
Dispose of, trial court is directed to consider that application in next date of hearing.
Please, my
The
lords.
parties are directed not to seek any further adjournment.
Please, my lords. I may be permitted to advance and proceed with the matter, my lords.
Yes, any date, you don't, nobody seek an
Please,
adjournment
Manoj.
and hear and dispose.
Deeply,
Yes.
deeply obliged.
All pending applications are disposed.
Serial number 2, Vamshi Krishna C for petitioner.
Appealing for the
Shivakumar.
petitioner, my lord. Yes. Yes,
Next matter same.
Next matter is also same, ಸ್ವಲ್ಪ difference ಇದೆ, but I would like my lords to have the other writ petition also
yes,
in hand so that I can point out to the impugned order and the order sheet
yes.
together.
No, now you are arguing that first matter.
Yes, yes, my lords.
Yes, you are appearing for
1 to 3 in serial number 3, not in serial number 2.
serial number 3.
Yes,
Yes, serial number 2, who is appearing?
VP Shivakumar.
my learned friend VB Shivkumar, I think he was here all this time.
Yes,
I think
Asor. Is it 1 and 2 is connected?
they are
They are not
arising out of
technically
the same
connected, but
trust.
being called together, being
Yes.
called together.
Yes.
Very
Now-
minor point that is involved, my lord.
No,
Uh,
he is not there. But he wants, what is that? He has not said anything. Guess you argue.
Yes, my lord.
Yes.
My lord, in writ petition 8245, which is at serial number 2, my lords, I would draw your honor's attention straight away to page number 165, annexure G, my lords.
No, you are that respondent before the trial court.
I am respondents 1 to 6 and 9. 1
Yes.
to 6 and 9.
What is that order you are challenging?
The impugned order, my lords, impugned order is at page 24. It is an order where my application for recall, reopen and enlargement of time to file my objections for a section 92 petition before the trial court was not allowed. 17.2 was the impugned order. But my lords, I want to give the perspective from the beginning of this section 92,
Yes.
which is why I want to draw your lord's attention to page number 165, annexure G. My lords is on page 165.
Yes.
Come to page 167, my lords. That is the day when 1311, this section 92 was filed.
Yes.
On 1611, my lords, at page 167, we see this. Perused IAS number 2 and the case papers.
Yes.
Admittedly, one more petition in miscellaneous number
Are
1139.
you sought for leave?
Well, I wanted to collate certain documents, my lords.
No. You have filed an 92 petition for what?
I did not file the 92
I've-
petition.
I've
my lord.
filed-
You
They
are
have
the-
filed it.
filed it.
I'm the respondent in
You are
that.
respondent.
Yes, my lord.
Yes.
Admittedly, one more petition in miscellaneous number so and so is pending
92
before this court.
petition, why you have filed?
One, the trustees are misappropriating the temple funds. It is a temple trust.
It is in respect of the temple.
It is respect
Yes.
of temple.
Yes.
In fact, the Archana,
They are all the trustees.
they are trustees.
Yes, ma'am.
Yes, yes. Now that you continue. Your
My lords, admittedly, one more petition in miscellaneous number so and so is pending before this court for similar reliefs. And that said case is posted on 28/11/2024. My lords, this miscellaneous 1139 is the subject matter of the serial number 3 before my lords today. Even in the said petition, the petitioners therein had sought for some interim reliefs and the court opined it proper to issue notice to the respondents therein before granting any such reliefs. In view of the same, court holds that it is proper to issue notice, etc., etc.,
Yes.
and adjourns the matter to 28/11.
Yes.
My lords, if I may cause some inconvenience to my lords in requesting to see serial number 3 writ petition file now, my lords. Page 76, annexure F. Similar, but it was filed in the month of September, my lords,
Yes.
24. On 20,
Why two petition? Two different persons.
two different people, sets of people have filed.
Yes. Yes,
On 26/9, heard, my lords, you're on page 77 now, my lords,
yes.
if I may. Heard Miss HRU advocate appearing for the petitioners, she has prayed to grant leave to institute the suit without issuing notice on the petition to the respondent. She has further, etc., etc. For orders on 27/9. On 27/9,
Yes.
the matter is, notice is issued. And then the matter gets posted to 28/10. On which date? The petitioners before my lord today, we've entered appearance and sought time to file objections.
Yes.
Then the matter, my lords, is adjourned to 28/11, the same date
Yes.
as the other matter also.
Yes.
And then both the matters were started to be called together, my lords. So 28/11. Now, my lords, I will ask my lords to come back to the serial number 2, my lords.
Yes.
Page 24, impugned order, my lords. Slightly before that, my lords, page 168, my lords.
Yes.
On 28/11, my lords.
Yes.
This is the order dated 28/11.
Yes.
Advocate for petitioner present, Sri VKC advocate has filed power for R1 to R6 and R9. My
Yes.
lords, on 28/11,
Yes.
in serial number 2,
Yes.
I have filed power
Yes.
for objection to main petition and IAS, if any, and to hear by 2012. So 22 days later, on page 169,
Yes.
advocate for petitioners present, common objection for R7, 8, and 10 to the main petition filed with a memo and document. Advocate for R12 to 14 has filed a memo praying to allow IAs and the main petition. Shri AD, advocate for R1 to R6 and R9, prays time to file objection to the main petition and IAS. The said prayer is rejected. This is 22 days after I have filed power.
Yes.
Heard learned counsel for petitioners on IA number 1 and IA number 2. Heard learned counsel for R7, 8, and 10 as well as learned counsel for R12 to 14 on IA number 1 and 2. My lords, next para is interesting. Counsel for R1 to R6 and R9 is not present before the court at the time of hearing on IA number 1 and 2. My lords, now I will once again inconvenience my lords to look at the other writ petition at page 84, my lords.
What is there in that?
In that, my lords, the honorable court records my presence.
Yes.
But in this, the honorable court says that I was not even present during the addressing of the arguments.
So what is your case?
My case, my entire case is, my lords, that I need to be permitted to file objections
No,
to the
as
main
on that day
petition.
you are present or not?
I was present, my lords. The honorable court has recorded, my lords. Both the matters are being called together. The reason why I inconvenienced
Maybe
this court,
by mistake or oversight. That
my lords, it could be, my lords, but if you look at the impugned order, my lords, it is as if we are causing unnecessary delay intentionally, my lords. That is not at all the intention, my lords.
Yes.
My lords, in so far as serial number 2, my lords,
Yes.
which is before my lords
You are
today,
that respondent number?
1 to 6 and 9, my lords. The matter is as simple as filing objections to section 92 main petition and IA number 1 and 2.
Yes. Yes.
And by virtue of the impugned order, my lords, if page 24, my lords,
Now, what is that order?
My lords is on page 24.
Yes.
Orders on IA 5 to 7. Respondent 1 to 6.
Yes.
Sorry, my lords. Yes. Got it.
Both.
The respondents 1 to 6 and 9 have maintained IA 4 under section 151 CPC, praying for recall of the order dated 20/12/2024. My lords, this is the order we just read now.
Yes.
Number 5, under order 151, praying to reopen the case to enable them to file their objections to the main petition. Under section 148, enlargement of time was also sought for. The petitioners have filed their common objections to these applications. This court has heard learned counsel for respondent number 1 to 6 and 9 and learned counsel for petitioners. This is a petition filed under section 92, praying for permission to the petitioners to institute a suit against the respondents. This petition was filed on 13/11. The petitioners have maintained IA numbers 1 and 2, praying for appointment of an administrator and for permission. My lords, in this particular matter, my lords, we have entered appearance only on 28/11, my lords.
Yes.
And my opportunity to file objections was rejected on 2012, my lords. Exactly 22 days after I have appeared in this matter.
Yes.
My entire grievance is that, my lords, it's not even 30 days was completed, but it was closed. And thereafter, when we file a recall and reopen application on 7/1, my lords, which was heard on 9/1, this impugned order has come to be passed.
Now, where is that limitation for 30 days?
I know, man. So I was only on reasonable time, my lords. That's it, my lords. I was not backing my argument based on a statutory right as such, but as a fundamental right, my lords, that reasonable time to be provided for me
Is
to
there
place
any-
my objections,
Is there
my
any
lords.
time limits for filing any written statement under that provision?
60, 90 days plus another 30 days, my lords.
Yes. Yes. No, this, you want to file any written statement or objection to that?
Objections to the main petition as well as 1 and 2, my lords. I will file for both
Yes.
and argue the matter on IA 1 and 2.
Now, what is that they have rejected?
They have rejected this, my
And
lords.
then what has happened?
Now we are before my lords challenging that particular rejection, my lords. And the matter is posted for orders on IA number 1 and 2, and the matter is listed tomorrow before the trial court.
Yes, Mr.
The only thing is, for filing written statement and all that, that is not the prayer made. Kindly turn to page 187. Page 187. This is the application filed by him,
187.
187.
Yes.
For the reasons stated in the accompanying memorandum of facts, undersigned counsel for the respondent 1 to 6 and 9 pray that this honorable court may please to enlarge time to file objections to the petition and IAs 1 and 2 in the interest of justice. This is all what he sought for. Then
Yes.
turn to the memorandum of facts. They have given some reasons, which this is what it said, para 3. I submit we have entered appearance on behalf of the respondent, 1 to 6 and 9, thereafter referred to as these respondents, on 28/11/24. Thereafter, the matter was posted on 20/12/24 for objections. On 20/12/24, we sought time to file objections to the main petition, as well as IAs 1 and 2. However, the said prayer was rejected by this court, and objections by these respondents was taken nil. On the same day, respondents 7, 8, and 10 filed their objections, thereby admitting the claims of the petitioner, pursuant to which the matter was posted to orders on IAs 1 and 2. It may be noted that respondents were not provided a copy of the objections and the documents relied therein by the respondent. This is the reason. Some respondents' objections were not given. That is 7, 8, 10. These respondents requested respondent 7, 8, and 10 advocate to provide copy of their objections along with the documents. However, respondent 7, 8, 10 advocate refused to provide these respondent a copies. I further state that petitioners and respondent 7, 8, 10 are hand in glove with each other. And it is imperative for these respondents to pursue the same and but for the same when. Therefore, without being provided with a copy of the objections and the documents relied by respondents 7, 8, and 10, these respondents will not be able to put forth their defense. Thus, for this honorable court to direct respondents 7, 8, 10 to furnish the said objections copy and documents filed in support and to enable these respondents to file detailed objections, so on and so on.
No, it's hardly within 30 days, they
I'm
start
not
for an
on that.
objection. What is?
He can even today file it with an application, or he need not file any applications also. This is 92 petition. But 92 petition will have to be seriously viewed. The reason is there are a serious allegations. Why this all expenditure in going to courts and seeking all sorts of things is.
Yes.
Not the
My lord, in
trustee-
view of the serious. Yes, my lord.
1 minute,
Apologies.
don't feel bad.
I'm sorry. I'm not feeling bad, sir.
The trustees themselves became thieves. The hundis were being taken away. Funds from the hundis were being taken away. Counted, they used to pocket it and then run away to their houses. That is the main allegations, and it is in the CCTV camera and also in the television. Public are against these trustees who are trying to stealthily take away. There is a criminal case pending, criminal prosecution case pending, and almost 35 lakhs is taken away. Public money is being taken away. If that is delayed, the court also felt.
No, now that is our application objection to that main, it is different because for that trial and has to go. In respect of that appointment,
Trial, my lord. There is no trial
you
now.
need not prove that
There
you
is,
are.
there is no trial now. The only thing is whether I have made out a case to grant leave or not.
Yes.
It's a discretion of the court. If I establish before the court that the scheme has to be taken and taken place by virtue of the accompanying suit, then the court can grant me leave.
Then both your application for appointment of the administrator and that this both can be heard
That
together.
can be considered even now,
That can be together.
prior to the leave being granted.
Yes. Now that anyhow that is objection is ready, we'll direct it to file and next date you only think is for an argument. Let
Yes,
them
ma'am.
argue and pass an order.
Yes, ma'am.
That's not a difficulty.
Hmm.
What should happen? There is going to be a meeting, counting everything on Monday.
No,
Some more hundi monies will go away.
see, show me that law, which law says that it should be filed within that time.
I am not saying, my lord, he should take, he should be diligent. But look at his affidavit, council's affidavit. Should we look at that or not? Council says, respondents have not given me copy, therefore I cannot file.
My lord, let me place one other
he
aspect,
say
my
so?
lords, on record.
See, now.
And you say hand in glove.
No, let me show you, sir. My lords, if I may permitted, my lords, lot of things were said, my lords. My lords, if I may take my lords back to.
No, now that only thing is that file, now he has already written statement is, his objection is ready.
Where
In
is
both
it
that.
ready?
When he has sought for an
Where
permission,
is
it
it
should,
ready, man?
he will file it. If you given a permission,
But he can even now go and ask for permission.
no.
Kind-
permission
That was
is
denied, which
rejected,
is why
therefore
before
he
my
is
lord.
before this court.
Kindly look at the order, what the learned judge.
That itself was denied, my lords, which is
Yes.
why before my
But
lords.
Kindly read the order, ma'am. Page
Yes.
26.
Yes.
Respondents 1 to 6
Hmm.
and 9 have maintained IA 4 under section 151 CPC, praying to recall order dated 2012-24.
Hmm.
IA 5, 151 seeking reopen the case to enable him to file their objections
Hmm.
to the main petition,
Hmm.
IA 1 and 2 and IA 6 under 148 CPC, praying to enlarge time to file their objections to the main petition. The petitioner have filed their common objections to this one. So, para 4. This is a petition filed
Hmm.
under section 92(1) of the CPC, praying for permission to the petitioners to institute a suit against the respondent. This petition was filed on 13/11/24. The petitioners have maintained IAs 1 and 2, praying for appointment of the administrator and for permission to participate in functioning of the respondent one trust as interim relief. On 16/11/24, this court passed an order, issue notice to the respondent on the main petition as well as IAs 1 and 2 on the ground that's the similar petition in miscellaneous number so and so is pending.
Yes.
On service of notice, respondents appeared before the court on 28
No, now that this application is rejected, IA is dismissed. IA for reopening and permission is
He has
dismissed.
given reasons.
Yes, yes,
His reasons can't be said it's a wrong reason.
yes, yes.
He is a district judge who has given reasons.
That we have to be, even district judge, we have to be accept.
I'm not saying accepted.
What is your argument saying that district judge has given a reason? Therefore, you can say that reason.
Section 92 must be viewed very seriously.
Yes, yes, I will consider.
Must be viewed very seriously.
Yes,
Look at how, my lord,
yes.
9, para 9, my lords may straight away
Yes,
take
I
9.
heard it, yes.
On 7/1/25,
Yes,
respondents 1 to 6 and 9
yes,
got advanced the case
yes,
and filed present applications.
yes,
The counsel for these respondents have filed
yes,
memorandum of facts accompanying these applications wherein he has stated that copies of the objections and documents relied upon by
yes,
respondents 7, 8, and 10 were not provided to them, and that without its copies, they will not be able to put forth their defense. As already pointed out, IA 6 to the respondent 1 to 6, 9 have sought for enlargement of time to file their objections to the main petition, as well as IAs 1 and 2. This court has rejected such prayer. These respondents vide order on 20/12/24. As such, it is to be held that prayer made in these respondents, IA 7 is misconceived. Respondents 1, 6, and 9 have maintained these applications only on the ground that respondents 7, 8, 10 are hand in glove with the petitioners, that they are not in a position to file their objections without copy of the objections.
yes.
So petitioners is not in, I am saying the miscellaneous petitioners who have before the court, there's no allegations against them. There's no impediment for him to file objections to the main petition. Only thing is, it's a delay tactics. The reason is trustees are thieves there.
Yes.
That's the only problem. And Monday they want to conduct a meeting. That's the reason why this hurried writ petition. 2 writ petitions were filed before this court on the previous occasions.
Yes.
They withdrew those writ petitions without assigning any reasons.
No,
This
my
is
lord,
the
that,
second
that
writ
was a,
petition.
that was a mistake on my part. There was a detailed order, that was my fault, my lords.
Yes.
We had not noticed that.
Yes.
We obtained the certified copy of the order and we have filed a fresh writ petition.
What is that next writ petition?
Similar orders, my lords, but in that the writ petition was filed on 25th of September. And then eventually we entered appearance on 28/10.
No, there also your objection to that.
Yes, same,
59.
similar.
Yes. Yes.
In
now
fact,
that-
the enlargement
now
application.
what is the next date in the trial court?
Tomorrow, my lords. It is posted for orders on IA 1 and 2, my lords.
Yes. No, your objection is ready.
My lords, I'll need another day, my lords. I will file my objections and argue the matter also, my lords.
Yes, we will fix the date. On that day, you argue that next week.
Kindly, my lord. Next week, any date, I'm okay, my lords.
I have different grounds. I may be hurt, my lord.
Yes.
Case number 3 writ petition.
Yes.
In that, the miscellaneous petition was filed much earlier. He
Yes.
had much more than 30 days. He has over 90 days to file the written statement,
Yes.
and it has not been filed. Your lordship may kindly see the order sheet which has been produced with petition.
My lords, not for a moment, I'm disagreeing with what my learned friend is saying in so far as this particular miscellaneous petition. I myself am submitting this. Yes, in that we had entered appearance on 25/10. My lords, in that on 2012, my lords, we have filed an application seeking enlargement of time, giving certain reasons that we needed to collect. One of the objections that was taken before the trial court and also recorded by the trial court in its impugned order is that the reasons given by us on 7/1 and the reasons given on 2012 do not collate with each other, and as such, I am not inclined to consider it.
In 92 petition, are they filing an objection or are they filing in a written statement? Which is that provision?
Objections, my lord.
Have to file
You have to
objections.
file objections.
What is that 92 says? Yes, 92. Yes, in case of any alleged breach, security officials having interest in the so and so institution. Statements and not principal origin. So, circumstances provided within the- Under the origin of the-
It only drawing up of a scheme on those grounds.
Yes, where the original purpose of the process was determined to follow from all things. What's the purpose? Where is that procedure and all? How that whether notice has to be given to that other side? No, if no
Actually-
person is there, public notice has to be given.
Actually, notice need not be given, other side need not be heard also. There are various citations on that point.
Hmm.
In the wisdom of the trial court, notice has been issued, they were given an opportunity. They have flouted their opportunity.
No, where is that? Is there any separate procedure for that?
There is no
92
separate procedure,
Hmm.
but there are various citations which would say that there is no need to hear the respondents.
Hmm.
It is only a permission, leave to
Deemed
file a suit.
necessary for the administration.
For
of
leave to
any
file a suit, no hearing needs to be done.
It's just a procedure that the court will have to take.
My lords, in fact, in this particular petitions, my lord, the court has.
Where is that, you have to be heard by passing an-
The court, my lords, before, when the matter was originally filed on 25/9 in serial number 3, my lords, the court deemed it fit to issue notice on 27/9, my lords, the petitioner in fact submitted that the IA number 1 and 2 be allowed without the respondents being present. But however, the court in its wisdom found it fit that notice should be ordered, and on 27/9 notice was ordered.
Yes.
So thereby the court starts, the time starts, my lords, and I entered appearance on 28/10, my lord. So my reasonable opportunity, once the court in its wisdom decided, no, I have to hear the other side, has issue notice to me.
What is that notice says? You have the
Notice.
copy of the notice. Is it says that if you have any objection, you have to file it?
Yes, my lords.
Is it that?
Yes, my lords. My lords, if,
I saw a citation of Honorable Supreme Court.
Yes.
There is no need to hear the respondents in a section 92 petition.
but the court chose to, my lords.
What is the position?
The, the only caution is that there might be a misuse of section 92. Therefore, as a matter
And-
of caution, the notice may be issued. But there is absolutely no mandatory requirement.
But when
by
the
law.
court has-
Please let me-
Wait,
please.
Yes, my lords.
Yes.
The very head note of that.
Head note B. Mr.
Head note
Hmm.
at the very beginning, there is absolutely no requirement for the court to issue notice or hear the respondents in a section 92 petition.
Hmm.
It is only a matter of caution to avoid abuse
is-
of section
No,
92.
you read that provision, the relevant portion of the judgment.
I got only one copy of it. The head note of it.
Head
Is
note,
that-
head note is not the judgment. Yes, para 17. Plain reading of native, leave of the court is. English and present judges of. Unless have their official objection.
Okay.
Now, once notice is given, court said, the defendant could bring to the notice of the court of instances that allegations made in the plaint are frivolous and reckless.
Absolutely.
Then he has to file an.
He
Absolutely.
has
my
been given. He has to file.
That's, see, whether sufficient opportunity is given or not.
Correct. Now,
That's
I
all-
will-
that is
I will
all that
come
is
to
there
your
to be
point.
Judgment
decided,
says
my
that once notice is issued,
Yes.
then he has to file an objection saying that, no, these allegations are wrong or.
Correct. Now, kindly your lordship may see the order sheet, how much opportunity has been given in serial number 3.
Yes, in serial number 3, we'll see that, yes.
See, kindly see page number 82 is the order sheet where they filed their wakalat. Serial number 3, my petition was filed much earlier than serial number 2.
80,
Page number 82, my lords.
82, yes.
The current petitioners before your lordship has filed their wakalat
Hmm.
on 28/10/24, 28th of October.
Yes,
Written statement 28/11, 31 days has already been granted.
Now, where is that?
Now,
Called
kind-
absent service of notice to so and so through his court held sufficient.
that
Appear
is as far as other response, we are not concerned with them.
Yes.
Advocates for respondents pray time, that is the petitioners hearing pray time to file objections. One
Objection
more
to the
opportunity is
main
given.
petition IA. Any to be,
2012, one more opportunity. So another 30 days is granted, which we are already 61 days into
no,
filing Makara.
28/10/2024 they have filed.
I filed wakalat and short time,
28th October they have filed.
and then thereafter 28/11, my lord.
Is 31 days,
28/11.
is 31 days.
Yes.
On 28/11, they seek another adjournment. Time is given for 2012,
Yes.
which
Now
is
that-
another 22 days.
If permitted to file an objection in that case is also nothing to do with this same thing. If both are claiming on the same this thing,
My lord,
if it is permitted in that one case, can we make use of that other also? See, because there is no 30 days limitation here, but taking into the consideration of that petition under 92, he should be file it within reasonable time. He cannot be dragged that matter. But-
the honorable court has not come down on delay. The honorable court has come down very heavily upon the petitioners for making a false submission before the court.
What
That
is
is
that?
why the court has come down upon them.
What is that false submission?
Kindly see
Hmm.
on 2012, that is the next day.
Hmm.
Page number 84, my lord.
No, that is one of the ground
That is the
supporting,
ground on which the impugned
no,
order
one
is
of the
passed.
grounds supporting your 92 petition.
Yes.
Even here also there.
Here
That-
also, because the petitioners are not clean people, they're very
Yes.
dirty people. Before the court also, they make a false submission. The
Yes,
court has come down very heavily upon the false submission. It
yes,
is not just mere delay. Kindly see, your lordship, page number 84, continuation. On
yes.
2012, what happens? They file an application under 148 for enlargement of time. That
No,
kept
that tomorrow is that date.
Tomorrow is the date.
for
No,
the-
tomorrow you file an objection.
Lord,
Next
day after
day-
tomorrow I'll file. Day after tomorrow I'll file, my lord.
That's today is the.
And next
20th.
week, one date can be fixed. We can argue the matter also, man.
On
Not a big deal.
25th or 26th, we'll fix the date. On that day, it can be heard.
Next-
Absolutely, my
next-
lords.
It is date tomorrow. They may be permitted to file their objections tomorrow itself, argue tomorrow afternoon.
Saturday, I'll file my objections, my lords.
No,
I will
you-
argue next
No,
week.
he
my
will
lords.
file it by Saturday
Yes, my lord.
and Monday or Tuesday, I will fix that for an hearing.
Let me argue on
Absolutely,
Saturday
ma'am.
itself. Let
But
me
there
argue
is
on Saturday
some
afternoon.
urgency on this matter.
No,
It's a-
then you argue on the Saturday. Yes,
Yes.
Saturday you file it and argue it.
We'll argue.
That's
But we have a prima facie case.
Very well, my
Let
lords.
them
So
decide
that-
on that.
Very well, my lord.
They can pass an order on IA, but let them give an opportunity.
Very well, my lords.
By 22nd, 22, you have to be file it. On that day, if court feels, can be pass an order.
Absolutely, my lords.
And in this matter, the delay is being caused deliberately because they're misappropriating. The longer this delay is there, the longer the trustees remain. there in
Yes,
order
now,
to be-
now that,
Kindly
yes.
terms may be placed for.
no, only
expeditious
2 days
disposal.
will be extended. That's all. Yes.
Kindly, they may put to terms to expeditious disposal. The trial court may be put to some terms for expeditious
No,
disposal.
22nd itself is courts, after hearing
And
that
also time limit for disposal of the section 92 as well as. the
92, what
application.
else remains then? After hearing that, court has to grant it or reject it.
Within maybe 1 week, because I don't know if they take several months, then they are put to great advantage, we are put to great disadvantage.
No, if your application is allowed, then there is no problem.
Correct. Let there be a time limit for the application.
Absolutely, my lords.
Question
Let
we
there
can
be a time limit for that, my lords.
Yes.
No problem.
Kali. In this,
Only one request,
yes.
let them not conduct meetings of the trust.
When is that?
But it's on Monday.
You asked me for the trial court. That is not the issue before me.
But even if,
No,
we-
see, even when the trial court is not ready to pass order on that before 24th, you ask that to grant any interim order on that 24th, not to take any decision till the disposal of that application. Because that is not the issue before me. When I
they have
dispose
been
of,
making similar requests there also.
yes,
But
If we
these,
file one more application on 22nd, they will take date for objection, another it will go for another few more months.
no,
So us making one more application.
no,
for the trial court
can
would
the
be-
court can't pass an order on your application?
but our only grievance is devotees' monies are being taken away.
Because all those will be answered in the objections, my lords. We are, just making allegations, I'm sorry.
No,
my lords,
that-
but.
We are not
it's
making
unfair, my lords,
allegations.
Very unfair. My lords, may I point to one other aspect, my lords? If so many
See,
amendments and allegations
you
are
are
being made,
giving
I
an,
want to point
you are
out one
giving
other
an
aspect.
opportunity to prove that allegation is frivolous.
I'm
That
obliged,
is
my
what
lord.
the Supreme Court said.
Absolutely, my
If you
lords, I'm
convince
obliged,
the
my lords.
court, they will reject that plea.
Absolutely, my lords.
Otherwise, they will grant
Unnecessarily,
it.
why
Yes,
these
correct.
allegations are being made in open court, I don't understand.
Yes. This petition is filed by respondent number 1 to 6,
1 to 6 and 9.
1 to 6 and 7 is the 1 to 6, 7,
And 9.
7 and 9, 1 to 7.
Only, no, my lords, respondents 1 to 6 and respondent number 9.
No, you see that in that last title. After 6, it is, yes, it is 9.
9, my lords.
Yes, petitioner 7, yes, respondent number 9, 1 to 6 and respondent number 9. In both petition, order has been passed on the same day.
Yes, my lords.
Yes.
They're being called together, my lords, from 2811.
Yes. 8245. Yes, first matter. ಎರಡನ್ನು ಕ್ಲಬ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ. Challenging order dated 17/2/2025 passed by Principal City Civil and Session Judge Bangalore in miscellaneous petition 1321 of 2024 and
139 of 25.
113
1139
1139 of
1139.
24.
24, whereby application filed by the petitioner herein. What are the two applications?
3 applications.
3.
Recalling order dated 20/12/24.
ಎರಡರಲ್ಲೂ ಒಂದೇ ಡೇಟ್ recalling, recalling order dated?
2012
2024.
Wait, one of
Yes,
them,
ma'am.
yes.
2012/24.
2012-24. Innondu?
The other is to permit the defendant to file the
Yes.
written statements.
Permit to file written statement. What is that another one?
And the third is to enlarge time under section 148.
Yes. File 3 application. One is for recalling the order dated 28/12/2024. Another one is permitted to file an objection. One more application is for enlarging the time for filing an objection. Thus, applications has been rejected by impugn order. The petitioner is before this. Defendant is before this court. Respondent herein has filed an petition under section 92 of CPC seeking leave of the court to file a suit against that trustees, and they have made a serious allegation against the trustees. On the basis of their petition filed under 92 and IA number 1 and 2 filed in the said petition, trial court has issued a notice on respondents.
In serial number 2, it is on 2811, 16.
In spite of granting sufficient opportunity, they have not filed any objection. Therefore, by order dated 28/12/2024, the objection of the respondent has taken nil. Now that matter is posted for argument on 21st.
Orders on.
Orders.
Orders on 20th,
Tomorrow.
Yes,
21.
21st.
Tomorrow it is.
Tomorrow is the 20th.
21 3 months.
20th, yes. 21-3. Be that as it may, since the respondents has received that notice from the court, they are required to file an objection to that 92 petition as well as IA filed by the parties, IA number 1 and 2 filed under that said petition. In the interest of justice, I am of the opinion that the petitioner herein may be permitted to file an objection to main petition as well as IA. In view of the above, the writ petition required to be allowed. The order dated so and so is set aside. The petitioner herein, that is respondent number 1 to 6 and 9, is permitted to file an objection as well as objection to that main petition as well as to that IA number 1 and 2 on or before 22nd.
You should serve copies to us.
After, before serving a copy to that other side, the trial court is directed to hear that application filed by the petitioner, IA number 1 and 2 on 22nd. The respondent is directed to not to take any further adjournment. Parties has to be directed to argue on that IA on 22nd. All the contentions of the parties are left open.
Disposal of the section 92 kind of date with or any.
Section 92 ಗೆ yes, 92 ಗೆ ತಗೊಂಡಿರೋದನ್ನ IA ಗೆ ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂಡು ಮುಂದಾಕ್ಬಿಟ್ಟಾರು, ಸುಮ್ನೆ ಬಿಟ್ಟುಬಿಡಿ. IA they can pass on order on 22 itself, kept open that. If I say
date be fixed for IA is to be allow or to be adjudicated at any date.
IA adjudicated, if I say it is next week, court may pass order on 22 itself, then they will stop it and will pass it on. You press for an order on 22 itself, mister.
On the interlocutory application.
On the interlocutory application, you press for an order on 22. If I say 29, then court will take it that I can pass an order at 29.
If no observation is made by this honorable court regarding time, then the court will take it
No,
immediately.
I will do one thing. I will direct it to dispose of that main petition by end of February, April. IA, I will not say anything.
End
You
of-
can,
end of March, my lord.
by end of April 9th.
Right.
Yes, and also directed the trial court to dispose of that miscellaneous petition on or before end of, on or before 9th April. Yes,
Interlocutory applications be heard on 22nd.
22nd, that's why I have said, yes.
But that's observation is not there.
I said that 22nd, it has to be heard.
On
Party
the-
should not take any
On the
agenda
applications.
on the application one, yes.
Highly obliged.
And it is made clear that the parties are directed to and without this order, parties are directed to be mentioned before the court.
Highly obliged.
Yes.
Highly obliged.
Because order, we may not get that order.
I know.
Yes. Or you, let us see, order one ready ಮಾಡಿ. Yes, we'll try to release that order.
But to hear on
Did we
those
make a memo
ideas and
for by
pass
hand?
orders.
Huh?
My lords have said to hear the interlocutory application.
Yes,
And also pass orders. Main petition, not let him pass orders on 9th.
no, I said on 22nd, he has to hear the parties on IA.
Yes,
And
pass
dispose-
orders.
And pass an order in accordance with law after giving an percentage.
Yes.
Main petition has to be disposed of on or before 9th April. That's what I said. Yes.
Cell number 4, Rupesha B.
The date of filing the impugned order was, certified copy was not available. This, my lord, plaintiff's writ petition. Plaintiff has filed a suit for declaration to declare Schedule C property as a common road,
Yes.
which I acquired under the registered partition deed.
Hmm.
The registered partition deed is at annexure A, my lord.
Yes.
That, my lord, page 30,
Suit for,
declaration
yes.
of easement right to declare suit Schedule C property as a common road
Hmm.
to access the petitioner as well as respondents.
Yes.
Annexure A is the partition deed dated 31/3/2009, my lord. In this, my lord, page 31, 106/1 measuring 1 acre 34 guntas,
Page 31.
page 34, my lord. Schedule B, item 1. All the piece and parcel of property situated at survey number 106/1, Kengeri village, Kengeri Hubli, Bangalore South Taluk, totally measuring 32.5 guntas, out of 1 acre 38 guntas and bounded by.
Yes.
East by property belongs to Leelavati and road 25 feet. Leelavati is the petitioner before my lords.
Yes.
She is the plaintiff. And 25 feet road is the C schedule property. Leelavati has also acquired 106/1 34 guntas at page 36, my lord. Schedule E, item number 1. She has also acquired 34.5 guntas. Ali west ke property belongs to Arsappa anta ide. That is the first respondent here. The first respondent now trying to put up compound wall to the 25 feet road is concerned. I filed a suit before the trial court and I prima facie I proved all the ingredients, including the photographs. But the trial court at the time of passing order has held that the petitioner has not proved a prima facie case, hence issued emergent notice. This is the, I request my lords, annexure C is the rough sketch, my lord. There is a service road, page 62.
Now what he is putting up in a compound wall?
Compound wall.
Where is your application for injunction?
Page annexure E, my lord, page 68. Page 69 is the application. That for the reason stated in the accompanying affidavit, the plaintiff prays this honorable court be pleased to grant an order of temporary injunction against the defendant's opponents, restraining them either through themselves, their agents, servants, or anybody claiming under them not to interfere at suit schedule C property for being used by the plaintiff as road to reach southern side of suit schedule B property, which runs from north to south in the interest of justice. So suit schedule is the road is described in.
Yes.
But though there is a prima facie case and threat of putting up compound wall. Annexure D4, page 67, photograph may be shown. Maybe it seen, my lord, in that.
No, that which C scheduled property, na?
Oh, the C scheduled property is the road.
Now in that he is putting up
He is putting up a compound wall, encroaching the road portion.
Yes, let him maintain status quo. Yes, heard. Issue notice. What is our directed to maintain status quo in respect of petition C scheduled property till next date of hearing? Yes.
Not up, put up compound wall and tadre.
Status quo andre he can't put up that compound wall. Huh?
ಈಗ ಕಟ್ಬಿಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳಿ.
No, see. ಅವ್ರು ನಾವು ಹಿಂದೆನೆ ಕಟ್ಟಿದೀವಿ ಅಂತಂದ್ರೆ ಸ್ಟೇಟಸ್ ಆದ್ರೆ ಈ can't do anything now. They may say that we have constructed earlier. No.
Status quo ಅಂತ ಇದೆ ಅನ್ನೋದು difficult.
Status quo andre even he can't put up and he can't use that this thing. That is how that it is protected. Yes. If you want, I say respondents are directed not to put up any compound wall. ಏನದು ರೋಡ?
In 25 in suit schedule C property, that is.
Put up any compound wall in. No, that where is that C scheduled property? What is that C scheduled?
Plaint, my lord. At annexure. Annexure B, page 58 is the schedule. A scheduled property is below to first defendant. B scheduled property is ours. C scheduled property is the common road.
C scheduled property is the only a compound wall.
C is the road.
A, B.
C is the road, 25.
The road.
Yes.
Yes. Not to put up any compound wall in C scheduled property. Yes, till next date of hearing.
Much of.
Cell number 5, Vasanta AK.
Appear for the petitioner, my lord.
Yes.
This is with respect to 25 guntas of land.
Yes.
In survey number 37/6 of Pindi Papanahalli village.
Yes.
Petitioner purchased in the year 2016, my lord.
Hmm.
Prior to that, there was a original suit.
Yes.
between the brothers of the sellers as well as other two brothers and father. Initially, in the year 1975,
Yes.
the settlement deed came to be executed on the basis of that the first suit
Yes.
partly decreed, and subsequently one more original suit came to be filed,
Yes.
numbered as OS number 386 of 1997.
Yes.
There 1/4 share of to the four brothers
Hmm.
allotted.
Hmm.
Subsequently, one more suit, OS number 186 of 2007,
Hmm.
came to be filed.
Hmm.
It partly decreed for partition.
Yes.
Subsequently, REA 65 of 2016 came to be filed and confirmed the order of decree of the confirmed the decree in
Yes.
OS number 186 of 2007.
Yes.
Now, FDP number 2 of 24 came to be filed.
Hmm.
During the pendency of REA,
Hmm.
I purchased the property. I was not knowing these proceedings.
Yes.
Now I have filed the IA on recently IA filed on 25/2/2025.
Hmm.
IA under order 21 rule 97 and 102 read with section 151 as well as IA under section 151 of CPC.
Yes.
IA number 8 and 9 of 2025.
What has happened that?
My lord, during the I am drawing the attention of this honorable court to page number 28, annexure A. Page number 27, annexure A, my lord.
Yes.
11 pages, 30 page number.
No, what is that? Your application is rejected.
My application is not rejected, my lord. May I read, my lord?
Hmm.
The case advanced today. Shri MK advocate files wakalat to objector and IA number 8 under order 21 rule 97 of CPC. Further, the objector filed IA number 9 under section 151 of CPC. Hence, objection on IA number 8 and 9 and avoid court commission report. Court commissions appointed on 1/10/2024.
Yes.
Relevant page is 28, page number 28.
Yes.
Last 4 lines in page number 28, my lord.
Yes.
May I read, my lord?
Yes.
Hence, perusal the case record, the ADLR Sidlagata appointed as court commissioner item number 1 to 21.
Hmm.
The subject matter suit schedule property here, item number 21.
Now, what is that order you are challenging now?
My lord, I am challenging the order dated 27/2/2025.
ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ಅದರಲ್ಲಿ?
Now, court commissioner has to demarcate the property, my lord, because I have purchased the property. My presence is not is required, my lord.
No, you can file an objection to that court commissioner report saying that no opportunity has been given.
But here, my lord, in the
Case advanced, the advocate filed so and so, and subjection of IA 8 and avoid court commissioner report. Aste court
Please,
commissioner appoint ಮಾಡಿ, he has already conducting the survey.
No, he has not conducted the survey. He has not visited the spot. That being
Now
the fact, my this coordinate page of this honorable court, I am drawing the attention of this honorable court to page number 170, annexure N. Relevant page is 175, my lord. Accordingly, while not interfering with the impugned order, the matter is disposed of, reserving liberty to the petitioner to take recourse to placing his rights in the final degree proceeding by way of appropriate application under order 21 rules 97 to 101 of CPC, and same may be considered as is permissible under law.
ಇದೇನು? What is that order you are challenging in this?
I am as a objector, I am challenging the order dated 1/10/2024.
Application seeking to impede the respondent in the final degree proceeding.
I may be pleaded as objector, then there may be a demarcation of the.
Now you have filed an application for objector. Before that only the commissioner has been appointed.
Please, my lord. Please, my lord.
Then you can challenge the commissioner report to give an opportunity for you.
But my submission before this honorable court, with respect, my lord, court commissioner has not visited the spot. That being the fact.
When is that appointment of the court commissioner?
1/10/2024, page number 27, annexure A, my lord. Relevant page is annexure to page number 28. Last 4 paras, I read, once again I will read, my lord.
No, you are not challenging that appointment of the court commissioner.
But at the time of visit of the court commission to the spot, item number
No.
21.
You have not challenged that appointment of the court commissioner in this prayer.
My lord, I have, in my IA,
No, in this prayer, you are not challenging that.
my lord, page number 31 to 35 is IA number 8, page number 35 is IA number.
No, you come to that prayer in this writ petition.
Please, my lord, please, my lord, please, my lord.
There is no prayer for
Annexure
parting
A,
that appointment of the order of that commissioner, Mr.
Annexure A is the appointment, order of the court below.
Annexure?
My interim prayer I prayed pending disposal of.
This prayer, main prayer, you see that.
Please, my lord, in FDP number dated 27 to, please, I have not challenged order dated 1/10/2024, my lord.
Then even if it is petition is allowed, that appointment of the commissioner will not go.
No, I am not challenging, my lord, because my presence is very important, at most important, at the time of the demarcation of the property, and also I am in possession of the property. On the basis of the IA under order 21, rule to 97 to 101, I may be permitted to be present at the time of.
Who is restricted? You go and present on behalf of your owner.
But my applications are not.
No, you are not, application is pending.
Please, my lord.
But to participated in that commissioner proceedings as your vendor, on behalf of your vendor, you can present that.
But I may be having say, my lord, that being the.
But thing is that you are not challenged that appointment of the commissioner.
As a prayer, I have not challenged, but
Then how
as
can
a
you get
interim
that?
relief, I sought before this honorable court with respect to.
What is that relief you have sought? You seeking for a stay of that order.
No, until disposal of IAS number 8 and 9, my lord.
That we can direct that,
Please, my lord.
dispose of that.
Please, my lord.
Yes.
Please, my lord.
What is the next date?
Next date is 29/3, my lord.
29?
3.
IA hence objection to IA 29/3 na?
29/3, my lord.
Yes. I will direct it to dispose of that application by end of April itself.
Please, my lord.
Yes, at the
Please.
time, let them file an appeal.
Till then.
Yes. In this writ petition. I will direct to dispose of within that end of April, Mr.
Please, my lord.
Yes. In this writ petition, even though petitioners challenging that order dated 27/2/2025, counsel for the petitioner submits that he will restrict his prayer only, directing the trial court to consider application filed by that petitioner, IA number 8 under order 21, rule 97 of CPC,
And IA number 9.
and IA number 9, 151 of CPC as expeditiously as
Please.
possible. In view of the above prayer, the notice to the respondent is not necessary.
Please.
The same is dispensed. Suit for partition, huh?
Suit for partition, my lord.
Who has filed that? Who is the plaintiff?
Plaintiff is one Chikka Muniswamy.
Our
Son of
resp-
Narasimhappa.
Here is the respondent.
Please, my lord.
Which respondent?
He is no more, his legal representatives are,
Who is his legal representative?
in, my lord.
Respondent herein, I filed a suit for partition. The suit came to be decreed. Who has challenged that in appeal?
Appeal, Dodda Muniswamappa,
One of the family member.
one of the family members
One of the family members,
and others.
one of the parties in the suit has filed an. Yenaito RA?
RA confirmed the decree.
Yes. Filed an RA number 65 of 2016. The same came to be dismissed and confirmed that.
Confirmed, my lord.
Yes, same came to be dismissed and confirmed that judgment and degree passed by the trial court in OS number 186 of 2007. On the basis of the preliminary degree dated 26 September 2015, passed in OS number 186 of 2007. The parties has filed a final degree proceedings in FTP number 2 of 2024. In the meantime, petitioner herein has purchased that.
Please.
Which property you have purchased?
Item number 21, 25.08 Gunta.
Item number 21 of suit scheduled property. Since he is interested in the said property, he has filed an application IA number 8 and 9 under section order 21 rule 97.
101.
Yes. The same is pending consideration. So far, no order has been passed. Therefore, he sought for early disposal of that application. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of the IA number 8 and 9 filed by the petitioner objector as expeditiously as possible, not later than end of April 2024. Yes, 2025.
My lord, till then,
Till then I can't, because I have dispensed the notice.
please, ma'am.
In the meantime, you go and file in a memo there that till my application is allowed, commissioner cannot be, because I may be denied my rights. Because I have dispensed that notice, I can't give any positive relief to you without that hearing other side.
Please, my lord, but what happens, the opportunity?
You go and file an application before that same court, saying that till my application is disposed of, that the commissioner cannot be draw that report.
Precipitative action.
No, if I grant any this thing, then I have to issue a notice to the party. No positive direction can be issued without issuing the parties. Only mandamus it is for the court I disposed of.
Please, my lord, but only thing is.
Then I will issue notice.
Please,
Take-
my lord.
I'll
Please,
take
my
it.
lord.
You take hand summons.
Please, my lord.
Yes. Heard issue notice. Respondent is directed, petitioner is directed to take out hand summons to the respondent. Post this matter on 28th.
Please, my
In the
lord.
meantime, you take hand summons and
Please, my lord.
yes.
Interim or.
Bill number 6.
No, you take hand summons, we'll dispose of that.
Please,
Because
my-
you are not sought for challenging that
Please,
commissioner
my
report.
lord. Please, my lord. I understand.
No interim order can be granted. Therefore, I said, you get them and I will dispose of them. Yes. In the presence, I can say that till disposing of that application, commissioner cannot be draw that report.
Please, my lord, it may post it on Monday, my lord.
No, you have to take hand summons.
Please.
29th, 28th.
28th.
Yes, you have to take hand summons today itself, mister.
Please, my lord.
Hand summons ಗೆ 10 ದಿನ time ಕೊಡ್ತಾರೆ.
Please, my lord.
Yes.
Bill number 6, Vijay Kumar T.
Yes.
To be permitted to appear on behalf of petitioner, my lord.
Yes.
My lord, the respondents herein, my lord, plaintiff before the trial court.
Yes.
Have a suit filed for, my lord, injunction, bare injunction, my lord.
Yes.
Along with the suit, they have filed suit, my lord, temporary injunction application.
Yes.
It is their claim that, my lord, the suit schedule property, which is site, my lord, they have acquired through their ancestor, that is from their father, my lord.
Yes.
And they have partitioned there is a partition in the family and they have got property, my lord.
Yes.
My lord, it is a specific case of the defendant that, my lord,
Hmm.
the father of the plaintiffs have sold, my lord, the suit schedule property in favor of the, my lord, the defendant mother-in-law, my lord. And under the our family ಒಳಗೆ it has come into the husband ಬಂತು husband ಸತ್ತೋದ್ರು ಈಗ in respect of defendant now suit schedule property. My lord, kindly come to annexure D, my lord, sale deed dated.
Now, where is the plaint?
My lord, plaintiff is annexure A, my lord. ಅವರು ಇದನ್ನ ಸಪ್ರೇಸ್ ಮಾರಾಟ ಮಾಡಿರೋದನ್ನ ಸಪ್ರೇಸ್ ಮಾಡಿ their father has sold the, my lord, this property to
This suit is for
bare injunction.
injunction.
It's only for bare injunction.
Yes.
Yes, my lord.
Who are you?
My lord, I am the defendant before the trial court.
Hmm.
I claim that, my lord, the father of the plaintiff has sold the suicidal property in favor of my mother-in-law.
Hmm.
And my mother, father of the prisoners.
No, you come to that annexure A plaint. Who has sold this property to you?
ಇವರು plaintiff for ತಂದೆ ಸಿದ್ಲಿಂಗಪ್ಪ.
Sidlingappa has sold a property to you. When?
ಅದು ಯಾರು ಸ್ವಂತ ತಂಗಿಗೆ ಕೊಡೋದು. ಸ್ವಂತ ತಂಗಿಗೆ ಕೊಡೋದು.
No, when?
ಅವರು ನಮ್ಮ ಅತ್ತೆ. ಅದು
No, I am asking when he has sold.
19 ಸೇಲ್ ಡೀಡ್ ಮೇಲಾಡ್ ಅನಕ್ಷರ್ ಡಿ ಮೇಲಾಡ್ 11/10/1979
11/10.
1979
79.
Hmm.
A register sale deed.
ರಿಜಿಸ್ಟರ್ ಸೇಲ್ ಡೀಡ್
Hmm.
ಅದು ಅನಕ್ಷರ್ ಡಿ ಮೇಲಾಡ್ ಪೇಜ್ ನಂಬರ್ 33 ನಲ್ಲಿ ಇದೆ.
ಆಯ್ತು, ಈಗೇನಾಯ್ತು ಈಗ?
ಈಗ ಇದ್ರಲ್ಲಿ ಕೊಡ್ತಾರೆ, ಇದ್ರ ಪ್ರಕಾರ ನೆಕ್ಸ್ಟ್ ಬನ್ನಿ ಸ್ವಾಮಿ, ಖಾತೆನೂ ಆಗಿದೆ ನನಗೆ.
ಹ್ಮ್.
ಇದ್ರಲ್ಲೆಲ್ಲ ಪಂಚಾಯತಿಲೆಲ್ಲ ಖಾತೆನೂ ಆಗಿದೆ,
ಹ್ಮ್.
ಈ ಖಾತಾನೂ ಆಗಿದೆ.
ಹ್ಮ್.
ಈಗ ಇವ್ರು ಏನಂತ ಹೇಳ್ತಿದಾರೆ ಅಂದ್ರೆ, ಆ ಶೆಡ್ಯೂಲ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಈ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ನಾವು ಕೊಟ್ಟಿದ್ದೆ ಅಂತ ಬರ್ದಿರ್ಲಿಲ್ಲ ಅಲ್ಲಿ. ಈಗ ಇವರು ಸರ್ವೆ ನಂಬರ್ 1 ನಮ್ದು ಇದು ಅಂತ ದಟ್ ಈಸ್ ದೇರ್ ಕ್ಲೈಮ್. ಎಂಟೈರ್ ಸರ್ವೆ ನಂಬರ್ ಅದು ಟೋಟಲ್ 7
ಅಲ್ಲ ಆಯ್ತು, ಈಗ ಸೂಟ್ ಫಾರ್ ಇಂಜೆಕ್ಷನ್ ಹಾಕಿದ್ರಿ, ನಿಮ್ದು ಏನ್ ಇದ್ರಲ್ಲಿ? ವಾಟ್ ಇಸ್ ಯುವರ್?
ನನ್ನ ಪ್ರಾಪರ್ಟಿಗೆ ನಾವು ಸಾಟ್ ಫಾರ್ ಇಂಜೆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ಮೈ ಪ್ರಾಪರ್ಟಿ.
ಇಂಜೆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ whom?
ಡಿಫೆನೆಂಟ್ಸ್. ನಾನು ಮನೆ ಕಟ್ತಾ ಇದ್ದೀನಿ. ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ಫೋಟೋಗ್ರಾಫ್, ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ಸೇಲ್ ಡೀಡ್.
ಯು ಆರ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ ದೇರ್.
ಎಲ್ಲಿ? ನಾನೇ ಪಾರ್ಟಿ ಇದ್ದೆ, ನಾನೇ ಪಾರ್ಟಿ, ನಾನೇ ಡಿಫೆಂಡೆಂಟ್ ಇಲ್ಲಿ ನಾಗರತ್ನ.
ನಿಮ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ?
ಹೌದು, ನಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದೆ.
ಇಂಜೆಕ್ಷನ್.
ಹೌದು.
ಅದಕ್ಕೇನು? ವಾಟ್ ಇಸ್ ದಟ್ ನೌ ಯುವರ್?
ನಾವು ಮೇಲೆ ಬೋತ್ ದಿ ಕೋರ್ಟ್ಸ್ ಮೇಲೆ ಗ್ರಾಂಟೆಡ್ ಇಂಜೆಕ್ಷನ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ಆ ಪ್ರಾಪರ್ಟಿನೇ ಬೇರೆ, ಈ ಪ್ರಾಪರ್ಟಿನೇ ಬೇರೆ ಅಂತ.
ವೇರ್ ಇಸ್ ದಟ್ ಆರ್ಡರ್?
ಮೇಲಾಡ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಮೇಲಾಡ್ ಪೇಜ್ ನಂಬರ್ ಮೇಲಾಡ್ ಅನಕ್ಷರ್ ಜಿ.
ವಾಟ್ ಇಸ್ ದಟ್ ಇಂಜೆಕ್ಷನ್ they have sought?
ಅವರು ನಾಟ್ ಟು ಇಂಟರ್ಫಿಯರ್ ಅಂತ.
Not to interfere.
ನಾಟ್ ಟು ಪುಟ್ ಅಪ್ ಎನಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ.
Now that where is the suit scheduled property?
ಮೇಲಾಡ್ ಅವರು ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅನಕ್ಷರ್ ಏನಲ್ಲಿ ಬಂದಿದೆ.
Yes. Where is that sale deed?
ಸೇಲ್ ಡೀಡ್ ಅನಕ್ಷರ್ ಡಿ ಮೇಲಾಡ್
Annexure?
ಡಿ.
What is that?
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಇವರು ಎಂಟೈರ್ ಈ ಸರ್ವೆ ನಂಬರ್ 1/1 ನಲ್ಲಿರೋ ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡ್ತಾರೆ ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ. ನನ್ನ ಇದ್ರಲ್ಲಿ ಬರೀ 3 ಗುಂಟಾಸ್ ಅಷ್ಟೇನೆ.
You have a boundary in that sale deed. Where is that boundary, Mr.?
ಬೌಂಡ್ರಿ ಇಲ್ಲಿ ಟೈಪ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ತಪ್ಪಾಗಿದೆ. ಮೇಲಾಡ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ನನ್ನ ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 8 ಬಂದ್ರೆ ನಾನು ಎರಡನ್ನೂ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡಿದ್ದೀನಿ. ಪೇಜ್ ನಂಬರ್ 8 ಆಫ್ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಬಂದ್ರೆ 2 ಬೌಂಡ್ರೀಸು ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡಿದ್ದೀನಿ. 2 ಬೌಂಡ್ರಿ ಟ್ಯಾಲಿ ಆಗುತ್ತೆ ಅವ್ರಿಗೂ ನಮ್ಗೂ. ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಸರ್ವೆ ನಂಬರ್ 1 ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಅವರು. ನಾವ್ ಹೇಳ್ತಿರೋದು ಸರ್ವೆ ನಂಬರ್ 1 ಅಲ್ಲೇ ನಮಗೆ ಪೋರ್ಷನ್ ಆಫ್ ಲ್ಯಾಂಡ್ ನಮ್ಗೆ.
Wherever the survey number, Mr. Boundary is prevails. Boundary cannot go to that survey number 1 and 2.
2 ಬೌಂಡ್ರಿ ಈಗ ಟ್ಯಾಲಿ ಆಗುತ್ತೆ ಅವ್ರಿಗೂ.
Where is that boundary?
ಮೇಲಾಡ್ ಪೇಜ್ ನಂಬರ್ 8 ಬಂದ್ರೆ ಎರಡನ್ನೂ ನಾವು ಇದು ಮಾಡಿದೀವಿ. ಅವರು ಈಸ್ಟ್ ಬೈ ಸಿದ್ಧಲಿಂಗ ಸ್ವಾಮಿ ಅವ್ರ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಪ್ರಕಾರ ಮೂಗಮ್ಮಸ್ ಪ್ರಾಪರ್ಟಿ, ವೆಸ್ಟ್ ಬೈ ಬಸವರಾಜು ಅರುಣ್ಸ್ ಪ್ರಾಪರ್ಟಿ, ನಾರ್ತ್ ಬೈ ಅನ್ನಪೂರ್ಣ ಪ್ರಾಪರ್ಟಿ, ಸೌತ್ ಬೈ ಸರ್ಕಾರಿ ಹಳ್ಳ ಅಂತಿದೆ. ನಮ್ದು ಯಡಿಯೂರಪ್ಪ ತಿಮ್ಮಯ್ಯಪ್ಪಸ್ ಪ್ರಾಪರ್ಟಿ. ಈಗ ಇದೇನಾಗಿದೆ, ಇದು ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿರೋ ಪ್ರಾಪರ್ಟಿ. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿದ್ದು 79 ಅಲ್ಲಿ. ಈಗ ಸ್ವಲ್ಪ ಅದು ಚೇಂಜ್ ಆಗಿದೆ ಶೆಡ್ಯೂಲ್, ಯಾಕಂದ್ರೆ ಅವರು ಬೇರೆಯವ್ರು ಮಾರಿದ್ದಾರೆ, ಬೇರೆಯವ್ರು ಮಾರಿದ್ದಾರೆ. ಈಗ ಇದೇನ್ ಹೇಳ್ತಾರೆ ಅವ್ರಿಗೆ ಅದೇ ಇದಕ್ ಬರುತ್ತೆ.
ಬಸವರಾಜಪ್ಪ ನಿಂಗಪ್ಪ ಗವರ್ಮೆಂಟ್ ರೋಡ್. Entire this thing is different, Mr.
ಅಲ್ಲ ಇಲ್ಲಿ ಒಂದೇ ಒಂದು ನಾರ್ತ್ ಬೈ ತಪ್ಪಾಕಿದೀವಿ. ಇದು ನಿಂಗಪ್ಪಸ್ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ, ಅನ್ನಪೂರ್ಣಮ್ಮ ಪ್ರಾಪರ್ಟಿ. ಅದು
ಎಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ತೋರ್ಸ್ರಿ.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಒಂದೇ ನಿಮಿಷ, ಪೇಜ್ ನಂಬರ್ 34 ಬನ್ನಿ ಸರ್.
ನಿಂಗಪ್ಪ ಜಮೀನು
ಪೂರ್ವಕ್ಕೆ ಯಡಿಯೂರಪ್ಪ,
ಉತ್ತರಕ್ಕೆ ನಿಂಗಪ್ಪ ಜಮೀನು ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ?
ಉತ್ತರಕ್ಕೆ ನಿಂಗಪ್ಪ ಜಮೀನು,
ಮತ್ತೆ
ದಕ್ಷಿಣಕ್ಕೆ ಸರ್ಕಾರಿ ರಸ್ತೆ. ಇದಾದ್ಮೇಲೆ ನಮ್ಗೆ ಈ ಖಾತಾ ಮಾಡ್ಬೇಕಾದ್ರೆ ಶೆಡ್ಯೂಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಒಂದೇ ನಿಮಿಷ ತೆಗಿತೀನಿ ನಾನು. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು
ಶೆಡ್ಯೂಲ್ಡ್ ಅಲ್ಲ, ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಿದೆ?
ಅಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಅದು 79 ಅಲ್ವಾ, ಆಮೇಲೆ ಚೇಂಜ್ ಆಗಿದೆ ಬರ್ತಾ. ಈಗ ಎಕ್ಸಿಬಿಟ್ D5 ಬಂದ್ರೆ ಟೈಪ್ಡ್ ಕಾಪಿಗೆ ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಇದೆ. ಟೈಪ್ಡ್ ಕಾಪಿ ಪೇಜ್ ನಂಬರ್ 56 ಬಂದ್ರೆ ಅಲ್ಲೂ ಚೆಕ್ ಬಂದಿ ಅಂತ ಅಲ್ಲಿದೆ. ಯಡಿಯೂರಪ್ಪನವರು, ಬಸವರಾಜಪ್ಪ, ನಿಂಗಪ್ಪ ಅವರು ಶೆಡ್ಯೂಲ್ ಅಂತೂ ತಪ್ಪು ಕೊಟ್ಟಿದ್ದಾರೆ. ದಿ ಓನ್ಲಿ ನನ್ನ ಗ್ರಿವೆನ್ಸ್ ಏನು ಅಂತಂದ್ರೆ, ನಾನು ಕಟ್ತಾ ಇರೋ ಮನೆಗೆ ದೇ ಶುಡ್ ನಾಟ್ ಬಿ ಎನಿ
No, if you are constructing that house in their property, what can they do, Mr.?
No, my lord. They contend that their property survey number 1. Their objection itself, my lord, kindly come to my lord.
See, now boundary will prevail. Survey number may be wrong.
ಅದಲ್ಲ, ಒಂದೇ ಒಂದು
boundary will not be.
ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ. ಅದಕ್ಕೆ ಅನಕ್ಷರ್ ಜೆ ಪೇಜ್ ನಂಬರ್ 102 ಬನ್ನಿ. ಅವರೇ ಕೊಟ್ಟಿರೋ ಅಬ್ಜೆಕ್ಷನ್.
Yes, you maintain status.
ಚಂದ್ರಶೇಖರ್.
Yes.
ಅಲ್ಲಲ್ಲ, ಅದು ನಮ್ಮ
boundary is not telling, Mr. If you are constructing that house in that somebody's property, that is what.
ಅಲ್ಲಲ್ಲ, ಅವರು ನಮ್ ಸ್ವಂತ ರಿಲೇಷನ್, ಸ್ವಂತ ಇದು
ಆದ್ರೆ ಏನಂತೆ ಪ್ರಾಪರ್ಟಿ.
ಅಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ ಅನಕ್ಷರ್ ಜೇಗ್ ಬನ್ನಿ 102ಗೆ. ಅವರು ನಮ್ಗೆ ಈ ಖಾತಾ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾರು ಪ್ಲೇಂಟಿಫ್, ಒನ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್ ಚಂದ್ರಶೇಖರ್ ಏನಿದ್ದಾರೆ, ಇವರು ಥರ್ಡ್ ಪ್ಲೇಂಟಿಫ್ ಇದ್ದಾರೆ. ಇವ್ರು ಕೊಡ್ತಾರೆ ನೋಡಿ, ಸರಗೂರು
ಫೋಟೋಗ್ರಾಫ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಲ್ಲ ಏನು?
ಇದೆ ಕೆ ಬೇಡ, ನಾನು ಆಲ್ರೆಡಿ ಕಟ್ಟಿದ್ದೀನಿ. ಹಳೆ ನಂದು 206 ಕೈಂಡ್ಲಿ 106 ಸಾರಿ ಮೇಡಮ್. ಆಮೇಲೆ ನಾನು ಅಫಿಡೇವಿಟ್ ಹಾಕಿದ್ದೀನಿ. ಈ ತರ ಶೆಡ್ ಇತ್ತು ಫಸ್ಟ್ ಅರ್ಲಿಯರ್ ಆಗಿ 106. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಇಲ್ಲಿ ಕಟ್ತಾ ಇರೋದು ಇದು.
Learned counsel for the petitioner submits that petitioner is already putting up in a construction in that suit scheduled property is construction in that half year. In view of the above, the petitioner is permitted to put up a construction and he has to, subject to condition that he has to file an affidavit.
Already filed a affidavit before the trial court.
And he has subject to condition that in case if he
Page
fails,
number 127.
he should not claim any equity.
ಬಿಲ್ಡಿಂಗ್ ಸಮೇತ ಕೊಡ್ತೀನಿ ಅಂತಾನೆ ಬರ್ಕೊಟ್ಟಿದ್ದೀನಿ, ಹೊಡೆದಾಕ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ ಅಂತ.
Yes.
127. Page number 127 annexure N.
Subject to that condition, yes. Should not claim any equity. Permitted to put up construction, subject to condition that he should not claim any equity in case if he fails.
Bill number 7, Vivek case.
Yes.
Plaintiff's writ petition, my lords, suit for permanent injunction. So plaintiff had filed an application under Order 6 Rule 17 seeking amendment of pleadings, my lords. By way of amendment, he sought to incorporate 2 additional prayers, my lords, seeking relief of declaration and further in
No,
case
that suit for
permanent injunction, my lords.
Now, what is that order you are challenging?
Application under Order 6 Rule 17 seeking amendment of plaint, my lords, was rejected by trial court, my lords. So the annexure A, page number
Your
13,
application and order?
Order 6 Rule 17, my lords. So it came to be rejected, my lords. It's at annexure A, page number 13.
Then your application is rejected, then you have to file in a CRP.
A writ petition is maintainable, my lords.
Okay.
Application to Order 6 Rule 17, my lords, seeking amendment.
Order 6 Rule 17, if that application is allowed, suit has to be dismissed. Then we see that under.
So the application is rejected, my lords. Application seeking amendment of pleading was rejected, my lords, against which I have preferred this application.
No, amendment you have sought for, not rejection of the plaint, Mr.
Not rejection of.
Amendment, Order
Sought
6
for
Rule
amendment.
17. Yes.
By virtue of the proposed amendment.
What is that amendment you have sought?
Sought for additional prayer, my lords, seeking relief of declaration and possession, my lords.
No, earlier,
Earlier, it's a suit for permanent injunction, my lords. During
why
the-
that objection has been dismissed? I read that whether
It was filed belatedly, my
proposed
lords.
amendment constitutes fundamental change of the nature of the above ratio.
Findings are on page number 26 and 27, my lords.
Need to cause a prejudice to the other side. In OS number 112 of 2014, pending in the file of civil judge JMFC at Koratagere till next date of hearing.
Bill number 8, Leelesh Krishna.
I am the defendant number 1 in the trial court, my lord. The plaintiff is none other than my brother-in-law. Just after 1 month of the death of my husband, brother-in-law files a case against me and his siblings. I am or what? My lord, it is in the nature of probate, but not probate, my lord. The prayer, my lord.
Where is the suit, Mr.?
Prayer is at page number 23 in the page number 23 prayer is my lord. Suited.
What is that prayer?
My lord, prayer is to declare that he is the absolute owner of the scheduled property, which he says that it has been bequeathed by my husband in his name. And also says that he is entitled to 10% of all the deposits in the policies and bank accounts, my lord.
Yes.
Yes, my lord.
Now, what is that order you are challenging?
My lord, he filed an IA number 2, to restrain me from withdrawing any amount from the bank accounts and policies ಯಾವುದೇ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಇಂದ ಅಥವಾ ಪಾಲಿಸೀಸ್ ಇಂದ ಅಮೌಂಟ್ ವಿಡ್ರಾ ಮಾಡಬಾರ್ದಂತ he's filed an application under order 39 rule 1 and 2. The trial court, my lord, in terms of the order, it partly allowed directing me, telling that you do not, you withdraw 50% of the amount and deposit it in the court, and the court will deposit it in a nationalized bank. And if a suit is in your favor, we will withdraw it and give it to you. If it is in their favor, they are entitled to 50% of the amount.
No, that, who is that petitioner? Plaintiff?
Plaintiff is my brother-in-law, my husband's brother.
Your husband, brother.
Yes, my lord.
Now, he has filed in a suit
Yes, my lord.
in respect of share in that your husband's policy.
He is filed suit telling that as per the will, husband has left a will according to him, which I have disputed. And according to the will, he has husband ಗೆ 2010 ನಲ್ಲಿ family partition ಅಲ್ಲಿ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಬಂದಿರುತ್ತೆ. That property in entirety, he says that it is bequeathed to him. And he is entitled to the amounts in the 10% of the amount. 10% of the entire amount in the bank accounts and the policies, he is entitled to ಅಂತ ಸೂಟ್ ಹಾಕಿರೋದು 10%.
10% ಗೆ ಮಾಡೋದ್ಬಿಟ್ಟು 100% ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ?
100% ಮಾಡಲಿಲ್ಲ, 50% ಮಾಡಿದ್ದಾರೆ. According to him, his other siblings are entitled to 40%, he is entitled to 10%, and I am entitled to 50%. So the court directed, it is his application, my lord, his application.
Now, where is that order?
My lord, order. Trial court order, my lord, page number 48. Operative portion.
Yes.
In the result, defendant number 1 is directed to withdraw 50% of the savings made by Gopal Krishna Bhatt in the bank accounts as well as policies and deposit the same before the court, so that the amount shall be deposited by the court in nationalized bank in short-term deposit, and the same will be accrued interest shall be made available to the successful party in the suit.
Now, why 50%?
Yes, my lord. Why?
See, that 50%.
Yes.
Remaining 50% can be kept it there in that.
Yes.
Why court has said you withdraw 50% and deposit here?
My lord, court's logic is that he and his siblings are entirely entitled to 50%. ಆ 50% ಅನ್ನು withdraw ಮಾಡಿ ಕೋರ್ಟಿಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅಂತ. You do whatever with your 50%. ಆ 50% ಅನ್ನು withdraw ಮಾಡಿ ಕೋರ್ಟಿಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅಂತ. Now, my lord, the issue is the court, neither them nor the court knows what is the amount in my this thing. And even as per the will, my lord, which I have disputed, a bill alli, it is only
now whether that will is fabricated or will is correct or not has to be decided.
Yes, ma'am.
Even if the will is decided, 50% of that amount will goes to that plaintiff. You will entitle for only 50.
Plaintiff only 10%, my lord. Only 10%.
What about that others?
They have not claimed. They did not come to court and ask for that money. It is only plaintiff who has come. So even if worst scenario, my lord, only 10% could have been directed.
Yes.
Not 50%. But even in that, my lord, I wish to take your lordships to the will. While I am disputing the will, the averment in the
disputing and all has to be decided.
Yes, ಯಾಕಂತ ಹೇಳಿದ್ರೆ, why I am saying, my lord, ಅದು 78 page number ಅಲ್ಲಿ ಇದೆ will, second paragraph. Will only mentions about the fixed deposits. He does not say fixed deposits or any deposit. And the will does not mention about the policies at all. Even ಇವ್ರದ್ದು ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಪಾಲಿಸೀಸ್ ಇದು ಕೊಡಬೇಕು, ಸೇವಿಂಗ್ಸ್ ಬ್ಯಾಂಕ್ ಇದು ಕೊಡಬೇಕು, ಎಲ್ಲದೂ ಕೊಡಬೇಕು. It cannot be so, my lord. MA ಅಲ್ಲಿ court records that he does not say whether it is savings bank or current account or what account. I cannot be made to such unreasonable.
What is that in appeal also? What the appellate court did?
Appellate court is order, my lord, is at page number 75 ಅಲ್ಲಿ ಇದೆ. It has just simply upheld the order of the trial court. 75. The order passed in OS number so and so, dated so and so, is hereby 10%. Secondly, in his application, he does not mention whether it is current account, savings account, what account, fixed deposits. As per the will, it is
to withdraw that 50% of the saving made by that Gopal Krishna. But in that, only 50% is permitted to withdraw. What is that meaning, Mr.
Yes, makes no sense.
Yes. Yes, 30. I would issue notice. Stay of order dated 11/11/2024 and 2024. Passed by
22/4/2024.
Passed by that additional district and session judge Shimoga in MA number so and so, and IA order passed by Principal Senior Civil Judge JMFC Sagar in OS number 9 of 2024 on IA on so and so date is state. Yes.
Serial number 9.
Great.
Lokesh
Declaring
Malawadi.
liberty to that respondents to file an application for modification or vacating that interim order.
Serial number 9.
My lord, appellate order 11/11/2024, my lord.
Yes.
Yes, great.
Yes, Mr. Bhatt.
Freeholders, writ petition, my lord.
Yes.
There is mistake in the calculation. Balance amount calculation ಮಾಡಬೇಕಾಗಿತ್ತು ಅದನ್ನ ಬಿಟ್ಟು ಮಾಡಿದ್ದಾರೆ. That is wrong. Connected matter ನಲ್ಲಿ notice and further proceedings has been stayed by the Honorable Court. We do that.
Yes. Or issue notice. Stay of further proceedings in execution number 1070 of 2011 pending on the file of second additional city civil session judge Bangalore till next date of hearing.
Serial number 10. Raghunath MD for petitioner VP Shivakumar.
I appear for the petitioner, my lords.
Yes.
In fact, on the last occasion, my lords had directed the respondents to produce documents to showcase fragmentation of property number 22, my lords.
Yes.
And they had to produce the document before my lords.
Yes. Yes, what is this matter?
My lords, this was a suit for eviction and arrears of rent.
Hmm.
It was based on the application filed for framing of additional issues, my lord, which was dismissed by the Honorable Trial Court.
Yes.
I had filed a review application, which was again dismissed. And that has been challenged. Both the orders have been challenged before my lords.
Yes.
And upon my lords perusing the documents, my lord, my lords had directed the respondent to furnish a document showcasing that the number 22 property has been fragmented and bifurcated into 22 A, B, C, D, E. And the respondent had to submit the same.
Sir, you have filed that document. Got the documents. You serve a copy to him. Want to go through, we'll have it tomorrow or day after tomorrow.
My lords, the matter is today, my lords.
Today
in
for
the
what?
Honorable Trial Court. One aspect is for orders, my lords, and the other one is for hearing.
No, we'll
Therefore-
have it tomorrow. Yes.
At least stay may be granted till then, my lord.
Let's stay.
In fact, stay of the proceedings, my lord. The
No, no,
Honorable
what will
Trial Court
happen?
is,
No, what is that? Why it is?
Some interlocutory orders are being.
That is there, nothing will
Yes.
happen.
and my learned friend has not been
No,
trying to
if you
complete,
want,
my
if
lords.
you don't want to look into that records,
I do, definitely, my lords,
Have-
definitely.
day after tomorrow, yes.
My lords could kindly see the table which I have given.
No, let him also go through and it can easy for,
What's the problem?
yes, day after tomorrow.
At least my lords may direct the Honorable Trial Court also at the same time to hear it on the day after tomorrow.
What is happening there? There
In
is only
fact, there
application.
are two aspects, my lords. One, there is an application filed by impleading applicants. This is posted for orders. And my application for production of documents, my lords, wherein I had showcased my lords with respect to those documents,
No.
city records.
Production of documents, let them hear and pass an order. This is only for additional issue.
Yes,
That
my
will be-
lords.
That will be there.
But it has an interconnected bearing, my lord. That is the only humble
Park
submission.
that I will hear today, yes. If
Please,
you are
my
ready.
lord.
Yes. Yes.
In the list which I have given.
No, you just give that brief facts.
Yes, my lords.
Yes.
In fact, if I may bring to my lord's attention to ink page number 15. Ink page number 15, my lords, is annexure A, the plaint filed by the respondent
Yes,
at para number 6, my lords,
yes.
wherein they themselves claim that the revenue extract issued from the office of the BBMP for the year 1/4/2000 to
Where you are
21/9/2004.
reading page number 15.
Yes, my lords, 1/5.
Yes,
Para number 6, my lords.
yes.
The third line says, in column number 7, in the name of the owner is mentioned as Abdul Karim Sahib, which is incorrect. Therefore, after noticing the incorrect name entered, the plaintiff filed an application on 23/1/2015 under provisions of the Municipality Act, and so and so filed a writ petition on the same, my lords. This subsequent para, my lords, may kindly peruse. Para number 7. The defendant willfully and with oblique motive had undertaken undue advantage and the mischievous attitude of the corporation authorities. Apart from the revenue authorities, the BBMP has started litigation and also tried to claim over the property by intentionally providing wrong identification when the properties are appropriate on the basis of the title documents of the title and possession of the property. Therefore, I filed my written statement, which is at ink page number 26, months, Annexure B.
A little more.
At that point of time, I had taken a specific contention at, in para number 2, my lords.
Yes.
The averments made in para number 2 of the plaintiff is the little owner, actually it should be no title owner of the premises. He is hereby denied by the defendant, and the plaintiff is not the owner of the scheduled shop. In fact, the scheduled property originally stands in the name of the temple called Sri Nagareshwara Kanika Parmeshwari Temple, though the plaintiff is not the owner of the scheduled property, further the defendant's great grandfather, and so on, so on, so.
Yeah.
For that, the Honorable Trial Court at ink page number 37, my lords, had framed the following issues, which is at Annexure B1. 37, my lords.
Yes.
Additionally, 3 issues were framed, my lords. Whether the plaintiff proves that the defendant became defaulter in payment of agreed rents as per lease agreement dated 2011-2012, and thereby due a sum of rupees 16,51,600 towards arrears of rent to the plaintiff. 2, whether the plaintiff further proves that he is entitled to recover vacant possession of the suit schedule A and B commercial premises from the defendant. What order, what decree means. Therefore, I had filed at the subsequent page, at ink page number 38, an application for framing of additional issues, my lords.
Yes.
The additional issue being 3, my lords, whether the plaintiff proves to this honorable court that the plaintiff is the absolute owner of the suit schedule property. Ink page number 38, 38, my lords, Annexure C. The first additional issue, my lords.
Yes.
Whether the plaintiff proves to this honorable court that the plaintiff is the absolute owner of the suit schedule property. 2, whether the plaintiff proves that to this honorable court that he is empowered to file the above suit on behalf of Sri Nagareshwara Sri Kanyaka Parmeshwari Temple. And 3, whether the plaintiff has locus standi to institute the suit, my lords.
Yes.
Unfortunately, my applications came to be dismissed, my lords.
Yes.
I filed a review application that also came to be dismissed, which I came before, my lords, challenging the same. On the 10th of March 2025, my lords, I filed a memo before my lords.
Yes.
On the 10th of March 2025, my lords, I filed a memo.
Yes.
In that memo, my lords may kindly peruse 3 main documents, my lord. 10th of March 2025.
Yes.
These are the documents, my lord, wherein the plaintiff, who's the respondent before my lords, had furnished the said documents before the Honorable Trial Court, and the same were marked, my lords. Wherein the first document which I'm trying to showcase to my lords is at ink page number 10. This is the sale deed dated 23/2/1931, my lords. Ink page number 10, my lords.
Yes.
ಅಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಬೆಂಗಳೂರು ಸಿವಿಲ್ ಅಂಡ್ ಮಿಲಿಟರಿ ಸ್ಟೇಷನ್ ನಂಬರ್ 4A ಜ್ಯುವೆಲರ್ ಸ್ಟ್ರೀಟ್ಗೆ ಪಶ್ಚಿಮಕ್ಕೆ ಭಾಗದಲ್ಲೂ ಪೂರ್ವಕ್ಕೆ ಸದರಿ ಜ್ಯುವೆಲರ್ ಸ್ಟ್ರೀಟ್, ಪಶ್ಚಿಮಕ್ಕೆ ನನ್ನ ಸ್ವಂತ ಮಂಡಿಗಳು, ಉತ್ತರಕ್ಕೆ ಕನ್ಯಕಾ ಪರಮೇಶ್ವರಿ ಸ್ವಾಮಿ ದೇವಾಲಯದ ಪ್ರಾಪರ್ಟಿಗಳು. That is clearly mentioned, my lord, that the properties are of the temple.
Yes.
This is one.
That is
Second,
not
my lord, may
correct.
kindly peruse.
But I oppose
is-
this submission.
Allah, you'll have your chance, sir.
Please, sir, please,
Let me make my submission.
please read what it is said. He has said on the northern side is temple property.
Yes, you can answer after that.
That clarification must be given.
Yes.
Every time, my lord,
You
this is
have
what is
chance.
being said by him.
Yes.
Please. Subsequently, my lords may kindly peruse ink page number 13 in the same set of document.
Yes.
This is the property tax paid receipt.
Yes.
In the property tax paid receipt, my lords may kindly peruse 22 Jeweler Street, Shivaji Nagar, Bangalore. It belongs to temple property.
ಎಲ್ಲಿದೆ temple?
ಅಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ.
Yes, temple property.
Yes. Based on all these observations, my lord had directed the respondent to furnish the document.
Yes.
In furtherance, my lords may kindly peruse the ink page number 49, my lords, in the same set of document.
Yes.
This, my lords, is with respect to the document executed, a will executed by so-called great-grandfather
Yes.
of the respondent.
Yes.
Wherein at ink page number 49, which is marked, my lords,
Yes.
I hereby give and bequeath to my wife in trust for Sri Kanyaka Parameshwari temple, the presiding deity in Sri Kanyaka Parameshwari temple in Jeweler Street, Civil Station, Bangalore. My wife shall perform the annual car festival in the said temple out of the rentals, and after her death, my adopted son shall also be the trustee and shall perform the said car festival from the rentals. It is given in trust. The properties have already been given to Sri Kanyaka Parameshwari temple, my lords.
Yes.
When that was also showcased, I had also produced the subsequent document, my lords, in page number 52. This is the property card, my lords, of the city survey records, wherein fourth column, my lords, city survey number anta ide, 531 and 107. It was earlier known as 531, later renumbered as 107. And that 107 was again renumbered, my lords, in the subsequent page, in page number 53. On the left-hand side, the first row, my lords, 107. The second column says 22, 23, 24, 25, 26, 27, 28.
Yes.
And the owner is, my lord, Sri Nagreshwara Sri Kanyaka Parameshwari temple property.
Yes.
All of these, my lords, had been filed by way of the present application before the Honorable Trial Court, which is to be adjudicated now, my lords. But earlier, I had also showcased to the Honorable Trial Court that there is a clear contention raised. Order 14 clearly stipulates, my lord, that whenever there's a material proposition of fact, which is derived from either the averment as well as the cross averment, that issue has to be framed. And likewise, the respondents, my lord, had given certain documents, wherein in their own set of documents, my lord, it is crystal clear that the ownership is with the temple, my lords. Wherein the first being, this is on the 10th of March 2025, my lords. This is the document given by the respondent before my lords.
Yes, that's.
Their
yes,
entire,
let-
please, please.
Yes, Mr.
That submission is this.
Yes.
My learned friend mentioned that the sale deeds which he referred to, it indicates that the property is dedicated to Kanika Parameshwari temple. But this statement is not correct. In the first instance, not kindly look at the document which is produced as a will,
Yes.
where my learned friend has just now read it.
Yes.
Let there not be a confusion that
Yes.
the properties are dedicated to the temple and all. Because this was read repeatedly before the trial court.
Yes.
Trial court had drawn its attention also, including the evidence that was let in. And, my lords may kindly turn to what it is said. It's a will which indicates
Yes.
conducting various performances by a family of Nanjundaya Shetty.
Yes.
But I'll commence from the previous pages. These must rebuild so-and-so properties in the manner debts due to such members must be paid. Then he has dedicated certain things.
Yes.
Ramchandra Shastri, so-and-so, so-and-so.
Yes.
I hereby bequeath during my life.
Yes.
Hereby bequeath during my life for the giving up of two scholarships in my name to two poor Vaishya boys for helping them to study after my wife Lalitamba and to the life I hereby give bequeath the said item.
Yes.
Item A, the trustees of the Vaishya hostel.
Yes.
Situation in Ibrahim Street, construction of the Bangalore in trust
Yes.
for them and to develop the said rental premises.
Yes.
Premises, that is in respect of another, some other Vaishya premises for giving scholarships for poor Vaishyas in my name for enabling them to study. The said item B, I hereby give and bequeath to my wife in trust for Shri Kanika Parmeshwari, the providing deity of Kanika Parmeshwari Temple, Jeweler Street, Cantonment Station, Bangalore. My wife shall perform the annual car festival in the said temple of the rentals, and after her death, my adopted son shall be the trustee and shall perform the said car festival from the rentals, and shall nominate the trustees to come after him for the purposes of the case, for the purposes, in case my adopted son predeceases my wife, then my wife shall nominate the trustee to come after her for this purpose. But this rental incomes are in respect of some other property.
Yes.
Not in respect to this property. This property is altogether a different property. So let this will not be confused by them and come to the conclusion that it is bequeathed to the temple. But temple has got nothing to do with the properties which these people own. Now today I have produced certain documents before the court. My lords may look at how I have placed it before the court.
Yes.
Now, these documents are, which my learned friend said, ADLR documents show properties of the temple and it belongs to the temple.
Yes.
But these properties are altogether different.
Yes.
Not earlier that which is mentioned, 530, if I think I may have rounded it off. Jeweler Street, my lords got.
Yes, yes, yes.
There, my lords would get 530.
No, what is that? Jeweler Street is there. One street it is for only jewelers, huh?
It's called as Jeweler Street.
Yes.
Because they are only jewelries.
Yes.
Not the petitioner is also a jewelry. That's the problem. 530 is the property which the plaintiff respondent belongs to.
Yes.
531 is a temple property.
Yes.
This temple property earliest point of time was given 531. But this has got nothing to do with both.
Yes.
Intermediarily, there is a rented premises which is given to a tenant by the temple.
Yes.
So these are two different because this is given by local area of the commercial street, Bangalore city. It is approved. I had to secure it and then place it before the court. Now this one document which establishes that properties are two different properties.
Yes.
Then city survey documents I have produced. Page 2.
Yes.
530 is mentioned.
Page 3.
Page 2. Page 2 first course 15. Property card ಅಂತ ಇದೆ.
Page 3 ಅಂತ ಹಾಕಿದಿರಲ್ಲ ಇದು ತಾನೇ ನೀವು?
ಅದು ಉದ್ದಕ್ಕಿರೋದು ಅದೇ. ಮಧ್ಯದಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಕಾರ್ಡ್ ಅಂತ.
It is there. Yes.
ಇಲ್ಲಿ 530 ಅಂತ ಇದೆ. ಅದು ಆಗ್ಲೇ ತಮಗ್ ತೋರಿಸ್ತೆ 530.
This is 108.
Yes.
He shown 107. No, the documents which he has referred, it is temple property.
Yes.
This is 107. Please.
Which he has shown.
Yes. No, in this is document.
City survey identification numbers.
What is that, sir? Something he has produced that. Yes.
City survey identification.
Yes.
Numbers.
Yes.
Is a different altogether.
Yes.
530 is what I pointed out to my lords in the larger sketch.
Yes. Yes.
This is a different property altogether. Then turn to what I have mentioned.
Yes.
The Kanika Parmeshwari temple in 3
Yes.
is altogether a different.
Yes.
So this is relatedly different property. Then
Yes.
turn to page 5.
Yes.
Page 5, case 531, which I showed it in the larger sketch. 531 is identified in that property.
Page 5.
Page 5. 530,
531 is
530 is
yours.
my property. 531 is temple property.
No, what he has shown this 531, 107. Yours is 530, 108.
531 is temple property.
No, 108, yes.
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 530 is temple property.
Yes.
Altogether, identification is different.
Yes.
Then this is shown in the PT sheet as Kanaka Parmeshwari temple property.
Yes.
Then go to page 7.
Yes.
The larger identification in the first map,
Yes.
they are identical here down below the
Yes.
sketch. No area, no extent is encroached upon.
Yes.
So this is the property of the temple.
Yes.
I have got nothing to do with the temple property.
Yes.
Then the property numbers are 22, 23, 24, 25, 26. In that area, these property numbers are given
Here, which page number?
at page 8.
Yes.
But in the entire area,
Oh, 107, your is 108.
yes, no.
Where is 108?
108, previously I have shown it.
No, here, after that 107, 108 is not there.
107, 108 is not there.
This is what that documents, Nagara Mapana.
ನಗರ ಮಾಪನ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಅದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಹೋದ್ರೆ 531 ಅಲ್ಲಿ ಆ ಟೆಂಪಲ್ದು ಐಡೆಂಟಿಫಿಕೇಶನ್ ಸಿಗುತ್ತೆ.
Yes.
So that is one thing.
Yes.
Then page 10, the T.N. Prasanna Kumar, who is the father of the plaintiff respondent.
Yes.
He was paying taxes
Yes.
for Ibrahim Street. This property relates to two, Jeweler Street and
Yes.
that street. But this property number is mentioned there, 28. Then,
No, that's, I think there is one judgment. You are also not producing that. In suit for eviction, title is immaterial, only landlord and tenants has to be.
100 times I have told the other side.
No, where is that judgment, Mr.?
I'll give them.
You give that judgment. Now here, only that whoever may be that owner of the property, only landlord and tenants relationship has to be proved. That is what that judgment somewhere is. Where is that judgment? You get it at 230. Yes, that's all. I will consider.
And agreements from this person is from more
No,
than.
no, I am not deciding title to suit, Mister. It is all that.
May I make
only
a humble submission, my lords? Apologies on intervening.
Yes, we'll hear that 230. Yes.
Their own documents, my lords, they're contradicting. If I may be provided at least
No,
2 minutes,
see,
my lords.
Here,
107,
no,
my lords.
there is a judgment says that C may be the owner.
Please,
He
ma'am.
may be asked them to be to, give a property for on lease. If you are accepting that lease and you are paying the rent, for getting you evicted, it is enough. For the title is concerned, person who is there, they will claim.
But my
You
lords,
can't say that. You cannot deny this title when you are accepting that he is in a landlord.
may I make a humble submission, my lord? In fact, if my lords may kindly peruse ink page number 37, issues framed, my lords. There's no issues being framed, my lords.
That's only clarification, even trial court also held. Even then, he has to prove landlord and tenant relationship.
That there is no
That
issue
will
being framed.
clarify. That I will clarify that.
Please, my lord.
116 estoppel, my lord.
And in fact, my learned friend hasn't.
Hey, that will clarify
Please, my lord.
trial court that he has to prove that landlord tenant relationship.
Please.
Otherwise, eviction suit
Suit
cannot
will
be
not be
decreed.
maintainable.
That is
In
what-
fact, my
that
learned
will
friend
clarify.
harps upon section 116. My learned friend has failed to realize that only when the property has been given can there be that kind of a contention raised. That is what 116 says. Please, I shall do so, my lords. If my learned friend may produce that judgment,
Yes.
I shall also hear on that aspect, my lords.
Yes, 230, I will dictate that. Yes, you get that judgment. Yes.
Please, my lords. Much obliged.
Yes,
Seal number 11, Aishwarya Hegde MOB.
yes. Yes.
I'm challenging the order passed on IA number 1 and filed under order 41 rule 5 CPC
Yes.
filed by the respondent in RA2 of 22, Your Lordship, seeking for a stay of my FTP proceedings which initiated by me.
Suit for?
Your Lordship, the petitioners herein initiated FTP proceedings
Yes.
based on a preliminary decree in OS 27 of 1972, Your Lordship.
Yes.
And this FTP proceedings were initiated and they came to be allowed. My petition came to be allowed on 7/10/2013.
Yes.
Challenging this, the respondent filed a writ petition. However, that came to be dismissed, remanded back, and stating that the final decree has been passed and also an appeal lies here. And
Yes.
hence he filed an RA challenging this order passed on 7/10/2013, Your Lordship, which came to be dismissed. Challenging that, he filed an RSA. RSA also came to be dismissed, Your Lordship. And now this is a second round of proceedings that he's filed before the first appellate court, Your Lordship, challenging the order passed in my FTP proceedings, drawing where the trial court ordered for the decree to be drawn, Your Lordship. I'm challenging that, and my FTP proceedings have been stayed.
Where?
He challenged an RA, he challenged the order and regular appeal.
No, suit has been decreed.
Suit has been decreed.
Who has filed that appeal?
Appeal has been filed by the respondents.
No, that has been dismissed.
That has been dismissed.
Then RSA is also dismissed.
Also dismissed.
Now that suit has been, degree has been confirmed.
Confirmed.
Now what is that, now
Again, he's filed another round of RA challenging the previous order, Your Lordship.
how can that?
And he's also filed an IA to stay my proceedings.
Now what is that order you are challenging here?
I'm challenging the order passed on IA number 1 under order 41.
Is that order dated 4/3/2020?
Please, Your Lordship.
What is that 4/3/2020?
4/3/22 is staying my FDP proceedings.
Where is that?
Annexure M, Your Lordship, page number 246.
240?
246. Commissioner's report was accepted and the final decree to be drawn, it was ordered. And challenging this, he's filed a RA.
Another application, section 5 of the limitation seeking a permission to bring LRs of the respondent, another. So issue notice to so and so, avoid service of notice. Where is that order with page number, madam?
246, Your Lordship. Ink
240?
page number 246.
Yes. Here is the 246. Where is typed copy, madam? Where is that 246, madam? Nothing is there in 246.
One second.
Yes, you verify. We'll have it there.
1 minute, Your Lordship.
No, madam. So I have so many matters. I can't spend the time like this. Don't come here and read that file. Yes.
Number 12 adjourned, seal number 13, Bharadwaj KR.
Day after tomorrow, yes.
Seal number 13.
Lord,
Yes,
suit for specific performance
yes.
was filed by the first respondent.
Hmm.
The petitioner herein is the fourth defendant before the trial court.
Yes,
That suit was decreed, an ex parte decree was passed.
yes.
That ex parte decree, my lord, after the execution was filed,
Yes,
notice was served on us and we immediately filed a miscellaneous
yes,
under order 9 rule 13
yes.
to set aside the ex parte order. In the meantime, my lord, in the execution proceedings,
Yes,
I made an application
yes,
under order 21 rule 29
yes.
seeking stay of the execution proceedings pending disposal of the miscellaneous petition.
Yes.
Your lordship,
That miscellaneous petition has been filed.
it has been filed, my lord, it is pending trial.
Now that ex parte order has been passed.
Yes, my lord, earlier ex parte order was passed. I had no knowledge, summons was not served on me. When I received notice on the execution petition in 2019, I immediately,
In that miscellaneous petition filed
yes, ma'am,
under order 9 rule 13.
please.
You can't seek for stay of that judgment and
That
decree.
can also be done, my lord. And but there is a specific provision under Order 21, Rule 29 of the CPC, which empowers the court.
Order 21. Yes, read.
Yes. Shall I please?
Yes.
Where a suit is pending in any court against the holder of a decree of such court, or of a decree which may be executed by such court, on the part of the person against whom the decree was passed,
Yes.
the court may, on such terms as to security or otherwise, as it thinks fit, stay the execution of the decree until the pending suit has been decided.
Yes.
Your lordship will see.
Now, where is that order passed by that?
Yes, my lord. Internal page 28, my lord, 27, my lord.
Yes.
My lord, the order is a cryptic 4-line order without hearing either party. I'll read, my lord.
Stay the
Order
proceeding
at
this
15/6/2024, internal page, running page 27.
Hmm.
No representation by either side. Perused IA1 filed by JDR number 4 under Order 21, Rule 29 of the
Stay of
CPC.
further
He prayed
proceedings
to
in
stay the proceedings.
execution petition 2477 of 2017, pending in the file of City Civil Judge Bangalore till next date of it.
Please.
Till number 14, A. Madhusudan Rao.
Yes. Yes.
And this matter your lordship had heard in the last occasion. For refreshing, my lord, the facts are this. Petitioners are the defendants before the trial court. Respondent number 1 files a suit for bare injunction. Suit had gone up to the stage of arguments. At that stage, respondent number 2 files an application claiming some independent rights in respect of the property, seeking to come on record as a party defendant. My lord, the plaintiff files objection, saying that he is not a necessary part. In fact, this defendant number 2
Yes.
claims he claims rights both against plaintiff and as well as the defendant. Subsequently, what happens? Plaintiff says in the course of the arguments, plaintiff says, I have no objection. The court below, notwithstanding that statement, says that because proposed defendant is claiming independent rights, it has to be adjudicated. That is not the common purport of Order 1 Rule 10(2) is my response. Your lordships asked me in the last occasion, the question was whether when the plaintiff is the dominus ritus, whether a defendant can object to the application and can question the impleadment of a party, more so in a scenario where the plaintiff says he has no objection. In that context, my lord, the matter was adjourned.
Yes.
There is one judgment before going to another judgment of the Honorable Supreme Court. There is one judgment of the Patna High Court, my lord, I may be permitted to pass out, wherein exactly the similar situation was dealt with.
Yes.
Kindly go to, my lord, it was a case in para 2, my lord, I'll just read the facts so that your lordship will be able to see the similarity of the situation.
Yes.
A title suit has been filed by the opposite party number 2 for restraining the other dependents, including the Patna Municipal Corporation, from demolishing the part of a house, which is an occupation of a monthly tenant. On 28 November 1975, an application was filed by Murali Manohar Jala, opposite party number 1, for his addition as a party dependent. Copy of the petition was served admittedly only on the plaintiffs and not on the contesting defendants. When this petition was taken up, the plaintiff did not oppose the prayer for addition of the Murali Manohar Joshi and Murali Manohar Jalan, and the learned subordinate did without assigning any other reason. And on the sole ground that the plaintiffs did not oppose the prayer for opposite party number 1, ordered for his addition as defendant number 5 in the suit. So this is the facts of the case.
Yes.
After extracting the provisions of Order 1 Rule 10(2), this is what in para 3 onwards, the Honorable High Court has dealt with. This This provision requires the court to add a party not only as a matter of course, but on the given conditions whether the presence of the person sought to be added is necessary in order to enable the court effectively and completely adjudicate upon and settle all the questions involved in this suit. This finding is a condition precedent for exercising the jurisdiction by a court for addition of a party. The order therefore suffers from lacuna and cannot be maintained. Mr. S.C. Ghosh, appearing for the opposite party number 2, however, contended that the plaintiff being the dominus ritus, it was upon him to choose any party to be added in a proceeding which has been left out by him at the time of filing the suit, and that if the plaintiff did not choose to oppose the application, the court below cannot be called upon to enter into the question and record a finding as required by a sub-rule 2 of Rule 10 of Order 1, as already indicated above. He placed reliance upon a decision in so and so, AR 1962, partner 357. In my opinion, the contention of Mr. Gose is erroneous, and the reliance placed on the decision is entirely misplaced. In the case cited by Mr. Gose, a petition was filed on behalf of the defendant for being added as a party, and the same was strongly opposed by the plaintiff. Raj Kishore Prasad J. clearly laid down that there were only 2 cases in which a person may be added as a party to the suit under sub-rule 2 of Order 10 of sub-rule 2 of Rule 10 of Order 1, namely, when he ought to have been joined as a plaintiff or defendant and is not joined, when without his presence, the questions in the suit cannot be completely decided. It was clearly observed that in this case that if either of the 2 conditions is not established in a case, the court has no jurisdiction to add a party. It is in this background that an observation was made that on a proper construction of Order 1, Rule 10(2), a plaintiff cannot be compelled to add a person as a party dependent against his wishes. This observation, however, cannot be construed to mean that if the plaintiff so chooses or desires, he can be permitted to get any person added to the suit, although the 2 conditions laid down under Order 1, Rule 10(2) are not satisfied. If this astounding proposition is accepted, then it will lead to different standards for applying the provisions contained in sub-rule 2 of Rule 10 of Order 1. Namely, if the application would be on behalf of the defendant or by an outsider, the 2 conditions as mentioned in our sub-rule 2 of Rule 10 of Order 1, as has been indicated earlier, will have to be established. But if it would be on behalf of the plaintiff, then the conditions will need not be fulfilled. This construction is not possible, as it will result in a direct violation of the provisions of Order 1, Rule 10. So in this background, my lord, the Honorable High Court said, even if the defendant opposes, question is only this, whether the presence of this particular person is required for the adjudication of the controversy. This has not been considered by the court.
Yes, I would issue notice, stay of order dated 18/7/2024, passed by First Additional City Civil and JMFC Malur, Annexure A, in
Annexure
OS number
Midada.
398 of 2014, till next date of hearing.
Much obliged.
This objection first time matter, serial number 15, but Ramachandra.
I appear for the judicial dispute, not. But I have completed the office objections, not paid the court fee claim, not.
Court fee has paid.
Today I have paid. Not the petitioner is the JDR, my lord. The dispute is between he is a member of the respondent association.
Yes.
Dispute is with regard to the payment of arrears of maintenance charges.
Yes.
But I have suffered a decree, my lord, for 3,24,118.
Yes.
My lord, the respondent filed execution petition for 11,83,000, my lord. But I made an application before the trial court, my lord, seeking postponement of sale. I deposited 1 lakh. My lord, today, my lord, Monday, my lord, I have deposited 5 lakhs, my lord.
What is that digrital amount?
11,83,000, my lord.
11 lakh.
That is the amount claimed. My lord, the decretal amount is only 3,24,118.
But
They have claimed 11 lakh, my lord, by adding interest,
and,
24%, my lord, they have added, my lord.
yes. Now that, what is that order now?
My lord, my property is not put for sale on Monday, my lord. I have sought for the stay of the execution.
How much you have deposited now?
1 lakh I have deposited, my lord. 1 lakh I have deposited. Monday, my lord, I will deposit 5 lakhs, my lord. I have taken the DD also.
Yes, 5 lakhs.
Please, my lord.
Now, what is that, total claims is 11 lakhs,
11 lakhs 83,000, my lord, claiming, not they are claiming 24% interest, my lord.
Is it agreed?
My lord, appeal is pending, filed by me. My lord, the trial court has passed a decree.
To notice, stay of further proceedings in execution case 552 of 2017, pending in the file of 42nd Additional City Civil and Session Judge, Bangalore, till next date of hearing, subject to condition. Appellant has to, the petitioner has to deposit 5 lakhs before executing court on or before 24th.
Please, my lord.
Yes.
Not I have sought for hand delivery of the order.
Submission is accepted, office objection is over. Yes.
Serial
My
number
lord.
16, Rajaram S.
My lord, I have to file the plaint and written statement.
Yes, when do you want?
2 weeks, 2
2
weeks
weeks
time may
to-
be granted,
2
my
weeks
lord.
Yes, 2 weeks to comply. Office
Much
objection.
much obliged, Your Honor.
Number 17, Kritika Raghavan.
Here on behalf of the advocate for the petitioner, plaintiff's petition.
Office objection.
Complied is what I'm told, my lord. Some pin code was missing. Pin codes have been given on there. They're not reflected there.
Waiting for the respondent. I may kindly request for a
Objection to be stated that the cost title R2, R4, R16, 25 pin code, R2 pin code, page numbers to be stated correctly. After that, page 208. Pass over, you correct it? Yes.
But pass.
Pass.
Serial number 18, Banu Prakash VG.
Yes.
Kindly pass over, your lordship. Seniors on his legs.
No, you have to comply office objection, pass over.
By the
Yes.
end of the day. Obliged.
Serial number 19, Rohan Wasmat.
There are two office objections, my lords. The first objection is that the miscellaneous petition is not filed. My lords, your lordships may take page 28.
That's written statement to be filed.
Written statement they have not filed.
Miscellaneous petition.
It's filed, my lords. It's actually filed as an application, then registered as a miscellaneous because it's filed under 39 Rule 2A. For the objections may be overruled.
We'll take a 2:30. Yes.
Lords, may I request for day after tomorrow?
Day after tomorrow. Yes. Leave this matter. at day
My
after-
lord, serial number 20, with file memo for withdrawal on
Yes.
17th, my lord.
Yes, permit.
Liberty may be given to file similar application in trial court, my lord. It
What is that liberty? If law is permitted, you can do it. Yes.
Amendment of the plaint, my lord.
Now, what is that you are challenging?
My lord, we wanted to amend the plaint. The trial court rejected it, hence we filed the writ petition. Liberty may be given for us to file the similar application in the
How
trial.
can be, madam? Once it is rejected, you cannot be given liberty to file same application.
Yes, my lord.
That cannot be permitted. If you want to withdraw, I will permit to withdraw.
Yes.
Yes, filed in a memo seeking leave of this court to withdraw. Dismissed as withdraw. Yes.
Lord. 45, point advocate is also. Lord, it is very identical matter. 31557 post along with serial number 45.
45?
45 post along with 31557.
Yes, 45 call along with that so on.
Next week, any date.
Next week.
In the month of kindly 6.
Yes, you inform other side. Yes, 40. No, that it is connected with other matter. ನೋಡಿದಾರ ಅಂತಲ್ಲ copy. Okay, let's call this matter along with the so and so next week.
45 first week of March maybe.
Yes, Bharat. Yes.
Post along with.
Yes.
It's a very small matter. I didn't.
Yes. Which one, mister? 14. ಏನಂತೆ? Yes. 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 Yes, awaiting service of notice, interim order, extended till. ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? Will dispose? Yes, we'll take that. Yes.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 32 ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ?
ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿದಾರೆ ನೋಡ್ತಾರೆ. ಜಾಸ್ತಿ ಹಾಗಾಗಿ ಕೊನೆವರೆಗೂ ನೋಡ್ತಾರೆ, ಸಾಹೇಬ್ರೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರೆ. ಡ್ರಾಫ್ಟ್ ಲಿಸ್ಟ್ ಜಾಸ್ತಿ ಇದ್ರೆ ಈ ವಾರ ಆಗಲಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ವಾರ ಆಗ್ತದೆ. ಏನಕ್ಕೆ ಬೇಡ ಸಾಹೇಬ್ RFA ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ನೀವು ಹೇಳ್ತಾರೆ ಕರೆಕ್ಟ್. ಅದೇಪ್ಪ RFA ಫೈನಲ್
17th ಗೆ ಕೊಟ್ಟಿದ್ವಿ.
ಈ ವಾರ ಆಗೇ ಆಗ್ತದೆ. GMCPC ಅವ್ರು ಜಾಸ್ತಿ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾರೆ. ವೈಟ್ ಡ್ರಾಫ್ಟ್ ಲಿಸ್ಟ್ ಸಾಹೇಬ್ರಿಗೆ ಅಪ್ರೂವಲ್ ಕೊಟ್ಟಾಗ ಅದು ಅಬೌವ್ 80, 100 ಆ ತರ ಹೋದ್ರೆ RFA ಪೆಂಡಿಂಗ್ ಇಡ್ತಾರೆ ಅಷ್ಟೇ. ಮತ್ ಮೆಮೊ ಮೂವ್ ಮಾಡೋದ್ ಬೇಡ. ಎವರಿ ಫ್ರೈಡೆ ಬರುತ್ತೆ, ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಬರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ವಿಚಾರಿಸ್ಬೇಕು. ಅವಾಗ ಕಡಿಮೆ ಇದ್ರೆ ಆಟೋಮೆಟಿಕ್ ಆಗ್ತದೆ ಅಷ್ಟೇ. ಏನಪ್ಪಾ? ಈಗ ಆಟೋಮೆಟಿಕ್ ಹೋಗಿರುತ್ತದು, ನೀವು ತಲೆ ಕೆಡ್ಸ್ಕೊಬೇಡಿ. ಹೋಗಿಲ್ಲ ಅಂದ್ರೆ ಶಾರ್ಟೇಜ್ ಇದ್ರೆ ತರ್ಸ್ಕೊಂಡು ಹಾಕ್ತಾರೆ. ಈ ಫ್ರೈಡೆ ಮಿಸ್ ಆದ್ರೆ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ, ಅಲ್ಲಿವರೆಗೂ ವೇಟ್ ಮಾಡ್ಬೇಕು ನಾವು. ಬಿಟ್ಬಿಡಿ ಅದೆಲ್ಲ ತಲೆ ಹೇಳಕ್ಕೆ ಆತರ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ ಅವರು. ಈ ವಾರ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮುಂದಿನ ವಾರಕ್ಕೆ.
Okay, sir.
Lordship will decide. ಇದೆ 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 ಅಂತ ಹೇಳಿದ್ರೆ
23.
ಇಲ್ಲಪ್ಪ ಇದೆ. ಹೌದು
23 ಅಲ್ಲಿ
ಹಾ ಸರ್,
entry model ಸರ್.
ಹಾ ಹೇಳಿದ್ದಾರೆ ಸರ್, ಹೇಳಿದ್ದಾರೆ. ಯಾವ್ದಿದು
20 ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ,
ಹಾ
ಕಡೆ ಇದೆಯಪ್ಪ ಇದು. ಡಿಸ್ಪೋಸಲ್ಸ್ ವಿತ್ ಅಂದ್ರಲ್ಲ,
ಹಾ.
ಹುಡುಗಿ ಮೆಮೊ ಕೊಡು ಅಂದ್ರೆ ಆಲ್ರೆಡಿ ಮಧ್ಯ ಇದ್ರಲ್ಲಿ ಹಾಕಿನಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದೀನಿ. ಫೈಲ್
ಇಲ್ಲೇ ಇತ್ತಲ್ಲ ಇಲ್ಲಿ ಫೈಲ್ಗಳು ಕೊಡಪ್ಪ. ಎಲ್ಲ ಅಲ್ಲೇ ಇತ್ತು ಇಲ್ಲಿ.
ಸರ್ ಇದಿಲ್ಲ ಇರಲ್ಲ.
ಎಲ್ಲಿದೆ ಬಾ ಸಾಹೇಬ್ರ ಟೇಬಲ್ ಎಲ್ಲ ಐತೆ. ಎಲ್ಲಿದೆ ಬ್ರಾಂಚಲ್ಲಿ ಹಾಕಿ ಇನ್ನೊಂದು ಕೊಡಪ್ಪ ನೀನ್ ಆನ್ ಸ್ಪಾಟ್. ಬ್ರಾಂಚಲ್ಲಿ ಹಾಕಿದ್ರು ಅವ್ರು ತಂದು ಕೊಡ್ಬೇಕಲ್ಲ ಎಂಟು ಟೈಮ್.
ಪಾಸ್ ಅವ್ರು ಒಂದ್ ಇಸ್ಕೊಂಡ್ರು, ಒಂದ್ ಇಸ್ಕೊಂಡಿಲ್ಲ.
ಆಯ್ತು ಆಮೇಲೆ ಕೊಡು 2.5. ಇಪ್ಪತ್ತೊಂದ ಇಲ್ಲಪ್ಪ, ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು? ಸರಿ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ. ಅವ್ರಿಗೆ ನಿಂತ್ಕೊಳಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಸರಿ ಕೂತ್ಕೊಳ್ಳಿ ಕೂತ್ಕೊಳ್ಳಿ. ಆಯ್ತು ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ. ಇವತ್ತಿಲ್ಲ ನಾಳೆ. ಹಾ ಹೇಳಿ ಸರ್, ನಿಮ್ದು ಹೇಳಿ. 49. ಇವತ್ತಲ್ಲಪ್ಪ, ನಾಳೆ 43 ಇದೆ ಇದೆ. ಇವತ್ತು ಎಷ್ಟು ನೋಡಿ ಸರ್, ಇಯರ್ ಎಷ್ಟು ನೋಡಿ. 2008 ನಮ್ದೇ. ಇವತ್ತಿರಲ್ಲ, ನಾಳೆ ಇರುತ್ತೆ. ನಾಳೆ ಇವತ್ತಲ್ಲ. ನೀವು ಒಂದ್ ದಿವಸ ಮುಂಚೆ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರ. ಅಲ್ಲ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು. ಯೂಶಲ್ ಆಗಿ ನಾಳೆ, ನೀವು ನಾಳೆ ಬಂದಿಲ್ಲ ಯಾಕೆ ಅಂತ ನನ್ ಕೇಳಂಗಲ್ಲ. ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಹೋಗ್ಬೇಕು. ಬರೋದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ.
Court officer. Court officer.
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ ಮೊದಲು ಪಾಸ್ ಓವರ್ ತಗೊಳ್ತಾರಾ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ?
ಅದೇ ಮೇಡಮ್, ಪಾಸ್ ಓವರ್ ಕಳ್ಸಿರೋಂತ ಮ್ಯಾಟರ್ ಇದೆ ಸ್ಕ್ರೂಟನಿ ಬ್ರಾಂಚ್ಗೆ ಬರ್ಬೇಕು, ಬಂದ್ರೆ ಡಿಸೈಡ್ ಮಾಡಿ.
ಓಕೆ ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಯಾವ್ದು ನಿಮ್ದು? ಎಷ್ಟು ಕೇಸ್ ನಂಬರ್? ಕೇಸ್ ನಂಬರ್ ಎಷ್ಟು? ಬೇಗ ಓಡೋದು. ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್ಗೆ ಹೋಗ್ಬೇಕು. ಸ್ಕೂಟನಿ ಮಾಡ್ತಾರೆ, ಪುಟ್ ಅಪ್ ಮಾಡ್ತಾರೆ. ಇದು ಬೇಡ ಅಂತ ಹೇಳಿದ್ನಿ, ನಾನು ಹೇಳಿದೆ ಅಂತ. ಆಯ್ತು, ಮಾಡಲ್ಲ ಯಾರು, ಮಾಡಿ ಟ್ರೈ ಮಾಡಿ. ಫಾರ್ಟಿ ಅಲ್ಲಿ ಸರ್. ಸರ್ ಹೌದು, ಮಾಡಿ ಮಾಡಿ. ಹೇಳಿದ್ದಾರೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೈಟೇಷನ್ ತಂದಿದ್ದೀರಾ ಸರ್? ಸೈಟೇಷನ್ ತಂದಿದ್ದೀರಾ ನೀವು? ರೆಡಿ ಇದೆಯಾ? ಇಲ್ಲೇ ಕುತ್ಕೊಳ್ಳಿ, ಹಿಂದೆ ಅವಾಗ ಶುರು ಆಗ್ಬೋದು. ಯಾವ್ದು ಪ್ಯಾನ್ ಹಾಕಿಲ್ಲ ನೋಡಪ್ಪ. ಕಂಪ್ಲೇಂಟ್ಸ್ ತಗೊಂಡಿದ್ದೀವಿ, ಮಾಡಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್. ಅದು ಒಂದೇ ಇರೋದು. ಹೇಳ್ತಾರೆ ಸರ್, ಪಾಸ್ವರ್ಡ್ ನೋಡ್ಕೊಂಡು ಬರ್ತಾರೆ. ನಾನು ತರಿಸ್ತೀನಿ ಈಗ ಅವ್ರು ಕೇಳಿ ಅವರೆಲ್ಲ ಅನ್ನಿಸ್ಕೊಳ್ಳೋದು. ಸ್ಲಿಪ್ಗಳು ಕೊಟ್ಟವ್ರಾ ಕನೆಕ್ಟೆಡ್ ನಂಬರ್ಗಳು 45, 46 ಹಾಕರಿ ಹಾಕ್ಬಿಟ್ಟು ಹೆಚ್ಚೆ ಕೊಟ್ಟು ಕಳಿಸಿ. 3 ಹೆಚ್ಚೆ ಇದೆ, 2ಕ್ಕೆ ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊ. Third time office objection, serial number 21, Rupali K. Trivedi for petitioner CN Mahadeshwaran.
That is ready, Mr. Put your books, put it. Sorry, don't mind.
May I make a humble submission, my lords? Before my lords may kindly peruse the citation, just one humble submission to my lords. My lords may kindly peruse the transpiring events that have occurred. Initially, they also accept and admit that it is Mr. So-and-so Nanjundeshwara Chetty's property itself. Their only claim contention is, my lords, that in that will dated 1956, my lords, I'm sorry, 38, 10/9/1938, it has been given to their children, to the wife and to the adopted son, and henceforth. My only humble submission is, in the said will, it's mentioned as trustees, my lord. If my lords could frame an additional issue, apart from whether the plaintiff and defendant have any
See,
Please, my lords.
for the trust to go and claim for right, you are the tenant.
Please, my lords.
You want to prove, he has to prove that,
Please, my lords.
yes, he is my tenant. Yes, I have given that lease. If that is there, eviction, that doesn't mean that he is an owner.
Of
For
course
that,
not.
it is for them. You cannot say that you
Please.
should be owner, therefore you cannot evict me and all. If that proves that he is a landlord and you are paying the tenant, it's the end of the matter. It is one for suit for only eviction.
Yes, my
It
lords,
is not
no
for
doubt.
that.
My only humble
40
submission is
is a tenant.
that, yes, exactly. 40 years, the tenancy has been done where the petitioners were paying rents to the temple, my lords. Subsequently, the respondent, who's the plaintiff before the Honorable Trial Court, had formulated certain and executed certain lease agreements.
All that will not available for you.
Yes,
If
my
it is
lord.
a
Yeah.
temple property, why you have taken a tenancy from him?
In fact, I have not taken tenancy from him.
Yes,
May I make a humble submission, my lords?
yes.
Just one aspect of it. If I may bring to my lord's attention to ink page number 38
Yes.
of the petition, my lords.
No, all that you are saying that in respect of the title.
No, my lords. My only humble submission is, at least if my lords may kindly peruse issue number 2 and 3, additional issue number 2 and 3.
Yes.
Empowered to file. My lords, I will not question the title. I will not question the title, my lords.
No,
But
that
at least
is
has
what
he
I am
right?
I am clarifying
Yes, my
that.
lords.
See, suit for eviction can be passed. Court can pass in a degree only that plaintiff proves that he is a landlord
Landlord.
and tenant. That's
True,
what.
my lords.
That I will
Along
clarify
with that, my lords, whether he has any authority or
What
he's
authority, mister?
empowered to file the suit and also to have a lease deed.
Then a landlord, then only that authority, mister. What else he has?
That may be at least come on record, my lords. That is it.
That is what that, see, I will clarify that.
Please, my lords.
What is required for suit for eviction?
Please, my lords.
Suit can be decreed only that plaintiff is proves that landlord and tenant. The court
Relationship.
before eviction, it has to be proved and then has to be
Yes, my
passed.
lords. Along with that, an observation of that sort, whether they're empowered to or not.
Yes.
That's it.
No, if he is not in a landlord, that cannot be in a eviction suit, mister.
Correct, my lords. At least an observation is what my humble submission was.
Yes.
Even then, the issue that the court has framed,
Yes.
the second issue is like this. Whether plaintiff further proves that he is entitled to recover vacant possession of the suit A and B commercial premises from the defendant.
Hmm.
That answers that issue.
I-
Until there is a relationship,
Where
I
is
can-
that issue number?
page 37.
Yes.
Kindly see, the first issue is he is a defaulter in payment of rent.
Yes, yes, that's what I will
Number
see.
two,
Yes.
whether plaintiff further proves that he is entitled to recover vacant possession of the.
Unless he is in a landlord, he cannot.
Yes, my lord. That's
how we
precisely.
clarify.
Let that come on.
It covers everything.
Of course not. I mean,
Yes.
It covers everything.
No, no.
Need not frame any other issue.
No, there is no any framing issues. I will clarify that it covers, but degree can be passed only if there is a landlord and tenant relationship is proved.
Of course.
Right.
But I have already proved, my lord. I have cross-examined him also.
may I make a humble
And in-
submission, my lords.
100 words he
course.
has said he is my tenant.
Of course, I bow down to my lord's observations.
Observe all these things.
Please, my lord. Only thing is just two aspects, my lord. One, let an issue be framed that whether he's a landlord and I'm a tenant.
This
Firstly, my
issue
lord.
is covers all these things. I will explain that.
Please, my lords.
Yes.
And also at the same time, an opportunity to showcase as to whether he's empowered to or not. That's it.
Yes.
Please.
This petition is filed by defendant challenging order dated 10/12/2024 passed by 85th Additional City Civil and Session Judge, Bangalore, in commercial OS number 955 of 2023, whereby IA filed by that defendant under order 14 rule 5 has been dismissed. Plaintiff has filed suit for eviction and recovery of the possession.
My lords, arrears of rent, my lords.
Huh?
Apologies. Suit for eviction and arrears of rent.
Yes, eviction and arrears of rent. On service of summons, defendant appear through counsel and filed a written statement denying that the plaintiff is not a owner of the suit scheduled property. On the basis of the pleadings of the parties, trial court has framed two issues as follows. Page 37 ಅಲ್ಲಿ ಇದೆ, ಎರಡು issue. On the basis of the issues, parties are adduced their evidence ಆದ್ಮೇಲೆ ನೀವು appeal.
Yes, ma'am.
Adduce their evidence.
Stage was arguments, final argument.
At the time of matter posted for argument, defendant has filed this application.
In fact, may I make a humble submission, my lords? It was, in fact, the defendant had filed an application for recall and it was posted for cross-examination. At close and Nantara, I filed an application of this sort, man.
Yes, at the time.
So
of
it's not for arguments.
Yes.
Cross-examination of DW1.
Sorry, I had argued the case.
No, that is immaterial for disposal. Action argument. Just I want to.
Want him to make
Yes,
statements which are
When
off
matter
the-
was posted for evidence, that time this application has been filed.
My lord, may
Taking
just
an
correct
additional
it.
issues.
Page 27,
Yes,
re-examination nil, that is of defendant DW1.
yes.
Where is the
When
question of
matter was
other arguments?
Posted for re-examination of
No, re-examination nil means no evidence is concluded in all.
concluded, yes, yes. After conclusion of that evidence, application has been filed. Seeking for framing of additional issues. Section page 38 ಅಲ್ಲಿ ಇದೆ. The additional issues requested by the plaintiff as follows, defendant as follows. The learned counsel appearing for that application has been dismissed, being agreed by the same. The petitioner, defendant is before this court. Learned counsel appearing for.
My lords, apologies for intervening again. Adalde, I filed a review application that also got dismissed, my lords. I'm challenging both the orders.
Yes.
Please.
Dismissed, being agreed by the order, he has filed an application for reviewing that order dated. Where is that order you are challenging?
Annexure H,
Dated
my lord.
10/12/2024. By order dated 18/1/2025.
Yes, my lords.
That review application is also dismissed, being agreed by the same. He filed an, ಆದಷ್ಟು ಎಷ್ಟು ನಿಲ್ಸ್ಬೋದು ಅಷ್ಟು ತಡೆ ಆಗಕ್ಕೆ review ಎಲ್ಲ
My lord will not see it that way.
You could have directly come here, filed in a review, see that sometime it can be pushed.
No, of course not, my
Yes.
lords. I'll have to bow down to my lords. They may
Yes,
not have that observation.
Yes. That's why they are engaging that counsels. Learned counsel appearing for the defendant contended that the premises in dispute belongs to Karnika Parameshwari Temple. The plaintiff respondent is not the owner of the temple, the owner of the premises. He has no right to seek for ejectment. He has no right to seek for eviction of the plaintiff, petitioner from the suit scheduled property. Therefore, he seek for an additional issues to be framed, to shifting a burden on the plaintiffs to prove that he has a right and title over the suit premises.
My lords, may I make a humble submission? Again, apologies for intervening. I do not contest that I have a right and title, my lords, over the.
No, you have
yes, ma'am.
contended, he has to.
He has to prove
Yes.
that, please.
Therefore, he's sought for additional issues to be framed. The trial court error in dismissing that application. For contra, so and so learned counsel appealing for the plaintiff has contended that this is a suit for eviction. The plaintiff has to prove the jurial relationship of landlord and the tenant between plaintiff and defendant is enough for terminating the tenancy. Title is immaterial. Heard the learned counsel for the parties. Heroes, read paper. The plaintiff has filed suit for, where is that, this thing? Plaint,
In page number 35, my lords. That is, in fact, the prayer is at 33, my lords. Apologies.
33 is that.
Apologies, apologies.
Yes,
Page
The-
21.
21, yes, my lords.
page 21. Filed in a suit for ejectment, directing the defendant to quit and vacate, deliver the vacant possession of the suit scheduled commercial premises in occupation of the defendant, and also seeking direction to pay the arrears of the rent. Even though petitioner has taken to me that records produced before the trial court that to show that suit scheduled properties is not belongs to that plaintiff, it is belongs to the temple. The plaintiff is also produced the documents to show that suit scheduled premises is belongs to plaintiff. Be that as it may, the suit is filed for ejectment, eviction. In suit for eviction, the landlord required to plead and prove only two things. First, that there is existing a jurial relationship of landlord and tenant between the plaintiff and defendant. And secondly, the tenancy is duly terminated in accordance with law. The issue framed by the trial court accordance with law. In suit for eviction, the title is immaterial. When the court wants to, if the court agrees the suit, only if the plaintiff establish that landlord and tenant relationship. In the case in hand, the issue number 2 framed by the trial court, it covers the above point. There need not be any additional issue in respect of plaintiff to prove that tenant, the landlord and tenant relationship. Therefore, it is made clear that in suit for ejectment, trial court can pass in a degree only if the plaintiff proves landlord and tenancy relationship. With that observation, the above writ petition is disposed of.
May I make a humble submission, my lord?
Yes.
Also an authority, my lords, whether they're entitled to file the suit.
No,
If
only
that-
if it is a landlord, he can file it. He needs
Yes, my
not,
lords, at least that observation may be made, my
it
lords.
is enough, yes.
I
that he-
understand, my lords, because what happens is
No, if it is not proved that he is not a landlord, then suit has to be
the word
dismissed.
landlord is not mentioned, my lords. Because what happens in a suit for recovery of possession over a property, any such parties could file for the same, my lords.
Recovery will come only suit for prior for eviction is ordered. For
Please, my lords.
eviction, he has to prove that landlord and
Correct, my lords.
tenancy.
For that, the word landlord and tenancy has not been
If
mentioned.
you want
If-
further, Supreme Court said, once you admitted, it need not be proved.
I understand.
If I
Just only my humble submission is that let the term landlord and tenant come into the picture, my lords, in the issue.
estoppel of the tenant from denying the title of the landlord on the date of commencement of the tenancy, once he has accepted that this is.
I agree, my lords. My only humble submission is the term landlord and tenant is not been mentioned in the issue.
No,
Let that be
therefore I
mentioned, my
said,
lords.
second issues is cover that unless it is proved that degree cannot be passed.
If I may also seek for one more liberty, my lords,
Yes.
at least additional evidence that I could be having.
That is for, this is not in respect of that.
Yes, my
That
lords,
you
with
go-
liberty to go ahead with any additional issue with respect to that issue number 2, my lords, because it broadly encompasses so many other things, as
No,
my lords had
see,
rightly said.
You have to file an application before the trial court.
Yes, my lord, at least a liberty may be granted, my lords, for that
For
aspect.
the trial court to decide whether evidence already is given is sufficient.
I'll again have to look before my lords with respect to a writ, my lords.
Matter is only for framing of an additional issue.
Yes, my lords.
Yes, yes.
Because of which.
I said
because-
that it need not be necessary. Yes.
Please, my lord. Much obliged.
Serial number 17, first over matter, serial number 17, Kritika Raghavan.
Yes.
On behalf of the petition. This is a plaintiff's petition. Suit for injunction filed.
Yes.
Ex parte application was made for ex parte relief not granted.
Yes. Suit for injunction.
Yes, madam.
Yes. What is that threat?
My lord, it basically a defamation suit where the defendant had been my employee.
Hmm.
In 2014, I had employed his services.
Hmm.
2017, he resigned.
Hmm.
After that, negotiations went on for some time. Then we said enough is enough. But he has kept on troubling us. He has kept on sending communications to us. In 2023, he made some very harsh defamatory statements, not only addressed to me, but addressed to, I am an investment company, a global investment company. I am the Indian subsidiary here or Indian arm here. To all heads of global investment companies, he sent a communication in 2023, defaming not only us as the party, but also the lawyers and the counsels who are engaged. There was a senior advocate of this court who has been engaged. By name, he has defamed him also. At that point in time itself, we needed to take some action against him. Now, on 18th February, he has once again sent us a threat saying that within 48 hours, if you don't comply with my demands, I will once again start all these things. So I have been prompted to file a suit for defamation to prevent him from doing so. Lord, I'll show my lord only.
Is that injunction order you have sought?
Lord, at page 39.
39.
My lord, the relief sought here before this court.
No.
There, in that court, my lord.
Yeah, you.
That I'll give the idea, my lord. It comes at page 175.
Yes.
175, from directly or indirectly communicating in any manner whatsoever, including but not limited to oral, written, electronic, or any other form of communication with the plaintiff's partners, stakeholders, related parties, associates, employees, investors, vendors, service providers, or any other entity connected to or having dealings with the plaintiff.
No, how can this, see, he cannot make any
Defamatory
communication
statement.
defamatory. He said that he is right to write in a letter, everything has been restrained.
No, if this is limited only to defamatory statements, I'm more than happy.
No,
The way the prayer is worded.
If this prayer is granted, his fundamental
From
right has been
communicating.
taken. Yes.
Not from communicating defamatory material.
Yes.
Note.
What is the prayer you have sought here?
My
What
lord,
is that
here-
order passed by the trial court there?
My lord, at page 43, no application of mine, my lord. At page 47, the trial court merely says after considering the facts and circumstances, no reasoning, nothing. At page 46,
Now
the
what
order
has happened
begins.
on 3/3/25?
3325, at page 46, my lord.
46. 3/3/25. Returnable on 5/4. Yes, next date is 5/4.
That's it.
Yes. Now, what is that interim order? sought here?
Interim order that I'm seeking here, my lord, is at page 39,
Yes.
2 reliefs.
it may be limited only to the extent of defamatory material.
Yes, sir. Or issue notice. Respondent number 1. Herein. Only respondent number 1.
Only one respondent.
To restrain from issuing any communication, oral or written. Issue any defamatory communication, oral or written. To plaintiff.
In fact, like my lord, prayer B, the interim prayer B, that is more applicable.
Agent, salesman, representatives false defamatory statement against the plaintiff in any manner whatsoever in any.
Because my lord, all the other respondents are the media houses.
Yes, such defamatory and false.
This is what he is threatening to do.
Yes.
Prayer B may be given.
Restrain the prayer B. Till next date of hearing. Yes.
Grateful, man.
Comply with that. Yes, submission is accepted, after subjection is.
Serial number 18, Banu Prakash VG for petitioner, V Manjunath Prasad.
Yes, the appellant, Lord. The only office objection is with regarding to production of a death certificate of the father of the plaintiff.
Yes.
Suit ಹಾಕುವಾಗಲೇ ಇರ್ಲಿಲ್ಲ ಅವರು. Nonetheless, my lords, I'll produce it, my lords. My lords, the case is that, my lords, in a suit for injunction,
Yes.
subsequent to an interim order of injunction being granted, notice was issued. The defendant should appear before the court, file their statements, issues are framed. My lords should get the order sheet where issues are framed at page number 30, my lords. The order sheet I produced.
Yes.
Issues framed for plaintiff's evidence by 25 so and so. Subsequently, my lords, the plaintiff would file a memo for withdrawal, which my lords would find it at page number 67, annexure G. There's a reason given, my lords.
Yes.
It is submitted that from the advice of elders and well-wishers of the family, plaintiffs are not ready to proceed with this case as there is a case pending in the so-and-so court in so-and-so number in which all the plaintiffs are made as defendants. Now by amending the plaintiff in this case, as such the plaintiffs will appear in a so-and-so court and ready to contest the matter as such plaintiff are withdrawing the above case and may be disposed of. Based on this withdrawal memo, my lords, the impugned order is passed. My lords would get the impugned order at page number 35, my lords. 35. The Honorable Trial Court, my lords, passes an order on the withdrawal memo, where at page number 36, paragraph number 4, my lords.
Yes.
Further, the defendants want to the content, because there was an objection by the defendants.
No, memo
Content that
by the plaintiff suit in so far as the plaintiff claims are concerned stand withdrawn. Suit survive for the limited purpose of adjudication amendment application filed by their application under order 39 rule on accordingly. These two applications will be considered on merit. Protect the interest of both the parties. Prevent any alteration such status quo. It is necessary to continue interim order. Now that how many plaintiffs are there?
Lords, there are in all, my lords.
You are also plaintiff or a defendant?
Plaintiff. There are 5 plaintiffs.
Only.
We wanted to withdraw. The defendant would say they would set up a counterclaim. That is what I intended to indicate, my lords. Page 36, para 4. The Honorable Trial Court in the impugned order holds this.
Yes.
Maybe around 7th, 8th line, my lords. It starts as the defendants have claimed counterclaim. My lords should get that, my lords, in the middle of the paragraph.
Yes.
The defendants have claimed counterclaim which has to be treated as plain, and the suit has to be continued before this court and adjudicate the matter of counterclaim. Not my case before the Honorable Trial Court was, once if any counterclaim has to be made, it has to be made at the time of filing of the written statement. But however, after the framing of issues, there cannot be any counterclaim. I even produced it in citation.
That is true.
Here's the case where that is why I indicated at page number.
When counterclaim has been made?
Counterclaim has been made by the time when I make the withdrawal application, subsequent to the issues being framed.
No, you have filed an application for withdrawing the suit.
Please. Along with, just before that, they would file this application.
No, that other plaintiffs are want to continue that suit.
No, nobody wants to continue. All the plaintiffs want to withdraw.
Now, what is this he said? Memo withdrawing filed by the plaintiff dated so and so is allowed suit in so far as the plaintiff's claims are concerned stands as withdrawn.
Please, all the plaintiffs want to
For
withdraw.
a limited purpose adjudication amendment application filed by the defendant. Their application, when they have filed this thing?
Yes, my lord, they have filed the application under order 6, rule 17.
Yes.
Only subsequently. That's on 3/12/24. May I just point that out, my lord, page number 32
Yes,
is the date on which they make this application under Order 6, Rule 17.
yes,
Issues were framed in the month of November 24, as per
Yes.
page 30.
yes.
The Honorable Trial Court wouldn't take that into consideration, but would indicate that even though a memo for withdrawal is filed and the court is ready to withdraw the case or dismiss the case as withdrawn, but insofar as this application filed with the defense and the defendants are concerned,
Yes.
the court would say that the proceeding should
Issue notice, stay all further proceedings in OS number 820 of 2024 pending in the file of 10th Additional City Civil at JMFC, Mysore till next date of it. Yes, submission is accepted, office objection is.
Great. Third time office objection, serial number 21. Bhopali K. Trivedi for petitioner, CN Maheshwaran.
Yes.
The petitioner
The
is K.
respondent in
Prana.
this case.
I've complied with the office objections, Your Lordship.
Appear for the respondent.
Yes, copy. to
They
this-
appear for the respondent.
Yes, copy has been served, yes.
Copy has been served, Your Lordship.
Yes.
Your Lordship, I have filed this petition challenging the order dated 12/11/2024 passed by the commercial court, Your Lordship.
Yes.
In the last occasion, I was directed to file an affidavit undertaking that I will deposit 50% of the decretal amount, Your Lordship. We had negotiations, we met the parties. We tried to come
No,
down.
this is the case where Advocate General has appeared.
Yes, yes,
Yes,
correct.
yes,
Same,
Your
same matter, same matter.
Yes, Your Lordship.
The connected matter is not,
Irrelevant, Mathis.
There's
Yeah.
another connected matter, Your Lordship, which is not listed today. So however, in the last occasion, we were supposed to come to a consensus with a figure.
Yes.
But we have still not arrived at a figure, Your Lordship. And we have no objection with the auction sale that is going to happen on 3/4/2025, Your Lordship. With respect to 24 apartments, let there be an auction sale. As per my valuation report that I have filed before the trial court at page number 109, annexure G, Your Lordship. In this, page 113, the total square feet is
No, what is that? Now you give a brief facts, madam. What is that suit for?
it's
The arbitration proceedings, it has culminated up to Supreme Court. 46 crores or 47 crores is the decretal amount as on today. my lord.
47 crores.
47
Now
crores.
execution has been filed.
Execution 144 flats have been attached, out
Yes.
of which we have confined ourselves to 83 flats, my lords. Let the auction takes place after 47 crores, we'll stop. There is no question of anything else. That's all. Where else, my lords?
Your Lordship, with respect to these remaining out of 84 apartments, the remaining 60 apartments have been encumbered by third parties, Your Lordship. I have a contractual obligation as against these 60 apartments, Your Lordship. And hence, now if
Now,
auction
totally,
takes
how
place-
many apartments are there?
Totally, there are 144 apartments.
144.
Yes, Your
How
Lordship.
many attached? This has been attached, Mr.
144.
144.
All 144 has been
are attached.
attached.
Yes.
Lord, Order 21 Rule 58 third party objection, Yaru file, that has been rejected. Nobody has challenged it. So this is again one more method of stalling the entire.
Yes. Let them action that.
Yes.
After satisfying their amount, they will stop that further.
That's
this
all.
thing.
Your Lordship, it will only lead to multiplicity of proceedings, Your Lordship. There are other third party buyers.
They are
I
not
have
before-
contractual
They are not
obligation.
before this court.
Nobody has come.
Yes, let them come. Now you have any due of the amount, your property is
I'm not
attached.
disputing the arbitral award. I'm not disputing the interest also, Your
Yes, yes.
Lordship.
Let them come before the court, then we'll see.
But with respect to these 24 apartments being auctioned, they will be able to satisfy at least 80% of the decretal amount along with interest, Your Lordship.
80, no, 100% decretal amount has to be satisfied. They will also go for the apartments which there is no encumbrance because they
Encumbrance.
should not create further litigation for them.
Yes,
They will
yes.
not, who will go and say that where there is a third party interest is there, they
Not
will
sell
go.
them.
First, they will go to that where there is there is no title disputes. If it is not satisfied, there is no other alternative, they will go there. Yes.
But Your Lordship, with respect to these 24 units, it's 40,000
Take
square
notice,
feet,
we'll
Your
see that.
Lordship.
Yes.
Yes,
We'll-
please.
Yes. Take issue notice.
Lordship may observe, the proceedings can go on and the lordship may
No,
observe.
I am not granting any stay.
Our sale officer at the lordship should notice and tell but for 8 years, not 1 rupee it has not come. Lordship may say proceedings may go on.
Yes.
Your Lordship, I'm not in
No,
the
I will say
position
that
to.
that is subject to result. Let them proceed.
Subject to the result and the madam lord. Then again, third party buyers, lords, they will say
Yes,
it is
issue
subject to the
notice,
result.
KVTR is undertaken to appear for respondents.
Sole respondent.
Pending writ petition before this court will not come in the way of the executing court to proceed with that matter.
Please.
In accordance with, yes. Yes, submission is accepted, of subjection is over.
For orders. Serial number 22, Vinod Prasad.
Office objection is at page 34, handwritten portion is there. In page 34.
For the above office objection.
Well, that is
another
only
typed copy
hearing that even best effort I could not get it.
of that. Yes.
I could
What
not
is
get
this
it
matter?
typed.
Yes, what is this matter?
This is my lord, decree has become final.
Hmm.
I have got filed execution petition for last 4 years simply going on. Page 37 is the
No, what is the suit for?
suit for partition between the brother and sisters.
Hmm.
Suit is decreed.
Hmm.
Operative portion is at page 27.
Where is that decree?
27 order, that is the decree.
Yes.
Last, further, the defendants are hereby directed to execute the rectification in favor of the plaintiffs in respect of item number 1 in B schedule and item number 1 in C schedule of the registered partition due date so and so, to the effect of replacing Amani Balandur Khane in the place of Yamanur. That's all.
Yes.
Only schedule has to be mentioned properly.
Mistake of plaintiff defendant.
That is the decree. They are not coming forward. I filed execution for last 4 years being adjourned unnecessarily.
No, see, this is the decree.
Yes,
Now, where is that FDP, final degree proceedings?
execution petition is,
No, it's a suit for partition.
yes,
And then, why,
suit
what
of
is
the
the
plaintiff
question of
hereby decreed.
final degree proceedings? Why execution has been filed? It is not degree for,
Execution petition is at page 29.
if hereby decreed with the cost.
And they are placed ex parte, only one sister is contesting.
Dependent mentioning the location. Yes. It's not a partition. Yes. What is that execution petition?
Execution petition number 484 of 13 at page 29.
You are the degree holder or an judgment?
Decree holders, both brothers. They are judgment debtors.
Why it is urgent?
At the unnecessarily, kindly look at the order sheet I have produced. They are objecting, that's all.
Judgment debtor have not filed an objection, hence argument JDR side is not canvassed by order, so and so.
I may take notice to the advocate for appealing R3.
Yes.
Let it be posted by Monday or
Issue
next week.
notice. In addition, petitioner is permitted to take out, serve a copy on the counsel appearing for the respondent before the executing court. Leaves this matter on 28th.
This month.
Yes, you serve the copy. And
I serve it. Well, next week it may kindly be, so they could dispose of.
no, that's what, 28th. Yes.
Office objection.
Yes, submission is accepted, office objection is over.
Serial number 23 adjourned, serial number 24, K. Ravishankar.
As regards the office objection, you made a note in the cost title at
Copy to serve KADB.
ಅಲ್ಲ ಅದಕ್ಕೆ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಾನು ನೋಟ್ ಹಾಕಿದ್ದೀನಿ ಇಲ್ಲಿ.
Okay.
But it's only the application filed at the behest of respondent number 20 and no relief is claimed against.
Yes, what is this?
But the petitioners are the defendants number 18, 19 and 20. The suit is filed for partition. In the partition, after the written statements have been filed, the contesting the interstate dispute between the defendant number 17 and the defendant number 18 to 20. But after the written statement has been filed, issues have been casted annexure D, page 59.
Page
59.
Yes.
But this at page number 60, additional issues came to be framed.
Yes.
Lordships got it.
Yes.
Whether the defendant number 17 proves that he is absolute owner of the property shown in item number so and so, scheduled properties in the written statement by him. Second, whether the defendant number 17 proves that as per the partition deed date registered documents saying so, all claim scheduled property except item number 1 and 2, scheduled properties of the written statement of the defendant number 17 were partitioned. Next, whether the defendant number 17 proves that the sale deed dated 13/11/2003 registered as document number so and so in the book number so and so is null and void document and not binding upon the defendant number 17. But after this written statement has been filed, the defendant number 17 sought a counterclaim. Last may kindly have a look at the written statement by a counterclaim.
That is, you have filed a counterclaim.
No. The defendant number 17 has filed a counterclaim.
Yes.
On the ground
Hmm.
that this written statement is page number starts from page 39, annexure C1.
Hmm.
Let the relevant portions, let para 8, page 45.
No, this counterclaim is allowed.
No. Suit is still at the stage of framing of issues.
Yes.
Now, after filing of this counterclaim, he wanted to shift a burden because once the counterclaim is filed, it is as good as a fresh suit in the eye of law, and every burden has to be, first initial burden has to be proved by the plaintiff therein.
Yeah.
But what he does is, after framing of this issue, he files an application under order for
Claim, what is this defense?
Let-
Counterclaim, what is that?
This defense is that I have the defendant number 18 has not executed any power of attorney in favor of the defendant number 19, and also no sale deeds have been executed.
No, what is that prior year sought
Yes,
by
yes,
counterclaim?
yes. Page 47.
Yes.
For a declaration. So and so.
Declaration that sale deed registered.
The very
document-
same sale deed, the burden has been cast upon him by virtue of additional issues framed on so and so date. Now he want to get away this issue by requesting the court to recast the same as per the impugned order. He want to recast it by an application kindly similar to his application. Now he wants to recast it. Page 62, annexure E. Whether the defendant number 18 to 20 prove. But once the counterclaim is prayed, he is requested to initially.
That why the plaintiff has to be proved?
No, not the plaintiff. Defendant number 17. It is not with regard to the plaintiffs. It is a inter-alia dispute.
What has happened? This issue has been.
Now recasted. Order to be recasted, a burden is shifted upon me. Kindly similar to the impugned order. When there is a counterclaim.
No, that is burden has to be him to prove.
Him to prove.
Yes.
Now it has been discharged to me. Onus is been
Where
shifted.
is that?
Let you lost me kindly turn to the impugned order.
He has before the court, then he has to.
Yes. The issue has been recasted. Last operative portion. The additional issues are framed and the additional number issue 3 is recasted. That can't be permitted.
Heard. Issue notice. Stay of further proceedings in OS number 561 of 2019. Pending in the file of third Arsenal City Civil Judge, JMFC Mangalore. Till next date of hearing.
Look, I am only seeking notice as against respondent number 20, defendant number 19 before the trial court. It is because it's application. ಬಾಕಿದವರಿಗೆಲ್ಲ ನಾನು ನೋಟೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅದಕ್ಕೆ ಮೆಮೊನೇ ಬೇಡ ಅಂತ.
Memo ಕೊಡಿ. Yes.
ಮೆಮೊನ ಹಾಕ್ಬೇಕು ಇದರಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಕಾಸ್ಟ್ ಐಟಲ್.
Filed in a memo, dispensation of notice to so and so is dispensed. Issue notice to so and so. Yes.
Public.
Submission is accepted. Office of.
Serial number 25, Nagaraj RC. And for the.
Please, sir.
I may be permitted to appear for the respondent filing.
Yes.
Dispose of the matter, Lord.
Yes.
Now
What is this?
Suit for declaration. The facts, Lord, the petitioner husband, Paramchwaya.
No, you suit for declaration.
Declaration.
Now
One
what
is
has
declaration, another is my suit is for eviction.
Now what is that?
10,
stage?
12 facts are available. 10, 12, 2010, Lord, I purchased the suit
That
property.
is not necessary.
Alala, suit property. And same day he has executed the rent agreement. Mane irlilla, rent. Immediately I filed.
What is the stage, Mr.?
Stage in arguments. Arguments.
No,
128, page number
My lord,
128.
I have the document, my lord. Your lordship may kindly peruse this application, my lord. My lord.
Very easy.
Court of.
Kindly see the page number 128. my lord.
128.
128.
My lord.
Only
Wait,
15,
One submission, my lord.
Wait, Bertin.
15, 10, 24 in there.
15/10/24. ಅಲ್ಲಿಂದ ಕ್ಲೋಸ್ ಫಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ಫಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ಅಲ್ಲಿಂದ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಹೋಗುತ್ತೆ. ಒಂದ್ ಸರಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ. ನಾವು ಐ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಅಲೋ ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್, ಕ್ಯಾರಿಡ್ ಔಟ್ ಆಗುತ್ತೆ. ಮತ್ತೆ ಅಗೈನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡಲ್ಲ.
Full argument for argument.
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
In-depth arguments. Now that everything is completed.
Everything is concluded.
That is not the fact, my lord.
Concluded.
My lord, I may be permitted to submit, my lord.
Yes, what is this?
My lord, in my learned friends suit, my lord, they filed a writ petition before this honorable court.
Oh.
4 years they have dragged on this suit before this honorable court for the issue of, my lord, court fee. They have not, my lord, proceeded their suit, my lord, before this honorable court for compounding the, my lord, stamp duty of the this one. Later, my lord, the writ petition was disposed of. Later, my lord, this honorable court has passed an order on
2014 and 15. 2014-15.
I will submit, my lord.
Yes.
I will submit. Then the remanded back, my lord. That is not, my lord, on the part of the respondent here.
Yeah.
My lord, my suit, my lord, for declaration. My lord, several applications filed by both the parties.
No.
My lord, ಒಂದ್ ನಿಮಿಷ ತಾಳಿ ಸ್ವಾಮಿ, ಎಲ್ಲದಕ್ಕೂ ನಾನು ಏನ್ ಮಾಡೋದು? ಅವ್ರು ಮಾತಾಡ್ದವ್ ನಾನೇನು ಮಾತಾಡ್ಲಿಲ್ಲ
ಅಲ್ರಿ, ನಿಮ್ದೊಂದ್ ಸೂಟ್ ಅವ್ರದೊಂದ್ ಸೂಟ್ ಎರಡು.
ಹೌದು, 2 ಸೂಟ್ ಇದೆ. ಅದಕ್ಕೆ ಇವರು ಮಾಡಿ ಅಂತ ಹಾಕ್ತಿದ್ದಾರೆ. My lord, I have filed an application, my lord, right now. This application, my lord, went for hearing for 2-3 times before the trial court. We cooperated. My learned friend is also cooperated. Now the matter is posted for hearing on IA.
No.
That IA.
He has filed a suit for declaration.
No.
I have filed for a declaration.
Nimda?
Nandu eviction.
Eviction application.
For eviction.
Only suit for eviction.
ಎರಡನ್ನು ಕ್ಲಬ್
I am the owner of the property.
ತಡಿಯಪ್ಪ, ಎರಡನ್ನು ಕ್ಲಬ್ ಮಾಡಿದಾರಾ?
2 ಕ್ಲಬ್ ಮಾಡಿದ್ದಾರೆ, ಜಾಯಿಂಟ್ ಆಗಿ ನಡೆಸ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರದ್ದು ಏನಾಗಿದೆ ಅಂತಾರೆ, ಅವ್ರು ಡ್ರ್ಯಾಗ್ ಆನ್ ಮಾಡ್ಬಿಟ್ಟು ಇವಾಗ ಅವ್ರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೋಗಿದೆ.
ನಿಮ್ ಸೂಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ?
ನಮ್ ಸೂಟ್ ಅಲ್ಲಿ ಈಗ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ಸ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಐಎ ಮೇಲೆ. ಅದು ರಿಬಟಲ್ ಎವಿಡೆನ್ಸ್ ಆಗ್ಬೇಕು. ರಿಬಟಲ್ ಎವಿಡೆನ್ಸ್ ಆಗಿದ್ದಾದ್ಮೇಲೆ ಅದ್ರ ಮೇಲೆ ಕ್ರಾಸ್ ಆಗ್ಬೇಕು. ಕ್ರಾಸ್ ಆಗಿದ್ದಾದ್ಮೇಲೆ ದೆನ್, ಮೈ ಲಾರ್ಡ್, ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಅಗೇನ್, ಮೈ ಲಾರ್ಡ್, ಫಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆನ್ ಮೈನ್ ಮ್ಯಾಟರ್. It will take another, my lord. I request, my lord, I am not coming on the way for dispose of the writ petition. There is a trial court, my lord, at least for, my lord, 2 years, my lord. Otherwise, my lord, he is, my lord, pressurizing the court because, my lord, thousands of cases before the trial court.
Your suit number is what?
My lord, 287 of 2012.
Where is that order sheet in respect?
My lord, my order sheet has been only produced, my lord, my learned friend. ಇನ್ನೊಂದ್ರದ್ದು ಹಾಕಿಲ್ಲ, ಅವ್ರದ್ದು ಹಾಕಿಲ್ಲ.
ಕ್ಲಬ್ ಆಗಿದೆ, ಕ್ಲಬ್.
ಅವ್ರದ್ದು ಹಾಕಿಲ್ಲ.
ಲಾಂಗ್ ಬ್ಯಾಕ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್.
ಎಲ್ಲ ಒಂದೇ ಅಲ್ಲ ಅಂತ.
ಅಲ್ಲ, ಅವ್ರದ್ದು ಸೂಟು. ಸಾರಿ,
1111.
ಐ ಆಮ್ ಸಾರಿ,
1111.
287 of 2012 ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ನಂದರ್ದು ಹಾಕಿದ್ದಾರೆ. Because it is a declaration suit, my lord. Several, my lord, issues was framed in my suit only in the year 2022, my lord.
Mister, in your case itself, it is posted for argument.
ಹೌದು.
No, my lord, I have just produced, my lord, application for rebuttal evidence.
129 ಏನ್ ನೋಡ್ರಿ?
ಅಲ್ಲ, ಅದು ಯಾವಾಗ ಓಲ್ಡ್ ಡೇಟ್ ಹಾಕಿದ್ದಾರೆ. My lord, application we have filed, it matter was argued by learned friend and is posted for application orders for EA number 18, my lord.
Page number 128.
EA number. Status, my lord, I have now.
ಎಲ್ಲಿಂದ ಬರ್ತಾರೆ? 15/10/24 ಅಲ್ಲಿ.
My lord,
ಆರ್ಗ್ಯುಮೆಂಟ್.
ಏನಿದು?
my lord, I just, my lord, take down the.
ನಾವು ಮೈಕ್ ಬೇರೆ ಕೊಟ್ಟಿದೀವಿ, ಒಳ್ಳೆ.
I am sorry, my lord.
ಇದ್ರಲ್ಲಿ ಮಾಡ್ದಂಗ.
ಅದರಲ್ಲಿ third argument for IA number 18. For orders by 3/4/2024. It's not for argument, my lord.
No, now what is that application you have filed?
I have for the income tax officer. Income tax department. These are also very much relevant documents. Before the trial court to summon the document and adjudicate the income tax department evidence.
At what stage, mister?
ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ.
ಆಯ್ತಪ್ಪ, ನೀವೇನ್ ಅವ್ರನ್ನ ಆರ್ಗ್ಯೂ ಮಾಡತ್ತಿ, ನೀವು ಆನ್ಸರ್ ಮಾಡ್ತಿರಲ್ಲ. ವಾಟ್ ಇಸ್ ದಿಸ್? ಫಾರ್ ಹೌ ಮೆನಿ ಇಯರ್ಸ್ ಯು ಆರ್ ಪ್ರಾಕ್ಟಿಸಿಂಗ್ ಇನ್ ಹೈಕೋರ್ಟ್?
ಐ ಆಮ್ ಸಾರಿ.
Yes. No, 2012 matters, suit for eviction, you are dragging that matter. ಅವ್ರ ಎವಿಕ್ಷನ್ ಹಾಕಿರೋದು. See, ಅವ್ರ ಎವಿಕ್ಷನ್ ಹಾಕಿದ್ರನ್ನ to avoid, you filed an application for declaration. Yes. 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 No, I will direct both the suit to be disposed of within 1 year, Mr.
ಅಲ್ಲ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದರ ಆಲ್ರೆಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಕನ್ಕ್ಲೂಡೆಡ್, ಎಲ್ಲ ಕನ್ಕ್ಲೂಡ್ ಆಗಿದೆ, ಎಲ್ಲ ಕನ್ಕ್ಲೂಡ್ ಆಗಿದೆ, ಎಲ್ಲ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಕನ್ಕ್ಲೂಡೆಡ್. ಒನ್ ಸಬ್ಮಿಷನ್ ಬಿಡು.
Wait, I will secure the records from the trial court.
ಬೇಡ ಸರ್, ಇಟ್ ಇಸ್ ನಥಿಂಗ್ ಬಟ್ ಸ್ಟೇ.
Yes.
ಅಲ್ಲಲ್ಲ ಬೇಡ ಸ್ವಾಮಿ, ವಿತಿನ್ ಒಂದು 2-3 months ಅಲ್ಲಿ ಇಟ್ ಇಸ್.
Yes.
ಅಲ್ಲಲ್ಲ ಒನ್ ಸಬ್ಮಿಷನ್ ಬ್ಲಾಟ್, ಒನ್ ಸಬ್ಮಿಷನ್. ಇಲ್ಲ, ನಾನು ಒನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಟ್ಟು ಸಬ್ಮಿಷನ್. ಅಲ್ಲ ಸ್ವಾಮಿ, ಒನ್ ಸಬ್ಮಿಷನ್. ಲೆಟ್ ಹಿಮ್ ಪೇ ದಿ ರೆಂಟ್ ಬ್ಲಾಟ್, ಲೆಟ್ ಹಿಮ್ ಪೇ ದಿ ರೆಂಟ್.
ಅದಕ್ಕೆ ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್.
ಅಲ್ಲ ಮತ್ತೆ ಇದು.
Yes, ಅದು ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಲ್ಲ ಕೊಡ್ರಿ. ಹೈಕೋರ್ಟ್ ಕೆನಾಟ್ ಡೈರೆಕ್ಟ್ ಫಾರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟು ಡಿಸ್ಪೋಸ್. ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್. ಕೊಡ್ರಿ. ಅದೆಲ್ರಿ ನಮ್ಮ ಇವರೆಲ್ಲ ಆದ್ರಿ. Tomorrow I will pass an order on that. There is a Supreme Court direction. High Court should not direct the trial court to dispose of the suit. Yes, it is for the trial court to pass an order. Yes, I will dismiss it, Mr. Yes, tomorrow. Yes.
Cell number 26.
Yes.
Joseph Anthony for petitioner. Prakash Nayak.
For the petitioner, your lordship.
Yes.
Your lordship, this matter had been disposed of by your lordship
Yes.
earlier, giving a direction to the trial court to
Yes.
dispose of the matter by 3rd March 2025.
Yes.
The miscellaneous appeal, 1 of 25. However, your lordship, arguments spilled over by a few days.
So that what is the stage now?
It's for final orders, for judgment, your lordship.
Judgment. It is
Judgment.
reserved for judgment.
Your lordship filing a memo with the last date's daily order in the miscellaneous appeal. It is posted for judgment on
No, they are seeking
on
only
7th,
6
4th.
6 weeks for extension. We'll grant it. Yes.
Your lordship, just one humble submission, your lordship. We had approached this honorable court by way of the writ petition because there was some urgency in the matter.
Yes.
Already it has exceeded the date fixed by your lordship. Lordship, we pray that a direction be given to pass the judgment by the date they have already assigned, which is 7th of April.
7th of
April.
Where is that?
In the memo I just filed, your lordship, they have posted it for judgment on the trial court has posted it for judgment on 7th of April.
7th
Last page, your lordship, of the memo. Page number 10.
Page number 10.
Yes, your lordship. Our only humble request is that it may be directed that judgment may be passed by 7th of April.
7/4.
Otherwise, the very purpose of approaching your honorable,
They have asked 4 weeks, Mr.
4 weeks. Very well, your lordship. As long as they adhere to the time.
My order is end on 3/3/2020. Then 5 weeks has to be extended for 7. That's why they asked that.
Please, your lordship, as long as that
Yes.
timeline is stuck to.
This court by order dated 10th February 2025 has directed the trial court to dispose of the appeal MEA number 1 of 2025 as expeditiously as possible, not later than 3/3/2025. The registry has received a communication from 7th Additional District Session Judge, Bangalore, seeking further extension of the time of 6 weeks' time. In view of that communication dated 28/2/2025, the further period of 5 weeks is been extended from today. Yes, further period of 5 weeks is extended. Yes.
Your lordship, just one humble request. If it can be directed, please, that the matter, that no further extension may be sought for or granted.
Now, I think they will pronounce on 7th. The date has been given on 7th.
7.
But 7th will cross that limit, time limit given by this court. Therefore, they are asking for an extension. That's all. They will do it on that day. Yes. Therefore, I have extended only 5 weeks. Now they can't ask further time. Yes.
For the time.
Cell number 27.
Authorized.
Ala Shetty Jagdish for petitioner. Arun Govindra.
Yes.
The last occasion, my lord, I mentioned, raised the question of maintainability of the writ petition.
Yes,
Order 7, Rule 11 application has been allowed.
yes,
Writ petition is presented, my lord, before your lordship.
yes, yes. Office is not raised objection.
Office has not raised the objection.
Then, that is what that law, Mr. In CPC, Order 7, Rule 11. Yes.
Yes. No, my lord, what my learned friend is pointing out is that, my lord, the rejection of plaint order, Lord, since it is a decree, hence it is appealable. Lord, that is under CPC. Now, my lord, may please see the Commercial Courts Act. Commercial Courts
No,
Act.
it's in a commercial court.
Out.
No, commercial court act, even appeal, you have to go before the division bench.
Kindly see section 13 is what I'm saying.
Yes.
For appeal, I have to go before the division bench, correct, in appeal. Now, Commercial Courts Act. 13.
Yes.
Yes. Now, what my learned friend says is that appeal has to be filed under 13(1) capital A.
Yes.
I read, any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising original civil jurisdiction, or as the case may be, commercial division of a high court, may appeal to the commercial appellate division of that high court within a period of 60 days from the date of the judgment or order. Two things are mentioned. One is judgment, another one is order. Here I am before my lord challenging the order. And now the proviso to section 13(1)A says, provided that an appeal shall lie.
It has been called an order, but it is in a decree.
It's a decree, correct?
Not that it has been, what is the meaning of decree has been explained and said that any rejection of the plaint, it's in a decree, therefore appeal has to be filed.
It's not so is what I am pointing out, my lord. It's not. Please, ma'am.
Yes.
Yes. Provided that an appeal shall lie from such orders passed by a commercial division.
No, no doubt. If
Yes,
it is an
correct.
order,
Does not fall under 43, order 43. My lord, petition lies before this.
Yes, this
Yes.
is a decree. That's what he is saying. that-
He says
That's
this
what
is
we
a
are also understood that. Let us see that.
Yes.
Yes.
Now,
Order passed under Order 7, Rule 11.
11.
It is not in a decree, it's an order, any authority you have, judgment.
My lord, it is a.
Any
even if
judgment on that point.
Right, ಅದು ನಾನು ನೋಡಿದ್ರೆ ಸಿಗ್ತಾ ಇಲ್ಲ ನನಗೆ. I'm to be true to the court.
Otherwise, there
True
is
to
a
the court.
judgment that it is in a decree.
Right, 1 second. Please. Now kindly see subsection 2 of the Commercial Courts Act. Notwithstanding anything contained in any other law for the time being in force, no appeal shall lie from any order or decree otherwise than in accordance with the provisions of this act. Now, my lord, we cannot bank upon CPC, say section 2 says so, and hence you have to file an appeal. My lord, I'm not filing appeal under section 96. Kindly see section 96 of the CPC. Section 96, interestingly says, my lord, it starts with part 7. Part 7 appeals. Appeals from original decrees. Appeal from original decrees, save where otherwise expressly provided in the body of this court or by any other law. Now I say, my lord, that or by any other law, my lord, Commercial Courts Act. Commercial Courts Act, 1A proviso says order. If the order does not fall under order 43, my lord, the petition lies. If, my lord, I am filing an appeal under section 96, if it is original decree, my lord is right, my friend is right. But here is a case where, my lord, the rights of the parties are not, my lord, decided. What is decree under section 2(2)? My lord, the attributes of a decree, my lord, is not found under the order that I am challenging before my lords. Decree means, my lord, may please see section 2(2).
Yes.
The formal expression of an adjudication,
Yes.
which so far as regards the court expressing it,
Yes.
conclusively determines the rights of the parties.
Yes.
My lord, where my rights are determined in this case? This is an order rejecting my plaint on the ground of limitation. My lord, what is rights of either parties are not decided. Hence, my lord, it is not a decree in its a true sense, my lord. That we need to, my lord, understand and say, my lord, that if we apply, my lord, the literal rule, my lord, what they are saying is absolutely right. My lord, in this case, my lord, the purposive interpretation should be, my lord, applied so as to say that where the rights are not decided. Let us understand a situation where, my lord, I file an appeal. It is against a decree as the.
You have any judgment on that point?
One second. Other ನೋಡ್ತಾ ಇದ್ದೀನಿ. One second.
Argument, what is degree and all, we have learned and so many this thing. Now, you have any judgment to show that order passed under order 7 rule 11 is not in a decree? Any judgment on that point?
But so far, my lord, in 2 ದಿನ ಹುಡುಕ್ದೆ ಸಿಕ್ಕಿಲ್ಲ ನನಗೆ.
What is this? Yes.
Well, ಇನ್ನೊಂದು point may make an attempt, my lord.
Yes.
And means on this point,
Yes.
my lord, I have given some consideration on this.
Yes.
My lord, if the rights of the parties are not decided, my lord, can we call it as a decree? Is what, my lord, I am trying to, my lord, impress upon.
Yes.
My lord, here is a case, my lord, on the ground of limitation, straight away at the threshold, my lord, my plaint is rejected.
Yes.
Now, if I file an appeal,
Yes.
whether I am a decree holder, if I succeed, whether I get the prayers that I have, my lord, sought for in my plaint,
Yes.
no, I will be directed again back to the trial.
I will give a time to find out that this is not in a degree. Therefore, my right has been not determined. You can come up with a judgment.
Please.
Let us see what.
Please.
Yes.
Section 2. During the last bit of section 2. Decree means the formal expression of adjudication, which, so far as regards the court expressing it, conclusively determines the rights of parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include rejection of a plaint.
I agree with
CPC
that.
says, my lord, this is interpreted by the Honorable Supreme Court.
Yes.
In the first citation, note 2016, part 6 SCC, Rishabh Chand Jain,
Yes.
para 13, page 5.
Yes.
In terms of section 2.2 of the code, in case the court adjudicating the case conclusively determines the rights of parties with regard to any one or all, or any one or more or all of the matters in controversy in the suit, the requirement of decree is satisfied. Such determination can be preliminary or final. Rejection of a plaint is deemed to be a decree under section 2.2 of the code.
Now, provision itself says it is.
I'm not disputing that.
Then,
not
if you are
para
not
14.
disputing, then.
No, I am not. No, I am.
Para
No,
14,
kindly
15.
see, my lord, please appreciate this
Lordship
point.
permits me, my lord. I will.
Yes, I
Yes,
will
let him complete.
There are 2 other citations exactly on the point of maintainability of a writ petition in case of rejection of plaint before a commercial court.
Yes.
That's the judgment of the Calcutta High Court, my lord,
Yes.
page 8. Writ petition was rejected. An application to recall was filed, placing reliance on the proviso to section 13(1)(1)(a).
Yes.
So this is, may I read, my lord? Page 8, may I read?
Page 8. Yes.
Page 8. A very interesting point has been raised by the petitioner in the recalling application. The question which has been put for adjudication before court is whether pursuant to the provisions of section 13, read with section 21 of the Commercial Codes Act, an appeal shall at all lie against an order of rejection of plaint, although it is deemed decree as per section 2 of the Code of Civil Procedure. Learned counsel appearing for the petitioner argues that section 21 stipulates that the 2015 Act has overriding effect on anything inconsistent therewith contained in any other law for the time being in force, or in any instrument having effect by virtue of any law for the time being in force other than this Act. Section 13 of the 2015 Act, on the other hand, stipulates that any person aggrieved by the judgment or order of a commercial court may appeal before the forum as provided in subsections 1 and 1A of section 13. However, it is contended that proviso to subsection 1A clearly enumerates that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure.
Yeah.
As such, it is argued that a dispute may crop up if an appeal is preferred by the petitioner before the competent forum as regards the maintainability of such appeal in view of the provisions of section 21 of the Act. Exactly what my learned friend is stating. Although there is sufficient scope of confusion over the matter, which might have led to the filing of the application under Article 227 of the Constitution of India, a complete reading of the entire scheme of 2015 Act makes it clear that the contention of the petitioner cannot be accepted. A conjoint reading of sections 8 and 13 of the Act clearly indicates that there is a bar against revision or petition against interlocutory orders of a commercial court, although there is substance in the argument that such bar may not be applicable to a constitutional remedy such as Article 227 of the Constitution of India, since 2015 Act is a subordinate legislation under the aegis of the Constitution. The question which arises next is whether the impugned order is an interlocutory order simpliciter or a judgment as contemplated under Section 13(1) of the 2015 Act. The proviso to subsection 1A of the 2015 Act clearly indicates a clarification that orders which are appealable under Article 43 of the Code shall also be appealable under the 2015 Act. Section 16 also holds the key to the interpretation of the question which has arisen herein. Subsection 1 of subsection 16 of the 2015 Act stipulates that the provisions of the CPC 1908 shall, in their application to any suit in respect of a commercial dispute of a specified value, stand amended in the manner as specified in the schedule. It is noteworthy that the schedule does not mention any amendment to Section 2 of the Code of Civil Procedure, which section stands in its original form despite the introduction of the 2015 Act. Subsection 2 of Section 16 of the 2015 Act further clarifies that the commercial division and commercial court shall follow the provisions of the Code of Civil Procedure as amended by that Act in the trial of a suit in respect of a commercial dispute of a specified value. The above provisions clearly indicate that an order of rejection of plaint is not an interlocutory order, since it is a deemed decree under Section 2 of the Act Code, which remains unamended by the 2015 Act, but is a judgment as contemplated in Section 13(1) of the 2015 Act. The proviso to Section 13(1)A does not restrict the right of appeal only to orders which are appealable under Order 43 of the Code, which interpretation will be observed, since in that event, decrees passed by commercial courts can also not be appealable. Keeping in view the cumulative interpretation of the aforesaid provisions, it is evident that an order of rejection of plaint is neither an interlocutory order as envisaged in Section 8 of the 2015 Act, nor an order as contemplated under 43 of the Code of Civil Procedure. However, no confusion can arise as regards such an order of rejection of plaint being a decree as contemplated within the definition of Section 2 of the Code of Civil Procedure, which remains unamended by the 2015 Act. Hence, there cannot be any doubt that Section 13(1) and 13(1)A, as well as Section 16 of the 2015 Act, are applicable to an order of rejection of plaint is a deemed decree and hence a judgment as contemplated in the said subsections of Section 13 of the 2015 Act. Thus, such an order is appealable before the competent forum as contemplated in Section 13 of the Act of 2015. In such view of the matter, the finding rendered in the order sought to be recalled regarding application under Article 227 of the Constitution being not maintainable against the imputed order of rejection of plaint holds good.
All questions has been answered.
The
So
very
this is from
contention
which-
raised by my learned friend has been answered.
Yes.
It's not
This is
so.
from which court?
Commercial.
Calcutta High Court, Manoj.
Calcutta High Court.
Calcutta High
Subsequently,
Court.
the Jammu and Kashmir High Court also has the next judgment, Manoj.
Apart from that, my lord,
Yes.
apart from
Para
that,
6 at page 19.
Wait, let him.
what?
Para 6 at page 19.
Yes.
Keeping in mind they refer to order section 2(2).
Yes.
Keeping in mind the aforesaid position and principles of law and reverting back to the case on hand, it is not in dispute that the plaint of the plaintiff petitioner herein came to be rejected to the trial court in terms of the impugned order under Order 7 Rule 11 CPC, and the same under Section 2(2) CPC is deemed to be a decree, and a decree is appealable in terms of Section 96 read with Order 41 of the CPC, as it is a decree against which an appeal lies, being the settled position of law, and the view of the apex court as laid on the case titled Jagadish Bhargava. It is thus clear from the aforesaid provision that no revision would lie against rejection of plaint, even if it is found that the trial court, while passing the impugned order, has committed any procedural irregularity, as had been held by the apex court in case titled Rishabh Chand Jain. This is
Yes. Yes, this is Calcutta High Court has extensively held that.
exactly on the point of section 13(1)A proviso.
Yes, Mr.
Now, my lord, may please see, my lord, my petition, my lord, how this happened. I submit that there is a miscarriage of justice. And my lord, the jurisdiction of this court under 227, my lord, the constitutional remedy, my lord, is not barred, even otherwise also. Now, kindly see, my lord, that what the learned trial court judge says, that the plaintiff ought to have filed the suit within 3 years, since it is filed after 3 years.
No, I'm not on that.
And I'm not saying that. I'm not saying that. But this is, I'm referring to
Yes.
that, my lord, the trial court, my lord, failed to take into account the judgment of the Supreme Court.
Yes.
Judgment of the Supreme Court as page number 50,
Yes.
Annexure Z. Now kindly come to, my lord, One
See,
second.
No, I don't want to waste the time on
No,
this.
I am
Only
also-
maintainability, if you want to argue.
I'm
you
also
argue.
not, absolutely not. I'm last person to do that.
Yes.
I am on miscarriage of justice. That, my lord, when the COVID period was there, Supreme Court said, you exclude 2-year limitation.
Yes.
This is on maritime right limitation. So when there is a direction to all the courts, including the High Court, that exclude this period from 15/3/2020
You will have an alternative efficacious remedy before bench, not single judge. They can be heard and yes, that's all.
Lord may have it on Saturday, my lord, if I find any
But-
any judgment.
No,
If
this
I-
is what to clear.
ಅಲ್ಲ
See,
ಕ್ಲಿಯರ್ ನಾನು ನೋಡ್ದೆ ಇನ್ನು ಎರಡು ದಿನ ನಾಳೆ
ಏನ್-
ಸ್ಯಾಟರ್ಡೇ ಇಸ್ ವರ್ಕಿಂಗ್ ಡೇ ಮಲೋಡ್
ಈ-
ಐ ವಿಲ್ ಕಮ್ ಅಂಡ್ ಸೇ ಮಲೋಡ್ ಐ ಅಕ್ಸೆಪ್ಟ್ ಆರ್ ಎನಿ ಜಜ್ಮೆಂಟ್ ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್
yes,
ಅಷ್ಟೇ ಮತ್ತೆ ಐ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಮಚ್ ಟೈಮ್ ಆನ್ ದಟ್
yes. When do you want?
ಸ್ಯಾಟರ್ಡೇ
Yes, Saturday. Day after. See, only confusion is there, the word is degree is not used, only a judgment. That has been, otherwise, there is no appeal against that order of that commercial court. That is not the intention. That was extensively considered by that Kolkata. Yes. Great. No, your attempt is right, but that has already answered by that court. Therefore, yes.
Bill number 28, Vamshi Krishna C for petitioner, connected matter, Rajeshwara PN.
Appearing for the petitioners, my lord.
Yes.
Hearing for respondent, my lord, 1 to 3 in
Yes.
connected matter WPD 33594 of.
Yes.
2024. But,
My lord.
in this case, I seek for a week's time to file the objection. For this reason, my lord, though the order is not against me,
Yes.
respond number 1
Not
to 3.
against him, my lord.
But in effect, my lord, all these
It's a very interesting point of law
orders
that comes
which
for
had,
consideration of this honorable court, my
which
lord.
which
The
were
impugned
passed, my
order.
lord, it is because of the application which is filed by me.
Yes.
It is
When
for
do you
that
want?
reason.
When do you want? Yes.
So
My
next
lord,
week,
if I may just
any date
bring
may
to
be
the
fixed, my
notice
lord,
of this honorable
by that
court,
time I will
the point of
file my
law that is
objection.
involved here, very minimal point of law, whether LRs of a deceased plaintiff can file an application under 1 Rule 10 or under Order 22 Rule 3. This is the limited point for consideration of this court, but this is the second time they're seeking time.
No, my lord, I have not said,
No, I think there is a judgment on that point.
no.
There is one
This-
Andhra Pradesh High Court judgment of 1992 where this specific point has been considered. I'll place it before my lords.
Lord,
My lords, if I may just place that one.
next week, my lord, it may fix. Because in this case, what had happened, it is not on that point.
Compilation of judgments I have.
We have served. No.
Whether LRs of a deceased plaintiff can come on record by virtue of Order 22 Rule 3 or 1 Rule 10. My lords may be looking at the Sumati judgment, my lords.
Yes.
There is a 1992
Hmm.
Andhra Pradesh High Court judgment.
Hmm.
I'll take my lords only to the first paragraph and last paragraph.
No, that your application is filed under which provision?
I am the defendant in this, my lords.
Hmm.
The suit is actually for a suit for declaration
No, they have filed an application in which provision?
under 1 Rule 10, my lords.
That has been allowed,
Allowed. my lords.
but
On the ground that it is a transposition application, not even direct impleading. So there are certain,
no, see, they can be implemented under Order 22. Just mentioning that wrong provision which will not that vitiate.
I completely
Only
go down to what
thing
my
is
lord
that
is saying.
court has any power or not, that is there.
I
Then-
go down to what my lord is saying. The only point that needs to be considered is when such a legal representative of the plaintiff chooses to file an application under 1 Rule 10, he needs to establish an independent legal right for 1 Rule 10 to be considered. Otherwise, his right is directly from the rights of the deceased plaintiff. And as such, it must be under 22(3). As long as that independent right, if it has been established or not, is the only point that needs to be seen. And in this case, I would establish by that that independent right was never set up by the
No, they are
impleading application.
claiming any independent right or
No,
they
they're
are
not.
substitute.
They're not. They're merely asking for substitution.
Then it is provided under 22.
Exactly.
That has to be treated.
That is
under-
entirely my case. That is my case.
No, that application has to be treated under 22.
Absolutely. But
On-
it has been treated as one rule 10 and they have been now implemented as defendants. But here, the rights that they're claiming through is of a deceased plaintiff.
No,
There-
plaintiff is dead.
Plaintiff is dead.
No,
But
LRs is not brought on record.
there are other LRs already on record. These are grandchildren of certain other, there are other LRs, my lords. These proposed defendants are other LRs.
No, they are not claiming or impleading that they are the LRs of the deceased. They are
Yeah.
impleading, they have any rights in that.
Through the deceased person.
No.
No, I will show the application. my lords.
Ready, mister?
Next week, it may be. But
Yeah,
because
who is contesting?
it
You
is-
are,
Milord, though they are the person.
no, who has filed, who is that LRs? Impleading applicants ಯಾರು ರೀ ನೀವು ಅವ್ರಿ
ನಾನಲ್ಲ ಸ್ವಾಮಿ, but for the first
They are the
time,
existing
for the
plaintiffs,
first
my
time,
present plaintiffs.
ಆಯ್ತು ರೀ
for
Mr.
one reason, I want to file objections. In this case, what has happened, my lord? Plaintiff, my lord, plaintiff number 1 died. Plaintiff number 3 to 4 were their children who were already on record. My lord, at that point of time, we filed memo and also application saying that already they are there on record. Kindly treat them as LRs. The defendant, the petitioners herein, my lord, filed objection to that. They continued saying that no, there are other grandchildren. We have to bring them on record. My lord, rightly or wrongly, at that point of time, without any wakalat or anything, what we filed, there are who are the other grandchildren were there. We also filed an application saying that these are the grandchildren who are there. Without there being any wakalat on or not being represented, no notice was sent to them or anything. Court also did not notice, and thereafter, my lord, they were made as plaintiffs in the same suit as they were brought on record. Thereafter, we came to know that this has happened. My lord, we pointed to court. At that point of time, these defendants came before the court. When we asked for the wakalat, they said they don't want to contest, they don't want to go along
That
with
is
other
exactly my
plaintiffs.
case. That they were never on record before the court, and
because-
as such today,
So,
today
I want
they
to
have to
clear
step
my
in.
objections
You are
for
ready,
the court.
mister? You are ready?
ಇಲ್ಲ ನಾನು ಅದು objections ನಾನು ಅದನ್ನ ಹಾಕದೆ
ನಮ್ದು ಅದರಲ್ಲಿ ನಾವು ಕೆಲವು ಸ್ಟೆಪ್ಸ್ಗೆ ನಮ್ಮ ಪಾರ್ಟ್ ಇದ್ದಾರೆ ಅಂತ ಏನೋ ಹೇಳಿದ್ರು, ನಮ್ಮ ವಕಾಲತ್ ತಗೋಬೇಕು ಅವ್ರ ಸ್ಟೆಪ್ಸ್ಗೆ.
We have already served copies. We have
That in first matter, you are taking notice to whom, mister?
My lord, I have
28. This
They
is
have to take notice for the proposed defendants.
33594.
335
Proposed defendants 15 to 20.
1 to 3, my lord, I have
But
filed
but we have already served copies on all of them.
Wait.
Yes, no. Yes, ma'am.
Yes, you are, Rakesh, you are appearing
Please,
for,
lord, I appear for 1 to 3.
Rajeshwar ಇದಾರಲ್ಲ.
My lord, I am appearing
Four-
for Bharat Krishnappa.
4, 6 and 7.
My lord, Bharat Krishnappa.
1, 2, 3, 4. Who is appearing for 5?
My lord, I am appearing for
Now, what about that other respondents, mister?
I am appearing for the petitioners 1 to 13 are defendants 1,
No,
12 and 14
No,
before
you are
trial
the
court.
petitioner in that first matter.
Yes, my lords.
Then you show me that who are representing that respondents.
Yes, my lords.
1 to 3 is there. 4 is there. 5, nobody is representing.
No, my lords, I am representing parties up to
In your petition.
ನೀವೇನ್ represent
I am
ಮಾಡದ್ರಿ?
appearing-
ನೀವು
my
are the
lord, I am
petitioner.
appearing for respondent number 4, 6, 7,
ಆಯ್ತು.
8 and 9, my lord.
ಅಲ್ಲಿ 5 ಇದಾರೆ.
ಅಲ್ಲ 5 ನಾವು ಅಪೇರ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಅದೇ ಹೇಳಿದೆ 5 ಗಿಲ್ವಾ? 5 ಆಗಿಲ್ಲ.
5 ಇಲ್ಲ. 4,
ನೀವು
6, 7, 8 and 9, my lord.
8, 9 ಗಿಲ್ಲಲ್ಲ ನಿಮ್ಮ ಹೆಸರು.
ಅಲ್ಲ
ತಗೊಂತೀರಾ?
ತಗೊಳ್ತೀವಿ. 4, 6, 7, 8, 9.
4, 6, 7, 8, 9. ಅಂದ್ರೆ 5, 11, 12 and 13 notice has to complete, mister.
3 and 10.
Yes,
Only
other
10.
respondent.
Only 10.
ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳ್ರಿ ಫಸ್ಟ್. No, you don't want to serve to the respondent. Who is that? Show me that. All the respondent is served. What is this, mister? Not acknowledgement. Show me in the cast list, mister. Who is representing, who are the respondents? Till some respondents have, till a service has to be completed. Yes. Still that notice has to be taken to 5, 8 and 10. Yes.
I pardon if some confusion was created.
Yes. Not created, Mister. You have to be seen and assist the court.
Absolutely, my lord.
Yes. Week's time is granted to.
I beg your
In
pardon.
second matter, putri
Second matter, no, interim matter may kindly be extended, because both the matters, my lord.
second matter, no, service is completed.
Some service is completed, my lord.
Now, who is taking notice for second matter 5, 8 and 10? Who is appearing in your case, Mister?
ಅದು notice
there.
dispensation ಮಾಡ್ಸಿದ್ದಾರೆ.
He is appearing.
Yes.
Service is completed in.
Service is completed. You take notice in respect of R5, R8 and R10, Mister.
Please.
Yes.
Interim order may kindly.
Yes. Interim order granted earlier is extended till next date of hearing.
Serial number 29, Narasimha Murthy L for petitioner, Dushyant Aradhya HC.
Yes. Where is your, what about that process, Mister? Oh, to whom? No, 2 is dead, Mister. Yes. Dispensation of notice to R3, R5 and R6. Week's time is granted to take necessary steps to bring a loss of R2. Yes.
Serial number 30, Rakshita DJ for petitioner,
Yes. No, you have served to whom? By hand summons. Hand summons are right. In addition, petitioner requirement, take out an hand summons to R3. Have you served? Where is that acknowledgement? Notary. For having served that hand summons through that WhatsApp and email file, advocate for the petitioner. No, you have not taken hand summons. You are through the WhatsApp. Who is R3? No, in before that, before the trial court, who is appearing? Who is appearing for him? You have served a copy to that advocates. Yes. Learned counsel for the petitioner has filed in a memo, having sent that notice through WhatsApp and email, and also served in a copy, counsel appearing for respondent number 3 before the trial court. Yes. Defendant number? Yes, file in a memo. In service of notice to R3 is held sufficient. R1, you file in a memo. Yes. What is this matter? What is the suit for? Who? Yashodamma Kenchappa. Yashodamma Kenchappa is which respondent? No, Yashodamma Kenchappa here, which you are the plaintiff. Counterclaim, your rejoinder has not been permitted. Yes, where is that order? Page number 18. Now you come to that para 8. Yes. See, fourth defendant has filed a written statement on 25/4/2018. Third defendant filed a written statement on so and so. Case was posted for written statement of the plaintiff to the counterclaim for the, on 4/7/2019. Written statement of the plaintiff to the counterclaim of the third respondent was not as taken as not filed and 2023 present application. Now that the third respondent has filed filed a written statement along with that counterclaim. Counterclaim is on 2019, posted for written statement and counterclaim to the counterclaim by the third respondent on 4/7. Yes. 25/8/2019. 4/7. Time has been granted due to file. But the plaintiff counterclaim that to that respondent was not taken, not filed. 4/7/2019. Yes. On 2/3/25, present application has been filed. What are you doing till? Not during that COVID period. Filing as so and so. Now that what is the stage in the suit, madam? Yes, that. This petition is filed by plaintiff challenging order dated 7/8/2024. Whereby application filed by the plaintiff under order 18, rule 17, read with section 151 of CPC, to recall that order dated 4/7/2019 and permitted to file plaintiff to written statement to the counterclaim of the third respondent. The same came to be dismissed. Being agreed, plaintiff has filed suit for specific performance of the contract. On service of summons, defendant has filed written statement along with that counterclaim on 28/5/2019. Defendant number 3 filed a written statement along with that counterclaim on 29/5/2019. Thereafter, matter was posted on 4/7/2019. On that day, the plaintiff has not filed any written statement to the counterclaim. Sought some more time. Same has been refused. And it is taken as not filed. Therefore, the plaintiff has filed this application for recalling that order dated 4/7/2019. Seek permission to file written statement to the counterclaim of third respondent. Otherly, respondent has served and represented. The learned counsel for the petitioner submitted that matter is not yet to posted for evidence of the parties. If the plaintiff will not permitted to file a written statement to the counterclaim, it is difficult for them to defend their case. Since third respondent has filed a counterclaim on 28/5/2019. The plaintiff has all rights to file a written statement to the counterclaim filed by the third respondent. In this matter, the trial is yet to be started. If that application is allowed and that plaintiff is permitted to file a counterclaim, it will not cause any prejudice to that defendant. In view of the above, the writ petition is allowed. Order dated so and so is set aside. The IA number 19 filed by the plaintiff under order 18 rule 17 is allowed. Yes.
Serial number 31 disposed of. Serial number 32, Sheshadri NS for petitioner. 32.
Yes. Furnishing a PF issue notice. Formal part. Yes. Notice to so and so is dispensed. All others are served. What is this, mister? Hmm. 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 No, that you come to that plaint, para 10, page 10. What is the relationship between the plaintiff and defendant? No, relationship. Hmm. Hmm. Yes, one of the brother has filed a suit against their brother, wife and children. Brothers, yes, legally. Yes, you are the plaintiff. Yes, what is that application for amendment you have filed? Hmm. $35. Hmm. 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 Yes. Hmm. Hmm. Yes, now what is that you are challenging? Hmm. 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 Why they have sought for recalling? Hmm. Hmm. The counsel submitted that he has not submitted. He has not submitted no objection to allow that application, but the order sheet speaks. One submitted that no objection to allow that IA, but due to oversight, no signature of the defendant for us. Hereby allowed. Memo filed by the defendant is allowed. Recalled for the objection. Now that they have sought for an objection, let them now hear and pass an order. See, there is no a signature of the parties that they have given no objection. Now they are saying that they are not said. Now they have recalled, your application is restored. They will consider in accordance with law. What is wrong in that? Unless you have to prove that they have given a no objection, it cannot be. Now they are saying, carried out, that will be. What is the material to show that no objection they have given? They have not filed any memo. Their signature is not there in that order sheet. Now they are coming before the court said that we have not said. Then what to do? Yes, let them consider on merit. Aye, sorry. This petition is filed by plaintiff under Article 227 of Constitution of India, challenging that order dated 12/7/2024, passed by Senior Civil Judge Kolar in OS number 293 of 2001, whereby order dated 26/6/2023 is recalled. Plaintiff has filed a suit for partition and separate possession. During the pendency of the suit, plaintiff has filed an IA number
7, my lords.
page
IA number 7, my lords.
Who is he?
My lords, I am respondent number 4 and 5, my lords.
Respondent number
4 and 5, my lords. Contesting respondent.
4 and 5.
Yes, my
Number
lords.
ಎಷ್ಟಿದೆ?
7, my lords.
32 na? ಅವ್ರ ಹೆಸರು ಇದೆಯಾ? ಇಲ್ಲ sir. Your name is not shown, mister.
My lords, I am appearing in the trial court, my lords. It has been served on me.
No, that you have not filed any wakalat.
May leave may be granted, my lords. I'll pay the wakalat, my lords.
What is that leave granting here? Yes. You have no power. Then you
No,
have
they have served on me, my lords.
Yes. Yes. ಏನಿದೆ? Plaintiff has filed an IA number
7, my lords.
7. Where is that? Have you produced that copy?
Annexure C, my lords.
Filed IA number 7 under Order 6, Rule 17. 6 for an amendment. By way of amendment, he wants to delete defendant number 6 and also to delete item number 5. Said application has been allowed on the ground that defendant has no objection. Thereafter, defendant number 4 and 5 has filed a memo stating that they have not filed either memo for no objection to allow that application. Since no signature of that defendant number 4 and 5 has been taken on the order sheet, that they have no objection to allow that application, and they have not filed any memo. Therefore, trial court has allowed that they have not, their signature has not been taken. Therefore, the trial court has allowed that memo filed by that respondent number 4 and 5 on the ground that in the order sheet, it's by oversight, on the ground that they have not given any objection, no objection to that, allow that application. Therefore, the order dated 26/6/2023 has been recalled. There is no error or illegalities in the order passed by the trial court. Accordingly, writ petition is dismissed. The trial court is directed to reconsider that IA number 7 filed by the plaintiff under order 6 rule 17 in accordance with law. After giving opposite.
My lords, my name may be shown as G. Srinivas, my lords.
You file wakalat, Mr. Yes. Yes.
Bill number 33, Om Prakash BV for petitioner, V. Lakshmaya.
Steps await notice agide or appear.
ಯಾರಿಗೆ?
R2.
R2 ga?
Ah.
Yes. Yes, Mr.
I am for R1, my lord. My lord, this petition is filed 2824 in the.
They has filed an application for vacating.
Yes, my lord.
Vacating is dismissed in last hearing. Order passed is confirmed after hearing the respondent one. Now, once again, you can't agitate.
When that application is rejected?
In last hearing, my
Not
lord,
dismissed, my lord.
last hearing, he filed a application to vacate. My lord, this court heard it and confirmed the order of interim order. And hence that application is not maintained.
No, my lord, no, my lord.
Once again, you can't agitate
Before me only.
before yourself, my lord.
After arguments.
Yes, argument 18 to 25.
Is it, Mr.?
No, my lord.
Then,
I taken a copy, my lord, and searching.
ಆಯ್ತು ಏನ್ what has happened on that day?
On that day, ಸ್ವಾಮಿ ಇಲ್ಲಿ ಅವರು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ನಿಮ್ಗೇನ್ ತೊಂದರೆ ಮಾಡ್ಕೊಳ್ಳಿ ಬಿಡಿ, ಯಾಕೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಬಾರ್ದಾ ಅಂತ ಹೇಳಿದ್ರು. ಅದು ಹೇಳಾದ್ಮೇಲೆ ಆಮೇಲೆ ಆರ್ಡರ್ ಆಯ್ತು ಅಂತ ನಾನು ಹೊರಟ್ಬಿಟ್ಟೆ. ಆಮೇಲೆ ಆರ್ಡರ್ ನಾನು ಇದು ನೋಡಿದ್ಮೇಲೆ ನೆಟ್ಟಲ್ಲಿ ಸೊ ಸ್ಟೇ ಹ್ಯಾಸ್ ಬೀನ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂತ ಬಂತು.
Now what is this? Yes, what is this?
It's vacated, my lord. Stay should be vacated or heard. This petition is not maintainable at all, my lord.
Yes.
See, my lord, one thing, my lord, please permit.
ಆಯ್ತು ಆರ್ಗ್ಯೂ ಮಾಡಿ ನಾನು ಏರ್ ಮಾಡ್ತೀನಿ.
Yes.
Will hear you.
So, ಇದನ್ನ ತಗೊಂಡಿದ್ದು 2824 ನಲ್ಲಿ.
Yes, what is your case, Mr.?
My lord, first one on maintainability itself, I will take it. His objection, he is not an applicant in the trial court.
No,
How can he agitate before the honorable court?
No, you argue your case, Mr.
Okay.
Nice. Yes,
My lord,
what
this is a case of a suit for declaration and permanent injunction that the respondent number 1 and 2 has no authority to interfere in our association management College of Education in Tumkur. My lord, the education of the association was established in year 1972 and running a college. All of a sudden in year 1997, the respondent here in 1 and 2 started to interfere in the.
Where is that plaint?
Plaint, my lord, annexure E, my lord, page 31.
Yes, what is the prayer you have sought in that? Declare the defendant has no authority to interfere with the affairs of the management of the B.Ed College, Tumkur, and that plaintiff continue to be in secretary chairman, college education institution, restraining the defendant from granting a permanent injunction. Yes. Now what has happened?
My lord, the plaintiff led their evidence.
No, what is that order you are challenging now?
My lord, the impugn order permitting the third parties to lead the witness as a witness and lead evidence. My lord, defendant did not lead evidence. When defendant is not at all coming to the court, there is no question of third party filing an application and coming as a witness and leading evidence. That is my first ground.
Now, which is that order you are challenging?
Impugn order, my lord. Annexure D, my lord.
Annexure?
Annexure D, page 28. Page 28.
Yes.
Order 9/10/2023.
Application filed by the defendant number 124 under order 16 to 20 CPC seeking permission to file a witness list. That has been allowed.
Yes, ma'am.
Permitted to examine the witness named here in the next list. Yes, what is wrong in that?
My lord, he is not a defendant. Applicant is not a defendant. He has been impersonated and fraud has been committed.
No, it is said that defendant number 1, 2, and 4.
Yes, my lord, that itself is my objection. Defendant number 1, 2, and 4 have not at all filed an application. They have not sworn to the affidavit. The third party, 1B Lakshmaya, has sworn to the affidavit. That itself is an impersonation and fraud, the first ground.
Affidavit has been filed along with the application by the case. Nevertheless,
matter was brought to the notice of the court. Nothing has been said about the credibility of the petition. The cause and memorandum of facts has been filed by the advocate and no affidavit has been filed along with the application. Where is their application?
Application is page number 18, annexure B,
Page number?
18.
Yes. So and so. Yes, Mister, is it permissible to file in a memorandum of facts for application
Yes,
under order
permissible,
16.2?
Permissible way.
Which is that?
So that I also filed an application under Civil Rules of Practice 1967 or Rule 18.2, Chapter 3. In all interlocutory matters, the counsel is permitted to file affidavit or memorandum of facts before the court, provided that it shall not be necessary to file any affidavit, but only a memorandum of facts signed by the pleader in IS seeking relief other than the relief of temporary injunction, attachment, arrest, appointment of guardian, or the appointment of receiver, or amendment of pleadings.
No, where you are reading from where?
This is taken from the Civil Rules of Practice, that order 90 section, Rule 18.2. Rule 18.2, my lord.
Rule 82.
18.18.
18. Every interlocutory application shall be conducted by the IA shall be consequently numbered in suits appeal. All facts on which the applicant relief for making a prayer to obtain the relief sought in the application shall be set out in an affidavit accompanied by the application where the facts on which the application is based appear from the records appears in the court are related to that any act or conduct of the applicant pleader himself or permit the memorandum of facts signed by the to be filed instead of an affidavit. Yes, Mister, it is not necessary.
That is not a fact here. It is impersonation. Defendants are not at all coming for last 27 years to the court. They have not at all led any evidence. When main parties are not at all leading an evidence, how come a witness is only supportive? For the parties, witness is a supportive. When main party is not at all there, how come the witness come and lead an evidence?
No, show me any judgment that if main parties is not entered in a witness box, he cannot examine other witnesses.
Yes, madam.
Where is that?
1 week. 1 week.
You are arguing that you should be ready on that material.
ಇವತ್ತು ಸ್ಟೇಜ್ ಇದ್ದಿದ್ದು ಸಮನ್ಸ್
No, I will not extend that interim order.
ಅಲ್ಲ ಸಮನ್ಸ್ ಇತ್ತು ಅಷ್ಟೇ ಇವತ್ತು ಸ್ಟೇಜ್ ಸಮನ್ಸ್ ಇತ್ತು
No, he has filed a vacating application.
ಅಲ್ಲ vacating application was heard last time. Impugn order was stayed. My lord, this court come to
Copy has been provided by lord.
opinion.
Copy has been provided now. What I have taken setback.
This court came to know.
No, this court has granted an interim order only on your submission, saying that no affidavit has been filed by that parties. It is memorandum of facts filed that advocate. That order has been passed. Therefore, staying in that interim order.
My lord,
You see that civil rules of practice, only in certain extensions affidavit is required. Otherwise, advocate on record can be filed in a memorandum of facts.
my lord, last
That is what
occasion.
that.
ಅಲ್ಲ last
Now you
occasion.
say that
I'll get a ruling. I'll get a law also to forbidding a person who, without leading any main parties as evidence, the witness could not come directly lead an evidence.
that is your case, is it not?
My case also.
When you have filed, you should be ready on that authority, mister.
My lord.
After filing, after obtaining the interim order, you ought to search
No,
for
no,
the
no,
judgment.
my lord, it is interim order is granted in presence of the respondent.
That
Last time, my lord, 1 second, my lord, last time the impugn order was stayed. Further, this court opinion that if the evidence has been completed, a decree will be passed, they will be the loser. Entire proceedings is stayed. I never wanted to stall the proceedings of the defendants.
He is a third party. Nowhere is required, is party to this suit. Written statement is not existing. Then earlier this court has dismissed the very same of them.
No, Mr. Counsel, you show me on that authority
Well, I have stated.
who is made as a party, he don't want to adduce evidence, but he wants to examine his witnesses.
Already
Is it-
examined, my lord.
No, no,
Already
no, no,
examined,
no, no.
cross-examination stage now.
My lord,
My lord, please.
my lord, I'll
Application was filed in the 23, my lord.
Hmm.
August 23.
Hmm.
Order was passed in September, my lord.
Hmm.
See, he was keeping quiet. This order has been obtained on 2/8/24.
Hmm.
When he is presenting before the court, 16/1/25. Before that, 3 orders are there passed by this court to dispose this application. This OS shoot is 27 years old. This is 8054 of 97.
Yes. Yes, Mr.
my lord, earlier the same of debate is dismissed by the same court contending that he is not a party without the authorities of the.
Don't argue all these things. Now, only question is that.
Yes, my lord, evidence of debate is rejected earlier by the same court.
Now, you answer that. Now he wants to examine his witness. Defendant number 1, 2, and 4. You are saying that unless that party himself has been examined, he cannot be examined that his witness. That's what that you are.
Yes,
he
my
wants
lord.
to
Yes, my lord.
annex that list of the witness that you have objected, that was granted, that you are challenging.
Yes, my lord.
Which is that law? Show me that.
But it is a general law without the existence of the defendant.
This is the reason why that last occasion I urged that.
Yes, yes.
My lord,
Because of
my lord, can you see, my lord, very same judge dismisses an evidence of debate on 20, same judge dismisses.
Mr. Counsel, either you are, see, answer my question. Whether you have any authority to show that he cannot place any
Examine.
evidence unless he has adduced that evidence. Is there any authority? You show me.
My lord,
Don't say that it is general law. I don't know any general.
My lord, I'm getting a ruling, my lord. Can you give me time? That's on Monday or Tuesday.
Tomorrow.
Tomorrow, brother. Tuesday ಕೊಡ್ತೀನಿ ನಾವು ಹುಡುಕ್ಬೇಕಲ್ಲ.
Tuesday.
Tuesday.
ಹುಡುಕ್ತಾನೆ ಕೇಸ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ ಮತ್ತೆ?
ಅಲ್ಲಲ್ಲ ಕೇಸ್ ಹಾಕಿದ್ವಿ
Case
ಸ್ವಲ್ಪ grounds
ಹಾಕ್ಬೇಕಾದ್ರೆ ಮುಂಚೆ
ಈಗ
ನಿಮ್
ಅಲ್ಲ
law
additional
ಏನಿದೆ ಅನ್ನೋದ್ ನೋಡ್ಬೇಕು.
ಅಲ್ಲ additional ground ತಂದ್ರಲ್ಲ ಅದಕ್ಕೆ Tuesday.
Tuesday. Yes.
Serial number 34 disposed of. Serial number 35 T. Sheshagiri Rao for petitioner Bhargav G.
Yes. Yes, Mr.
Respondent number 1.
Short accommodation to
What is that process has to be served to whom?
respondent number 2 and 3, Laksh.
Yes.
Come
Yes.
back like with the Shara, such number in this address.
Let the process complete. Week's time is granted to. Do the
Interim order,
needful.
kindly extend the interim order, Laksh.
Interim order granted earlier is extended till next date of hearing.
Much obliged.
Serial number 36 Jai Prakash Shetty B. Serial
Yes.
number 36.
Yes, 2 weeks time is granted to do the needful.
Hearing interlocutory application matter, serial number 37, Sandeep S. Patil for petitioner, Kashinath.
For the petitioner in this case, my lords, we have complied the interim order, my lords.
Hmm.
As on today, we have paid 1 crore rupees before the executing court, my lords.
Now, what is that due amount?
4 crores, my lord. 4 crores. 4 crore.
You pay 1 more crores by another 1 week.
My
This
lord.
is how that I have to execute this.
My lords,
Yes,
50 lakhs.
repeatedly you have to pay that amount.
Yes, my lords.
Then you pay it by installment. Otherwise, I will dismiss that.
My lords, 50.
Or we will say that not to release that amount. Whenever that amount is released.
ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಆಲ್ರೆಡಿ
ಎಷ್ಟು ಕೊಟ್ಟು ರಿಲೀಸ್
2
ಮಾಡಿ?
crore 95 lakhs 2 crore 91 lakhs
2 crores
91 lakhs
ನಿಮಗೆ ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿರುತ್ತೆ?
ನನಗೆ 4 crore ಕೊಡ್ಬೇಕು
ಅದ್ರ ದುಡ್ಡು ಅದು ಸಾಕಾಗಲ್ಲ ಅದು.
ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಅದನ್ನಾರು ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ನಾನು.
ಆಯ್ತು.
My lords, the
Yes.
matter may be posted on Monday. Senior will make submissions on this.
No, in the meantime, you have to deposit. Otherwise, I will not. Yes. But the request.
My lords, one submission, my
Like
lords.
that.
It was ordered 50 lakhs interim order. I have paid 1 crore, my lords.
ಇಲ್ಲ ಇಟ್ಸ್ ಆರ್ಡರ್ ಬೈ ದಿಸ್ ಕೋರ್ಟ್.
ನೀವು 4 ಕೋಟಿ ರೂಪಾಯಿ ನೀವು ದುಡ್ಡು ಕೊಡೋದಿದೆ.
ಅಲ್ಲ ಇಲ್ಲೊಂದು
ನಾವು
ಡಾಕ್ಯುಮೆಂಟ್ ಕಳ್ಸಿಕೊಡ್ತೀನಿ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ ಅದನ್ನ 1 ನಿಮಿಷ ನೋಡ್ಬಿಟ್ರೆ.
See, 50 lakhs 2 ಸಾರಿ ಹೇಳಿದೀವಿ. 1 crores ಕೊಟ್ಟಿದ್ದೀರಾ ಈಗ.
Yes, my lords.
You pay another 50 lakhs by Monday. You will have it on.
Kindly one submission ಮೇಲೆ.
Yes.
Otherwise, my lord, I'll pass on this. I have served the copy the last week itself.
What is this?
This, my lord, page 9 of the documents.
Yes,
Compromise petition, 4 crore, my lord, it's agreed.
yes.
Upon this, my lord, a decree is passed. Kindly, my lord, the next document I will just place. The page 48, my lords. Page 48.
Yes.
This, my lord, the Kemparaju, the petitioner, as on 24/8/2024, pursuant to 23-year contract, he had received, my lord, around 1,028.86 lakhs. It's around 10 crore. Out of 10 crore, my lord, at least till filing of petition before this court and till this court passes an order, he's not complied with the decree, my lord.
No,
But
that, see, other than that, you don't have any property for attachment.
ಏನು ಸಿಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇದಕ್ಕೋಸ್ಕರ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು.
No, other than that, you don't have any this thing.
ಯಾವುದು ಸಿಗ್ತಾನೆ ಇಲ್ಲ. I made all efforts.
Yes.
Kindly, next,
At the-
another document, my lord. Page
At the request
47.
of counsel for the petitioner.
Page 47 on
This matter on 25th, subject to condition. Interim order granted earlier is extended, subject to condition. He has to deposit further sum of rupees 50 lakhs on or before 25th.
Let them, my lord, create a hold on the amount which is already received. My lord, by
ಕೊಟ್ಟಾಗಿತ್ತಲ್ಲ ಇನ್ನೇನ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಇವ್ರ ಹ್ಯಾಂಡಲ್ ಇದೆ ಈಗ, ಬಟ್ ಅಟ್ ಲೀಸ್ಟ್ ಲೆಟ್ ಹಿಮ್, ಮೈ ಲಾರ್ಡ್, ಡೆಪಾಸಿಟ್ ಅಟ್ ಲೀಸ್ಟ್ 2 crore ತಗೊಂಡಾದ್ಮೇಲೆ ಅಟ್ ಲೀಸ್ಟ್ ಅನದರ್ 1 crore ಆದ್ರೂ ಡೆಪಾಸಿಟ್.
On or post this matter on 28th.
Lords,
In the subject to condition that he has to deposit 1 crore rupees.
My lords, 25 lakhs may be ordered, my lords. My senior.
No, you have to pay, mister. You have taken that amount.
I oblige, my lords.
Then are you disputing this amount? Now you are saying that this cannot be attached. Now that amount has been
Yes, my lords.
withdrawn.
Yes, my
Now
lords.
that you have to pay that,
Yes, my
you are
lords.
not disputing that there is no due.
Yes, my lords.
Then
kindly, my lord, that
only thing is that you have to give it by installment.
Yes, my lords.
Now we are giving that in the,
At least
before 28th, you have to deposit
50 lakhs. It would be a bit difficult for the petitioner to arrange, my lords.
Yes.
at least
50 lakhs,
even
my
for filing up an appeal, my lord, he has to deposit 50%, my lord, 41 rule 5. But
Yes.
my lord, is
Yes, on or before 28th.
My lords, 50 lakhs kindly, my
Interim
lords.
order granted is extended, subject to condition that.
in addition to this amount, my lord, around
He has to
13 crore he
deposit-
has received after the decree.
Wait, he has to deposit,
I'll deposit 50 lakhs. my lords.
he has to further deposit 1 crore rupees on or before 28th. Yes.
Obliged.
Cell number 38, Santosh is going for petitioner, connected matter, this matter, MS Vishwanatha.
Petition is, my lord, in fact, my lords, my application for is the extension of interim order, my lord.
Yes,
And my lords, in fact, it's a short question for consideration, my lords.
yes,
My lords, Annexure A, my lords, impugned order, allowing amendment application, my lords, in 34 petition of arbitration act.
yes,
My lords, this application filed, my lords, beyond, my lords, 120 days, my lords.
yes.
This is a second round litigation against this application, my lord, order against amendment, my lords. In the first round of litigation, my lords, matter went up to Supreme Court.
Yes.
My lords, Honorable Supreme Court, my lords, has remanded back, my lords, with a direction. That direction would find, my lords, at page number Annexure F 93, my lords.
Yes,
A relevant para is, my lords, a para 5, my lords, and next page, my lord.
yes,
The issue as to whether the application for amendment could have been entertained beyond the period prescribed for filing the arbitration petition under section 34 of Arbitration and Conciliation Act 1996 is expressly kept open. Hence, it would be open for petitioner to oppose the amendment on the ground that it is beyond the period of limitation.
yes. Wow. Now that this issue has settled, what is that
Yeah,
law now?
now, my lord, the court has gone to the extent, my lord, trial court, while my lords admit that it is, my lords, it's beyond my lord's period.
Would have been entertained beyond the period of prescribing of limitation period before is expressly kept open. Earlier, why it is rejected?
My lord, earlier it was
Here
rejected
also
that
allowed.
it is an, my lords, in my absence, application was allowed, holding that it was a typographical error, my lords. I came before this honorable court. Honorable court, my lord, directed me to file objections in, my lords, to the amended petition. That, my lords, I went to Supreme Court, my lord, challenging that order. The court found that, my lords, one is it is beyond time, my lords. Second one is, my lords, it is, my lords, in a defense which was taken first time in 34, which was not a defense before the arbitrator. On these two grounds, my lords, and the Honorable Supreme Court has said you
file your objections.
Yes.
After coming, my lords, first thing is, my lords, admittedly, it is 164 days, my lords, beyond 120 days, my lords.
Yes.
Where period limitation specifies under 34, my lords, 90 plus 30 days, my lords, 120 days, my lords. It's covered by, my lords, and judgment of this honorable court.
Yes.
Here, 2019 Karnataka, my lords.
Yes.
177. Kindly to, my lords, para 8, my lords.
Yes.
Thus, it is evident that the aforesaid pleas which have been taken for the first time in the proceedings under section 34 of the Act were well within the knowledge of the petitioner at the time when the proceedings were conducted by the arbitral tribunal. However, no reasons were that the name have been assigned by the petitioner in the application for not incorporating the pleas in the petition filed under section 34 of the Act. In other words, the petitioners have completely failed to plead and prove due diligence on their part. In fact, the situation of the case, the ground which were not initially raised in the petition to challenge the award cannot be permitted to raise by way of amendment, as the grounds are independent ground and are part by limitation, as the same are sought to be incorporated beyond the period of limitation 120 days, as prescribed in proviso to section 34(3) of the Act. The order passed by the trial court neither suffers from any jurisdictional infirmity nor any error apparent on the face of record, warranting interference of this court in exercise of power under 227.
No, the code is section 34. No, that he has filed an application. Where is that application?
That application is, my lords, annexure
89.
E, my lords, page number 79.
What is that amendment he sought?
He sought, my lords, now, my lords,
Legal ground.
initially,
It is just a legal ground, my lord. That amendment is only for that it is not applicable. MSME Act, before the registration of the Act only.
No,
it is-
now that, can it be filed beyond that period has to be seen now.
Even after 120 days also, amendment can be filed, but should not be a new grounds, my lord.
Where is that? We'll see that first.
in fact, my lords, application is at page number 89, my lords, annexure E, my lords.
Sorry.
Yes. Now, first we'll see that what is that provision says, then we'll come to that.
34 for
34.
34(3), my lords.
What is arbitration act? Yes. Any application?
Clause 3, my lords. An application for setting aside may not be made after 3 months have lapsed from the date on which the party making that application had received the arbitral award, or if a request had been made under section 33 from the date on which that request had been disposed of by the arbitral tribunal, provided that if the court is satisfied that the applicant was prevented by sufficient cause from making the application within the period of 3 months, it may entertain the application within further period of 30 days, but not thereafter. In this case, my lords, 160 days, my lords. Beyond 120 days, my lords.
Yes, there is no this thing after the limitation.
No, my lord. This is in regard to only filing of the appeal, my lord.
No, amendment is that otherwise this object of this act will be defeated.
Therefore, my lord,
There are
Supreme Court has remanded back
My lord,
that
the
observation.
trial court clearly held that there are two grounds, my lord. A and B. 34A, of course, it is correct, my lord. When it is comes under B, my lord, kindly see B. Even at any time, at the time of argument, at any time, my lord.
Where, what are you reading?
Section 34, subclass B, my.
Subclass
B.
B.
B, my. The subject matter of the dispute is not incapable of.
B only the ring. 34B.
34 ಅಲ್ಲಿ A ನಲ್ಲಿ A is in respect of the arbitral records ಏನಿದೆ ಅದ್ರ ಮೇಲೆ ಸರ್. B is only a legal grounds.
3 ನ B ನ ನೀವು
B man. B.
ಎಲ್ಲಿದೆ 34B?
34B.
2B, my lords.
After 5 ಆದ್ಮೇಲೆ 1B.
There's no B, my lords.
A1 A5 ಆದ್ಮೇಲೆ ಸ್ವಾಮಿ. A5 ಆದ್ಮೇಲೆ B. The court finds that
No, I didn't get this.
Provided ಆದ್ಮೇಲೆ ಸ್ವಾಮಿ, provided
34
ಅಲ್ಲಿ provided ಆದ್ಮೇಲೆ
A,
fourth ಆದ್ಮೇಲೆ
court finds that.
yes ma'am, ಅಲ್ಲಿ ಸ್ವಾಮಿ.
Hmm.
The court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force. One swami. ಎರಡನೇದು, the arbitral award is in conflict with the public policy of India. So, and again, it is when it is against to the public policy of India, even the court himself itself can take into the consideration that can dismiss the arbitration appeal ಅಂತ at any stage. ಅದನ್ನ ಕ್ಲಿಯರ್ ಆಗಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. kindly permit me to read. ಏನಲ್ಲಿ ಬಂದಿದ್ರೆ that is okay. My amendment is in comes under B, my lord.
Where is that order, impugned order?
What is impugned order, my lord? Page number 41. Sir, ಯಾವ ಕೇಸಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀವಿ? 31-229 ಅಲ್ಲ? 31-229. ಅದರಲ್ಲಿ ಸ್ವಾಮಿ ಪೇಜ್ ನಂಬರ್ 41 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. Page number 40-41. Orders on application filed under order 6 rule 17 of 6. Page number 46 ಹೋದ್ರೆ reasoning. 45 ಇಂದನೇ arbitration act ಏನ್ ಹೇಳುತ್ತೆ ಅಂತ ಅಲ್ಲಿ ಹೇಳ್ಕೊಂಡು ಸ್ವಾಮಿ. 45 ಇಂದ kindly permit.
These are all the grounds available for the courts to set aside that. That doesn't mean that you have been permitted to see. Otherwise, what is the time limit purpose of fixing the time limit?
My prayer is also, my amendment is also very limited, my lord. It is not comes under subsection A, my lord, 34A. It comes under 34B, my lord, that's all. That's why this honorable court rightly.
There is no such, it is only 34A and B that section 3 says, subclass 3 says, application for set-asiding may not be made after the 3 months have elapsed from the date on which the party making an application had received the arbitral award. If request has been made under section 33, it is from the date on which the request has been disposed of by the arbitral tribunal.
Idರಲ್ಲಿ, since my amendment is comes under
keeping that
B,
my
my
lords is
lord,
in mind, my lords, honorable
at the
Supreme
time
Court
of
has remanded
argument-
back, my lords, and therefore, my lords, it is covered by our honorable High Court, my lords.
That is why that applicants was prevented from sufficient cause for making an application within the such period of 3 months. It may entertain that application within the further period of 30 days, but not late. See, in this case where you are retired, right? See, this
Kindly
is
see my
within
amendment.
120 days.
Within 120 days.
No,
It is, this application is not within
application is
120.
This judgment of Justice Alokarade,
Please, my lords.
is it within 120 days?
It was within 120 days. Therefore, my lords, court said
30 days plus 60
90
days
days,
plus
90
30 days.
90 days plus 30 days.
Yes, now after 19 days, within 30 days, if we file, if there is any reason.
Sufficient cause, then only it is. Otherwise, it is
But
strictly
120
90 days.
After 120, there is no question of
No
that.
question of it.
that is a law
Then
in respect of filing. of
Supreme
the
Court is also when remanding say that section 34 is kept open.
No, my kindly, non citation ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. Kindly permit me to read my
Which is that?
citation.
Copy to
ಪ್ಯಾರಾ
the copy to the.
ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. ನಿಮ್ದೇ citation. Judgment dated 1/4/2010, my lord. Civil appeal number.
ಆಯ್ತು, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡ್ರಿ. ಅವ್ರು should they not assist?
Last time ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. Kindly permit me to read 25 para.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ. We'll take it next week. You also go through that.
And my lords,
Hello,
and
sir.
my lords, my matter is coming up tomorrow. 2 times they have imposed cost, my lord, despite my lords, my learned friend undertaking. That he'll not pursue it for the argument. But my lords, he's proceeded to file written arguments also, my lords, only because one date is missed for extension.
No, let them file in a written statement, not to proceed further. Now that
It's for final arguments, man.
yes, we'll stay further proceedings.
Please, my lords.
My lord,
please.
what happened earlier, the same, since my application has been allowed by the trial court, my lord. So that has been challenged before this honorable court. This honorable court clearly held that, no, instead of it is rightly allowed, you file a amendment, objection to the amended petition. By that time, already amended petition has been filed. Thereafter, they have counsel.
Now only question of law. This is whether you can be allowed to file an amendment after that
Even after
20 days.
Yes, that is the citation.
Where is that?
Yes, sir.
What is that?
Para 25. A citation is para 20 finally. So there is no doubt the application is setting aside an arbitral award under section 34 of the 1986 Act has to be made within time prescribed under subsection 3. That is within 3 months from the further period of 30 days or on sufficient cause being shown and not thereafter. Whether incorporation of additional grounds by way of an amendment in the application under section 34 tantamounts to filing the fresh application in all the situation and
Now,
circumstances.
Mr. You see that?
I'll examine.
Yes, because here distinction has been made that amendment and that petition. This is Supreme
Yes,
Court
yes,
judgment.
yes, ma'am. Yes, ma'am.
Yes, which is that, I think, 2010. You see
But-
that, I think they have made a distinction.
Yes, ma'am.
Filing an application and amendment is a different thing.
That is my lord,
Otherwise,
in fact, that is covered in my lords in judgment, my lords of Justice Alok Karade. I mean, making distinguish
Court.
even in the amendment application.
Supreme Court.
I'll take my lords.
Yes. See, they said otherwise that amendment provision will be.
Yes, ma'am. That is
There. Yes, you see that.
I'll
When do you want?
any date my lord's convenience, but I want my lords stay of further proceedings.
No, don't precipitate that matter, Mr.
ನಾನೇನ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ ಅಲ್ಲಿ.
ಅವ್ರು ರಿಟರ್ನ್
ನಾನು actually-
ನನಗೆ 2 times ಕಾಸ್ಟ್
ಆಯ್ತು,
ಹಾಕಿದ್ದಾರೆ.
ರಿಟರ್ನ್ ನೀವೇನ್ ಆಗ್ಬೇಕು ಅಂತ? Okay, they have imposed the cost.
Yes, my lord, 2 times.
ಅಲ್ಲಿ
In
5-6
fact,
ಸಲ
they have argued, orally also they have addressed that.
ಮೆಮೋ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ಟೈಮ್ ತಗೊಂಡೋಗಿದ್ರು ಅವ್ರೇನೆ. ಕೋರ್ಟ್ ಮೆಮೋ ಮೂವ್ ಆಗ್ಬಿಟ್ಟು ಟೈಮ್
No,
ತಗೊಂಡು
if you say you will not precipitate, I will not grant. Otherwise, I will say that.
ನಾನೇನ್ ಪ್ರೆಸಿಡೆಂಟ್ ಮಾಡಲ್ಲ.
Yes, learned counsel for,
ಇಲ್ಲ ಬಟ್ ಅವ್ರು ಲೆಟ್ ದೆಮ್ ಮೂವ್ ದಿ ಮ್ಯಾಟರ್ ಬಿಫೋರ್.
yes, respondent. Undertake that you will not precipitate the matter before that trial court till next date of hearing.
Please,
ಡೇಟ್
You will see that, you see that judgment
I'll see that. I'll
Date.
collect it.
on 28th. 28th, yes.
Highly obliged.
Madam Kriya, Madam Kriya. Note down this Supreme Court judgment and keep it in the file. Yes.
Serial number 39.
Lord, I appear for the
Petitioner.
Yes,
connected petition and apologize. We had mentioned the matter a couple of times.
yes.
The issue, my lord, emanates from an execution petition.
Hmm.
The only
You
ground
are
that
appearing for whom?
I'm for the respondent number 3 in the connected
Who
petition.
is for the petitioner?
My lord, petition counsel appearing online.
39 Keshavamurthy.
Yes, my lord, I appeal
Online.
for the petitioner.
Yes, yes. Yes, what is this, mister?
My lord, these petitioners are the judgment debtors before the
Yes,
trial
Mr.
court. The respondent number 1 and 2 are the decree orders. My lord, they have obtained an expert order from the joint registrar of the cooperative societies. For alleged sum of rupees 4 lakh rupees, they have been deposited with the respondent number 3 society.
Hmm.
My lord, what has happened during they have obtained expert order, they have put for the execution.
Hmm.
My lord, page number G may kind of G. Straight away take this number, page number G, next is G, page number 49. During the pendency of this, my lord, there was a police complaint was registered, KPID Act was invoked. The government of Karnataka, annexure G, 59/2023, my lord, by invoking the KPID Act section 5, my lord, appointed the competent authority. May we permit to read, my lord, the relevant para number 2 of the annexure G, my lord.
Yes, wait. Let him give a facts, mister. Your voice is not
May I
clear. What
assist,
is
my
this
lord?
facts? Yes,
My lord, the petitioner before my lords is the judgment debtor.
judgment debtor.
Yes.
Yes.
All the petitioners were former office bearers of the cooperative society, which is respondent number 4.
Yes.
The award holders before my lords, that is the respondent numbers 1, 2, 3.
Yes.
They had made a deposit before the cooperative society, respondent number 4.
Hmm.
And by a dispute, because the money was not returned, a dispute was raised under section 39 of the Karnataka Sauharda Sahakari Act.
Yes.
The
Now
registrar,
that, the award has been passed by
yes,
that.
the registrar has passed an award.
Where is that award?
The award, my lords, we'll see at Annexure C, page 32.
Yes.
This is the final award. The operative portion is at page number 36. I must point out, my lord, the award has not been challenged.
The award is for sum of rupees?
42 lakhs 92,000 rupees.
Yes, now the society is before this.
Not even the society, the office bearers of the society who are found to be indulging in some money laundering
No,
activities.
that award is against whom?
Award is against the society and all the then office bearers of the society.
Yes.
In
Now
the
that,
yes.
where is that execution petition?
Execution petition, my lord, was filed.
Yes. Now what is that order they are challenging?
Two orders. My lords, may
My
first
lord-
have page number 18.
Wait, yes.
My lords may have page number 18. This
Yes,
is
yes.
the reasons begin for the first order that is under challenge.
Yes,
And that operative portion is on page number 22,
yes.
where the Honorable Court, Execution Court holds that the execution filed under Order 21, Rule 11 is maintainable because they came and raised a objection on maintainability.
Yes.
Then they continue to participate in the execution proceedings. And a second order was passed, which is at page number 26, my lords will see, orders on IA number 2. I will again take my lords straight to the operative portion. But I must just point out, the objection they raised before the execution court is the same objection that they're raising here, saying that the Sauharda Act is not applicable.
Appropriate means satisfying the degree and satisfy so and so.
Yes, so they have been called to declare what assets they have. These are the two orders that they have attempted to challenge.
Yes, yes, mister, on what ground you are challenged?
There, just one important point, the award itself has not been challenged.
Yes.
And
No,
I
award is
not
not
been
execution petition. They're
Yes.
saying that execution petition is not maintainable.
Yes, and the basis for that is to say they claim, as my learned senior pointed out, that some order has been passed under the KPID Act, which is a sister act, where for all depositors who do not have a dispute, I have instituted a dispute and have an award in my favor. There may be many depositors who have not instituted a dispute, but they've lost out. To assist them, a special officer is appointed. That and this has no connection. And I must point out, because it's a judgment of a coordinate bench, the same issue by respondent number JDR number 13, who's not a party here, had raised before a coordinate bench and took the same objection, saying that because the KPID Act is applicable, the Sauharda Act won't be applicable. The Honorable Court, with a categoric finding, saying that the KPID Act has no relevance to the Sauharda Act in this scenario. I'll just take my lord straight to the. My lords may have the reasoning.
Copy not furnished, my lord.
I'll give you the, if you were here in court, sir, I would have given it. My lords may first have para number 6. It's the same objection taken. I will, with my lord's permission, read.
Yes.
Learned counsel for the petitioner, who's similarly placed as the petitioners here, submits that the proper remedy for the claim lies under the Karnataka Protection of Interest of Depositors in the Financial Establishments Act, and not under the KSS Act, which is the Sauharda Act, as approached by respondent numbers 3 to 5. Respondent number 3 to 5, not the secured creditors, etc. So the objection is on jurisdiction.
They are not challenging that award. That question would not arise as.
That's, my lords, the court answers, they have not challenged it, but the same objection is taken as to that which act is applicable.
No, they are also that in respect of the
Same.
execution petition.
Same order, same award.
Yes.
Now, my lords, the court records all my submissions.
Yes.
I had I appeared in this matter also.
Yes.
And in page number 12, the operative portion, the court first dismisses the writ petition on maintainability, saying that if you have to challenge the award, please go to the alternate remedy before the Honorable KAT. But please see the last point, my lord. It is made clear that this court has not expressed the opinion on the merits or demerits of the case, other than the maintainability of the claim under the Sauharda Act, which is the same objection they're raising, saying that the Sauharda Act doesn't apply. Now a decision having been rendered, my lord, that the Sauharda Act for the very same award, for the very said claim is maintainable, the same objection cannot be taken in the guise of a writ petition before my lords to avoid execution. And none of these judgment debtors have challenged the award. They have accepted the award.
In this case, what they are in that execution petition, or they are challenging the award itself?
Award itself they try to challenge on the same ground. What they've done, my lord, some.
Their execution petition, they can't change that.
Yes, same ground. In fact.
Yes, Mr.
Yes, my lord. Shall I make my submission, my lord? The first and foremost submission, my lord. The award passed by the joint registrar is an ex parte order. It is for a sum of rupees 4,01,000 rupees. It is not
41 lakhs.
As my learned friend submitted before this court. It is for only 4,01,000 rupees. 4 lakh. Page number 36, my lord.
Yes.
That's not in dispute, ma'am. That's not in dispute. It was a slip of tongue by the learned counsel appearing
You
in
are
the
appearing
connected
for
matter.
whom, madam?
That's the connected
My
petition.
lord, I'm appearing in the main matter for R1 and R2, my lord.
25014.
She is appearing for
2501.
R1 and R2.
R1 and
R1
R2,
and
my
R2.
lord.
Who is R1 and R2?
They are the senior
Lord,
citizens.
They are
Similar
they are
to your
degree holders, my lord.
Wait. Madam. She is arguing. Let us. Yes.
Yes, my lord.
My lord, the only dispute before this honorable court is that they have raised an objection with regard to the maintainability of execution proceedings only on the ground that under section 10 of the KPFID
No, I will
Act.
hear you, madam. Wait. Yes.
I'm sorry, I apologize.
Yes.
My lord, this is an expert order passed on, my lord, on 27/3/2022, directing to pay 4,10,000 rupees with interest. Well, this has been put for execution.
Page number.
Page number 36, my lord. Relevant page is page number
36.
Yes, my lord.
Yes.
4,10,000 rupees with interest. Order to
5
pay
lakhs. 4,10,000.
with interest.
Yes.
My lord, this is an expert order. My lord, they
What
have
is
put
that?
this order.
What is the difference between that ex parte and that order passed after hearing?
Yes, ma'am.
Unless you challenge.
Yes, ma'am.
What is said?
I will convince this court, ma'am. I will convince this court, my lord. Thereafter, this ex parte order came to filed an execution petition before the civil court. As per section 39. I am not disputing that section 39, my lord, they have no power. Civil court has power to adjudicate, implement the orders of the joint registrar. I am not disputing it.
Yes.
And my respectful submission, in view of the invoking of the section 10 of the Karnataka Protection KPI Act by the government of Karnataka, as per page number 49, my lord, notification.
Yes.
Before that, my lord, page number 47, annexure ref, my lord, all the director has been disqualified because of the certain omission and commission of the respond number 3 society.
Yes.
Page number 49, my lord, the government of Karnataka issued a notification on 59/2023.
Yes.
My lord, I may permit to read the notification. What is the purpose of issuing notification, my lord?
Yes.
My lord, it has come to the notice of the government that the financial establishment, that is the respond number 3 society, is involved in the fraudulent transaction and failure to return the deposit to their depositors. Hence, the government has decided to initiate action as per the provisions specified under the Karnataka Protection Interest of Depositors in Financial Establishment Act 2004. It was reported that properties belong to the, my lord, I will repeat, my lord, it was reported that properties belong to the said financial entity may have spread over various districts and depositors are scattered throughout the state of Karnataka and possibly in other states also. In order to avoid duplication of efforts, the necessity has arisen to authorize the competent authority to call for claims from all the depositors of Sri
No,
Vaibhav.
you take this defense and challenge that award. You don't say that when the award is passed by the competent authority, that has to be executed.
I will come to Mela. I will come to next point. I will come to that point.
Yes. Ex parte order antandre you have to challenge, mister. Yes.
My lord, I will come to this. The provision itself is like this, Mela. I will read, my lord. Therefore, in exercise of the powers conferred by section 5 subclass 1 of the KPID Act, the government of Karnataka hereby appoint joint registrar of cooperative societies, cooperative elections authority, TTMC building, Shantinagara, Bangalore, as the competent authority in respect of Sri Vaibhavas over the so and so. My lord, my respectful submission may kindly be taken up section 10 of the KPID Act at the moment, my lord.
Yes. When that award has been passed?
Before, my lord. That
Before
was what
this
I want to point out, that this is post facto.
The award was passed on 27/3/2022.
Yes.
Thereafter,
After that, this notification has been issued.
After that, but even otherwise, my lord, I must, as an officer of the court, fairly submit, this is for those people who have not yet made a claim.
Yes, yes, mister.
Section 5 Act to appoint the competent authority.
Yes.
Section 6 duties and responsibility of the competent authority.
Yes.
And I will take straight away to this honorable court, section 10, my lord.
Yes.
Section 10 is the special court appointed for this particular purpose for disbursement of the amount. My lord, it's not in dispute that all the assets and liabilities taken over by this competent authority.
Yes.
Things, including books of accounts, all the assets, movable, immovable, all the things has been taken over by the competent authority. The matter is the special for this purpose. Section 10 is there, my lord.
Yes.
Section 10. For the purpose of this act, the government may, with the concurrence of the Chief Justice of High Court of Karnataka,
Yes.
by notification, constitute one or more special court consisting of a single judge not below the rank of the district or session judge for
Yes.
such area or areas or for such class or classes of cases.
Yes.
No court, my lord, I read, my lord, no court, including court constituted under the Presidency, Towns Insolvency Act, so and so,
Yes.
other than the special court, shall
Yes.
have the jurisdiction in respect of any matter to which provisions of this act is invoked. No court has been in a jurisdiction, my lord. The
Yes.
next, my lord, subclass 3.
Yes.
Any pending case, my lord, I repeat, my lord, any pending case in any other court in respect of which the provisions of this act is invoked.
Where you are reading?
Subsection 3, my
Subclass
lord.
3, subclass 3.
Yes.
Any
We'll take this matter Tuesday.
Please, my
please, my lord, please. I will
Please.
come. I will answer
The
the matter.
lords consider having it slightly high on board, sir.
The matter may kindly be extended till then,
My
my
lord,
lord.
it has not been reaching for quite a long time, my lord.
No, it is extending on time to time.
Yes.
The matter was not listed.
Lord, what has happened is, in the connected petition, in which my learned friend, Ms. Tiwari appears, there is an interim order. In my petition, there's no interim order. But unfortunately, because the next date is coming up on the 28th, 28th, the trial court has treated it as a virtual stay of all proceedings. So
It has
on,
been
No, it is not wrong submissions.
on Tuesday, maybe
Yes.
we'll assist, my lords.
Yes.
May kindly be extended, my lord.
Please, sir.
Granted earlier, my lord.
Yes. Yes.
My lords may kindly have it high on board.
Yes. Yes. Tuesday.
So deeply obliged.
Yes.
That's all.
Great. Obliged.
Milord, serial number 40, date may kindly be given, Milord. There is urgency.
Yes. Who is
Lord.
applying for 40?
I'm for the petitioner, Milord.
It's become infructuous.
No, Milord. The execution
Delivery
is
warrant has been.
Delivery warrant is accepted, EFS, execution is fully satisfied.
So you have satisfied that degree.
no, Milord. It was only to break open lock anta order ಆಗಿತ್ತು. ಇನ್ನ decree has not been satisfied.
Satisfied. Let him take them. Yes.
My lord, 41, my lord, 41. In fact, it was listed on Monday.
Yes.
My lord, a very short question. It can be disposed of right now. My lord, they are asking for a framing of an additional issue,
Yes.
asking that the trial court has to frame whether suit is for non-joinder of the necessary party. But that question does not arise because it is my suit. I am the respondent, I am plaintiff before the trial court. They can't ask for a framing of an issue at the instance of the defendants.
Yes. Who is appearing?
When it is set down for the final arguments, that too after 2019 was the issues framed.
What is that? When do you want that?
My lord, which one?
No, which date?
No,
you want?
let the trial court proceed with the application, my application, let the matter be pending here and interim order, but let the trial court continue with the proceedings in so far as handing over of the temple is concerned, my lord. We are seeking for a police protection. They are resisting it. Therefore, to that extent, your lordship kindly modify this interim order.
Yes, we'll have it on Saturday.
ಅಲ್ಲ ಸಾಟರ್ಡೆ ತಗೊಳ್ಳಿ ಬೇಕಾದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತಗೊಳ್ಳಿ ಇಷ್ಟನ್ನು ಮಾಡಿಫೈ ಮಾಡಿದ್ರೆ ಸಾಕು ಲೆಟ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಗೋ ಆನ್ ವಿತ್ ದಟ್ ಅಪ್ಲಿಕೇಶನ್
Yes, I will hear that. Let us see.
My lord, in serial number.
Yes, we'll modify that interim order to that effect. Yes, Kodi.
only to that effect. I don't want to press the other things. Your lordship can decide later.
Yes, what is this interim order?
Now entire suit has been stayed now, proceedings.
What you want that modification?
My lord, modification with regard to the police protection sought for, there is an order by this honorable court to hand over the charge once in a year. They have not handed over from the 1st of January.
Yes.
Therefore, there is a court order by the trial court, and now the trial court before whom we want to file an application for the police protection.
What is your application?
Application, the trial court is refused to accept even the application.
Interim order granted by this court will not come in the way of trial court to decide that application to be filed by.
To be filed for police protection, my lord.
By the plaintiff for police protection
Please,
in
ma'am.
accordance with law.
Good.
Yes.
My lord, in serial number.
To that effect, interim order is modified.
Please, ma'am.
Milord, 40, a date may kindly be given.
Serial number 43. In fact, tomorrow is the hearing before the trial court.
Yes.
This matter was listed 3-4 times. If your lordship recalls, order 3 rule 1 and 2. Husband wants to examine on behalf of
No,
the wife.
Except tomorrow, any date you ask that, we take the date.
Monday, my lord. Monday.
Yes.
Monday,
any-
please.
Lordship.
43, serial number 43, Monday. ಸಾಟರ್ಡೇ
ಬರ್ತೀನಿ. 43 ಒಂದು ಮಂಡೇ ನೋಡಿ.
ಸರ್ 42 ಸಾಟರ್ಡೇ 42 ಸಾಟರ್ಡೇ.
ಹೇಳಿ ಸರ್, ಹೇಳ್ತೀನಿ ನನ್ನ ಕಂಡೀಷನ್ ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಆಯ್ತು
ಅದೊಂದು 43 ಒಂದು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
43 ಮಂಡೇ ಸರ್.
ಇಂಟರಿ ಮಾಡರ್ ಎಲ್ಲೆಲ್ಲಿದೆಯೋ ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಟೋಮೆಟಿಕ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಅದ್ರ ಬಗ್ಗೆ ತಲೆ ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್, ನಾನು ಡೇಟ್ ಕೊಡ್ಬೇಕಾಗಿರೋದು ಇವಾಗ 10th ಏಪ್ರಿಲ್ ಕಂಟಿನ್ಯೂಸ್ ರಜೆ ಇರೋದ್ರಿಂದ 15th ಏಪ್ರಿಲ್ ಇಂದ ಡೇಟ್ ತಗೋಬೇಕು. ತೊಂದರೆ ಇರೋರು ಬೆಳಿಗ್ಗೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ನಿಮ್ ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ನಾನು ಸೀರಿಯಲ್ ನಂಬರ್ ವೈಸ್ ಹೋಗ್ತೀನಿ. ರಿಪೀಟ್ ಮಾಡಬೇಡಿ ಸರ್. ತೊಂದರೆ ಇರೋರು ಬೆಳಿಗ್ಗೆ ನಿಮ್ ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ತಗೊಳ್ಳಿ.
ಇಲ್ಲ ನಾಳೆ ಒಂದಿನ ಬಿಟ್ಟು ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು.
ನಾಳೆ ಒಂದ್ ದಿವಸ ಅವರು ನಾಳೆನೇ ಪರ್ಟಿಕ್ಯುಲರ್ ಆಗಿ ಹೇಳಿದ್ರು ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳಿ.
42
ಸೀರಿಯಲ್ ನಂಬರ್ 42
ಎಷ್ಟು ಶಾರ್ಟ್ ಆಗುತ್ತೋ ಅಷ್ಟು.
ಇಂದಾನೆ ಕೊಡ್ಬೇಕು, ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ತನಕ ಬ್ಲಾಕ್ ಆಗುತ್ತೆ.
ಆಯ್ತು 15 ಕೊಡು. 15
ಆಟೋಮೆಟಿಕ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಬ್ರೇಕಪ್ ಇಲ್ಲ.
ಮೆಮೊ ಅಲ್ರಿ ಅಷ್ಟೊಳಗೆ ಮೆಮೊ
44 ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಸರ್.
47 ಇಲ್ಲ ನಾನು ಕೊನೆಯದಾಗಿ
47
ಅರ್ಜೆಂಟ್ ಮಾಡಿಲ್ಲ. ಬೇರೆ ಡೇಟ್ ಬೆಳಗ್ಗೆ ಆಯ್ತು. 48 49 50 ಬ್ರೇಕಪ್ ಇಲ್ಲ. 51 ಕೊಡ್ಬೋದಾ? ಆಯ್ತು. 51 ಬ್ರೇಕಪ್ ಅಂತ ತಗೊಳ್ಳಿ. ಬ್ರೇಕಪ್ ಇಲ್ಲ.
53 ಅಡ್ಜರ್ನ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಇದೆ ಸರ್.
ಬಂದಿದೆಯಲ್ಲ ಸರ್, ಬಂದಿಲ್ಲ ಅಂತ
ಅದು ಅಲ್ಲ ಬೇರೆ ಇದು ಅಲ್ಲ, ಅದು ಅಡ್ಜರ್ನ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡಿ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದೆ ಇದ್ರಲ್ಲಿ ಅರ್ಜೆಂಟ್ ಮಾಡಿ
ಸರ್
ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಅದು
ಕೋರ್ಟ್ ಆಫ್ ಸರ್ 53 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಅದು. ಹಾ ಎಸ್ ಸರ್.
ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ
ಓಕೆ
54 ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಸರ್.
55
15th ಪೆಟಿಷನರ್
ತಗೋಬೇಡಿ ಸರ್. ಇಲ್ಲ ಅವತ್ತು ಹಂಗೆ 56 58
58 ಇದು ಶಾರ್ಟೆಸ್ಟ್ ಇದು 80 ವರ್ಷ ಪಾರ್ಟಿಗೆ 16 ಕೊಟ್ಬಿಡಿ. 15 ಇದಾದ್ರೆ
ನೀವೇ ಕೊಟ್ಬಿಡ್ತೀರಾ? ಓಕೆ ಓಕೆ. 49 ಡೇಟ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ, ಅಡ್ಜರ್ನ್ ಮಾಡಿದ್ದೀನಮ್ಮ. ಬೇಕು ಅಂದ್ರೆ 15th ಏಪ್ರಿಲ್ ಇಂದ ಡೇಟ್ ನಾವು ಮಾಡಿದೆ. ನೀವು ಹೇಳಲಿಲ್ಲ, ನಾನು ಮಾಡ್ತೀನಿ. ಅಲ್ಲ ಯಾವುದು ಅಲ್ಲ, ಆರ್ಡರ್ಸ್ಗೆ ಹೋಗ್ಬೇಕಾದ್ರೆ ಸ್ಟೆಪ್ಸ್ ಇಲ್ಲದೆ ಹೋದ್ರು ಐఏ ಇದೆ ಅವ್ರದ್ದು ವೆಕೆಟಿಂಗ್. ಹಾ ಅಲ್ಲ, ಈ ಆರ್ಡರ್ಸ್ ಕ್ಲಿಯರ್ ಆದ್ರೆ, ಸರ್ವಿಸ್ ಏನಾದ್ರು ಕಂಪ್ಲೀಟ್ ಆದ್ರೆ ಅಷ್ಟೊತ್ತಲ್ಲಿ ಆಟೋಮೆಟಿಕ್ ಕ್ಲಿಯರಿಂಗ್ ನಾನು ಐఏ ಹೋಗುತ್ತೆ. ಆಗಲ್ಲ ಅಂದ್ರೆ ಆರ್ಡರ್ಸ್ಗೆ ಬರ್ತಿರ್ತೀವಿ. ಸ್ಟೇಜ್ ಇರೋದೇ ಹಂಗೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನಮ್ಮಲ್ಲಿ ಮಾಡ್ಸೋದೇ ಇಲ್ಲ. ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು ಅವ್ರು ಮಾಡಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಆರ್ಡರ್ಸ್ ಅಲ್ಲೇ ಬರುತ್ತೆ. ಅಷ್ಟೊತ್ತಿಗೆ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ರೆ ಆಟೋಮೆಟಿಕ್ ವೆಕೆಟಿಂಗ್ಸ್ಗೆ ಹೋಗುತ್ತೆ, ಐಯಾಗ ಹೋಗುತ್ತೆ. ಇಲ್ಲ ಸರ್, ಅದೊಂದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ನನ್ನ ಕಡೆ ಇತ್ತು, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸಿದೀನಿ. ಪಾಪ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು. ನನ್ನ ಕೈಯಲ್ಲಿ ಇರೋದು ನಾನು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ತೀನಿ.